everybody. Well, jury decided to get some stuff done on Tuesday. It's looking like Monday was a nice day to just go over everything that jumped out. And God, do you remember when that happened? And I couldn't believe when this guy said that. Go around the table a few times. Remember the whole experience everybody went through, but it looks like towards the end of the day, the positions are probably becoming a little clear, and now we're just negotiating around the edges a little bit. So, if you guys have not been paying any attention this morning, I of course have not been live, but I was watching what was going on with Bob and Allie over there on Defense Diaries while things were happening this morning. And I was outside, guys. I've been, like I said, I had a long list of stuff. I'm back getting in order now, and it's cool in the mornings, So if you're gonna go, like get your stuff outside taken care of, you really got to do that early. So anyway, but I've been watching what's been going on, and so you probably know the jury had a question. Jury, in fact, had 3 questions, series of questions. And latest I'm hearing now is that we are going to be back at 1:30. The judge has instructed the attorneys to be back in court at 1:30. So that's the time we've been having lunch so far, and that is about 45 minutes from now. So yeah, things happening. Things are happening today. We're going to go ahead and take a look at those questions that they had. We'll just go ahead and rewatch it, guys. Why not? We got some time to kill. I mean, they're not gonna come back just like that. I mean, unlikely anyway. They're gonna stop, have their lunch, talk about how they're going to fill out that verdict form. Of course, as we're going to see, the old lesser includeds continue to rear their heads, pose a series of problems. Courts, parties, participants, jurors, everybody trying to figure out what the options are, what it all means, why does it work like this. And of course, as jurors, you only get to know what you get to know. So, hey, let's go ahead and take a look at what happened when they were called back into court. Oops. Hang on here. Did I get the wrong one? I think I might have shared the wrong one. Here we go.
Please be seated. Court is in session.
Excuse me. I was just informed somebody just. So, Counsel, why don't you come on up?
Come on up, of course. Of course. Would it even be trial if we didn't start with the sidebar? Would it even be this case if we didn't start with the sidebar? Here we are, already waiting for the sidebar to conclude. I'm just gonna let it play, guys. So what I did is I queued up each part, like where something is happening. Now, having said that, put it out here in the chat, guys. I know there's a hot mic moment. I heard it. They heard it on Bob and Allie's show, so I heard that when that happened. But I couldn't find it in the NBC 10, which is what I've been watching for this particular trial. So I couldn't find it. I don't have that queued up, but I have the rest of it queued up, and we can just go ahead and watch what's going down. And so, okay. This was what? This was like 10 in the morning. No, it was like 11 in the morning over there on the East Coast when this was happening. So, tells us a little bit about how the morning is gone, right? Probably not a whole lot of dispute. It's very relatively speaking, considering how long this trial took. Okay, 32 days of evidence. Not a whole lot of time to go over and talk about the evidence before you start really drilling down what it is that you're finding to be roadblocks to consensus. And so the fact that they're asking a question now, at this particular stage, it just tells me that they've moved very quickly. They've been able to sort out what mattered and what didn't at that 10,000 foot scale. They've been able to sort that out pretty easily because that's you don't generally start getting questions until you start hitting points of conflict, right? And that's why they need to throw it out. They reach a point that they're stuck on something, and you don't necessarily know what it is. I mean, it can be the evidence things they're stuck on. It can be not understanding legal things they're stuck on. But there's something, it means they progressed to the point that you have gotten stuck. A lot of progress with just one day of talking about the facts.
Bob, I can't do this. I can't do this.
There it is. Okay, sorry. There it is. Bob, I can't do this again. I can't do this. There was our hot mic moment. There it was. Don't think they probably meant to say that publicly, but I can't do this again. Definitely sounded like it was AJ to me. I don't know what he was talking about, but wouldn't blame him at all if he was talking about this trial. Good Lord. What other feeling are you supposed to have about this trial? No, I really want to do it a third time. Of course you don't want to do it a third time. Nobody wants to do it a third time. This is why the jury is already trying to get it done. Day 2, morning of walk in, ready to get it done. They're like, we did our duty on the first day. We talked about all the evidence. We aired all of the grievances.
Those are done.
What's that?
Oops. Hartzell saying, I'm not sure I hear again, but I would think it was more about Bob talking and hovering. Absolutely could be. He's obviously off doing his own thing now. He's writing very attentively, not wanting to be distracted. So that certainly does make sense as far as the significance of that particular comment.
Okay, Hank,
Yes, sir.
here's number 3.
Jay Fiore saying 20 miles from the courthouse, earthquake inbound at 1:30. Thank you for making me smarter. Well, let's hope it's not too chaotic. Let's hope it's not like Philadelphia winning the Super Bowl kind of chaotic. I think they have some really nice like old lampposts and stuff in Boston. Isn't there like a gaslight district? Am I remembering that right? I haven't been to Massachusetts in quite a long time. But hey, it's going to be, if there is a decision, yeah, there's going to be reactions to it. No question about that. Hey, Evie's already out gifting memberships. Thank you so much for that. Let the chat get green. We're waiting for stuff. So yeah, Alan has put together his response. You know, he had to focus, he had to concentrate. Now he's going over it with all of them. It does stand out to me just how they do seem to function so well as a team, and to me that tells you a lot about the personalities. I mean, look at how this team functions. They have a good cooperative vibe. Everybody's attentive. Nobody is you know, getting out of
Counsel,
line.
what I'd like to do is I'm just going to read the questions
And then look at
to
the
you now. So
prosecution
please
team.
take your seats. So I'm going to read the questions. I'm going to have them marked. Then I will take a short recess, let you all talk about it, and then come back.
Thank you.
So, all right. So I received 3 questions from the jury. The first one is, they appeared on note cards, so that I don't know what order they came in, but this is the order I got them. This is the order I'm going to read them.
On note cards.
What is the time frame for the OUI charge? Offense 002, Section 5, OUI at 12:45 or OUI at 5 a.m.? The second, are video clips of Karen's interviews evidence? How can we consider them? And the third, does convicting guilty on a subcharge, example offense 2 number 5, convict the overall charge? So I will give you some time to consult. I think the first one, I'll hear from you as to what the time frame is, and I don't need to hear from you now. That's pretty clear cut what they're looking for. The second one are video clips of Karen's interviews evidence. How can we consider them? Well, we know they are evidence and they can give them whatever weight they want. I would also be inclined to give a humane practice instruction, and tell me if you want the digital evidence instruction. It's a little awkward because it would be something like, before you consider any electronic communication in your deliberations, you must first find that it is more likely true than not that the person who appeared in the communication was in fact Karen Reed. So think about that when I come back out. But I think it's appropriate to give a humane practice instruction, and also tell me what you think about what to say about the weight. The third question is a little bit more, I think, unclear as to exactly what they're looking for. Does convicting guilty on a subcharge, example offense 2 number 5, convict the overall charge? What I'm proposing, I gave you both a verdict slip where I included the language. I know yesterday I said they have to be read hand in hand, the jury instructions with the verdict slip. I've incorporated the language from the jury instruction into the verdict slip.
Yes.
I've given each side a copy. When I come out, I'd like your input on whether you think this is appropriate. I would instruct them, as I did before, that they start at the top and work their way down. That's the only thing I did not specifically
just exactly
put in here,
what
but
we
I think
said you should do the
takes it
first time.
Step by step.
Walk them through how to fill out
an
the
analysis
form.
to do it. So how much time does the defense want to be able to respond to me?
Perhaps 15 minutes.
Okay. And the Commonwealth?
That will suffice.
Okay. So it's 7 past. Why don't I come out at 25 after? Give you 20 minutes.
Thank you, Your Honor.
All right.
And then we wait, and then they chit chat, and then they chit chat. So let's talk about these questions, guys. Let's talk about these questions. Yes, very clear. All we are talking about is the OUI. We are having no conversation whatsoever about homicide. And to me, that is very significant. I think that does tend to indicate it was not hard for them to reach agreement on homicide. I think it's also clear that they have reached agreement on homicide, because if you've reached agreement on homicide and you're convicting Karen Reed of voluntary manslaughter, the OUI is an afterthought, or you're convicting her of murder. Certainly, the OUI is an afterthought. You don't care. If you have somebody on the jury who has figured out, at least, generally how to fill out this verdict form and what it means, then they would already know you don't even get to OUI before you've said not guilty on any homicide charges. So it does seem to be pretty significant that come back this morning and that's what's holding us up from going home is the OUI. To me, that really does tell a lot. So interesting question about the time frame. Very interesting question about the time frame. Is it 12:45 or is it 5 a.m.? Now, I don't know if the indictment says, because that would be the first place that you would look, wouldn't you? But typically, indictments tend to be in very general language. The charges in general, it's going to be typically on or about and maybe a date, but they're not usually required to, like, you don't necessarily have to charge the time. Where it comes up is that this is kind of an interesting issue, I think. It hadn't really crossed my mind with this case. So I have no idea how this doctrine, if it exists, if it plays out in Massachusetts or not. But in Washington, we have issues with unanimity, with jury unanimity. There's this landmark case called Petrich, State versus Petrich. And so what it says is that the jury has to be unanimous if there are multiple acts that are presented that each one could constitute the crime, but you're only just charged generally with one criminal act. Then the jury has to agree specifically on which act it is that you committed. If they're going to convict, they can't just generally, well, you were guilty of some of it, and some of them think it was this one, other ones think it was that one, because you have a constitutional right to a unanimous jury verdict. So if they're not agreeing on which act you did, and some of them think, that one didn't even happen, then you just run the risk of a situation where people just figure where there's smoke, there's fire, and go ahead and convict, even though they aren't actually in agreement about what happened. So in Washington, what happens is the prosecutor has to either specifically tell the jury which act we're relying on, or the jury has to get an instruction, it's called a Petrich instruction after that case, that tells them you can only convict if you unanimously agree on which act. So it could be either, but you would have to just unanimously agree on one or the other. And in that case, you could convict. So we have this, this whole body of law over there over here in Washington that would have been implicated here. And I got to tell you, it didn't even cross my mind. It didn't even cross my mind that 5 a.m. going out and driving, that they could, that could be the basis for an OUI too. I guess, OUI is sort of a new consideration in the case after 3.5 years. So suddenly we have to really focus on that. But that is that's an interesting question, right? Because it's much closer in time to when she had her blood drawn. So they, of course, don't have the retrograde extrapolation to 5 a.m. To be able to get her blood alcohol content. But they know what it measured in the hospital a few hours later. They know, what the range of it would have been all the way back at 12:30. I mean, assuming they credit the retrograde extrapolation testing. I don't know if that gets them there. I forget, what was her BAC at 8 a.m. I remember the range, the extrapolated range was the 0.1, 0.14 to 0.28. But what it actually was at 8 a.m. Oh God, am I going to have to pause and grab my notes out? I think I might have to. All right, give me half a second, guys. All right, I should have known better, but I did already put my notes back where they're not quite in reach. So let me find, it was Dr. Faller. I don't remember what day he was on. He was on day 4. Let's go find. Let's go find what he had to say. So it was the serum. They have the 1.18 conversion. Remember all that testimony, guys? Remember all that testimony about serum conversion rates and all that? Seems like it's been a million years ago, doesn't it? 9.3 nanograms per, or micrograms per deciliter, milligrams per deciliter at 9:03 a.m. when it was drawn. So 4 hours later, 0.93. That is that's the serum level. If they were taking really good notes, they have the math with the 1.18 conversion rate. And I forget if they actually did that in the trial. So you're closer to a 0.8 something. So you know, she might not even be over the limit at 5 o'clock. Just interesting. But you know, Massachusetts, it doesn't require, you don't have to be, you know, over the limit. You don't have to have a measurement over the limit to be found guilty, as long as they find you're affected by. But I find that kind of interesting. Just who's negotiating the time frame, and like what does that mean? How does that factor into not being sure about not being sure about whether there was a DUI or not, or whether you're going to convict on DUI? So then the video clips of Karen, that question, are they evidence? How do we consider them? Yeah, they are evidence. Yeah, you give them the weight you want. It sounds like maybe some people give them more weight than others back in the jury room. Maybe some people are really hanging their hat on Karen saying, oh, I had, you know, the drink count was 4, 5, 6 drinks. I don't know. I was a little, you know, she said something along the lines of like, I, you know, obviously wasn't as safe as if I hadn't been drinking at all, but I felt fine. And she said multiple times she felt fine. Is that, see, it seems like that would be what they're talking about, because that's relevant to the OUI. How can we consider them? Are maybe some people are discounting them? Are people saying like you have to accept what she says? Like, I don't know. There's some kind of dispute over Karen's statements. And then the last one, does convicting on OUI convict on the overall charge? I mean, I think that just really tells you everything about what's going on here. They're really concerned that this is lesser, and that it doesn't, you know, there's no overlap. There's no like implication. If we convict her on OUI, does it automatically convict her of manslaughter? Kind of seems like that's what they're concerned about, because it's a lesser. People don't understand lessers, and it's not a separate charge. And so why is it a sub? Why is it treated differently than these other ones that stand alone? And we just keep coming back to the problem that is lesser included offenses. Okay, I saw this this question, this issue come up in the chat. The Iceman 101418, is there a winnable constitutional argument for barring lesser included charges? It seems to me that more often than not, they are used abusive. No, there's really not lesser includeds. I mean, I suppose maybe somebody could make a creative novel due process argument about, you know, how it's just isn't fair. Basically, due process is kind of your dumping ground for it's not fair arguments. But lesser includeds have withstood scrutiny a number of times. It doesn't create a notice problem because the idea is it's incorporated in what you're actually charged with. That's what makes it lesser included. So they automatically have to prove that to prove the greater one. To me, it's not an issue like that. The problem is that, I mean, you can see it in this case. They chose not to indict on this. And so because they chose not to indict on it, we have this distinction in Massachusetts with how it gets treated by the jury as a standalone thing or as something that has all these implications with other charges. So think about it from an incentive perspective. If you're a prosecutor, you're prosecuting this case, what possible incentive do you have to even present OUI to a jury, to a grand jury, and get an indictment on it? Because if you can necessarily give it to the trial jury, and by the way, with the upside that if they can't agree on it, we get to retry her for manslaughter. If this was charged separately in a separate indictment, they could decide it separately. And if they hung on that, then that's the only thing we're coming back on retrial for, if we had charged it in a separate indictment. But because we didn't do that, we're just taking it as a lesser if they can't agree on it. So why would I ever take it to the grand jury? I never would. And that to me is a pretty distorted incentive. Is that raised to a level of due process? Doubtful. I mean, the question is there a court out there that would buy that? I don't know. But yes, it's a problem. It leaves a massive amount of discretion and control over the outcome and the process, how the process unfolds, just with the prosecutor's decision making. Gives the prosecutor a massive amount of control over how the whole process unfolds and what their position is. You know, their position in the event of a retrial. So I don't know of a constitutional argument, but it seems like it should be wrong. It's certainly something that could be addressed legislatively. They could pass legislation saying not allowed to do that. If you're going to proceed on a charge and present a charge to a jury, you have to present it to a grand jury and get an indictment on it. And they could, while they're at it, pass legislation that says if you change the facts, the fundamental facts on which you're relying to get your indictment, you're going to present a whole different factual theory to the jury. The trial jury, maybe you need to get a new indictment on that too. No reason you couldn't do that legislatively, but the reason why is because of lack of political will to do that. So those are our questions, guys. Those are our questions. So when we paused on the video here, we were waiting. They were, going to go do their confer and decide what it is that they were going to do next, and then come back. So we'll go ahead and skip forward to that. I've got it queued up, and we'll check out the conference, the conversation about how to handle it.
Please be seated. Court is in session.
All right, so I will hear you on the first question, the time of the OUI. Any suggestions?
Your Honor, do you want to hear from the defense first?
I'll hear from you're standing up, so I'll hear from you first.
I'll hear from whoever.
Question number one, what is the time
No
frame
control.
for the OUI charge, offense 002, section 5, OUI at 12:45 or OUI at 5 a.m.? Our suggestion would be something along the lines of, ladies and gentlemen of the jury, you have the evidence. It's your decision.
You are the fact finder.
You're the fact finder.
You're the fact finder.
Mr.
So that
Brennan?
sounds like they
Or
want
whomever from
they
the
want a
Commonwealth?
conviction.
My suggestion would be 12:45.
And why is that?
The case has always been focused at that time. I don't think there's anything specific in the indictment though regarding the time.
Do we have the indictments?
No.
We don't have the indictments. Why not?
You know, the indictments.
You don't have the indictment. You're
If
in
it's
the
not in the
courtroom.
indictment, I'm uncomfortable telling them a time.
I'm sorry?
If it's not in the indictment, I'm uncomfortable telling them a time.
Understood.
All right.
I agree with the court on principle. I just don't have the indictment memorized, so I don't remember if we can pull that up.
There's no time in the indictment. There's no time? There's just the date.
I don't expect that there's any time to be.
All right. So I'll say you have the evidence, and remember, you are the fact finders, or something to that effect. All right. Are the video clips of Karen's interviews evidence? How can we consider them? So I'll tell you what I was planning on saying, then you can add to it.
Sure.
Yes, the videos are evidence. Give them whatever weight you think is appropriate to give them. And then I would give the digital evidence instruction and the humane practice instruction.
The only thing I would respectfully ask the court to include in that sentence is give them whatever weight, if any, you deem appropriate.
All right.
If any.
Okay.
Thank you. Otherwise, it's fine.
We raised the issue of preserving.
Whatever weight, if any. Got to have that if any in there. So no unanimity concerns here.
What's the
Hank was
Commonwealth's
willing to
position?
say
We have
just
a
this
different
one.
perspective on that.
Okay.
The first part of the question, are the video clips of Karen's interviews evidence? The answer should be yes.
Okay.
How can we consider them? I think it's fair to say you should weigh the defendant's statements as you would evidence. Since they've been introduced substantively, they are like any other piece of evidence. There's no difference, and there shouldn't be any reflection of a difference in the answer. We didn't introduce any evidence in this case and say you should give it any weight, if any at all. We didn't provide a limiting instruction in any way, and these shouldn't be so limited. This is just like a photograph. It's no different than a physical piece of evidence.
He's not
And so
wrong.
I
It's
think
the
the
same
answer
as
should
any other
simply be
piece of
yes.
evidence.
You weigh the defendant's statements as you would any other piece of evidence. I do not think the court should give humane practice.
I don't like
or
that.
digital evidence. It suggests that there's some deterioration or further analysis that is different. Those instructions were already given during the charge. In addition, those instructions are in their hand in the written jury instructions. And so, to put it most simply, as I think that we should, is this is a piece of evidence and you weigh it like you would any other piece of evidence, whatever they decide, rather than give them guidance to curtail it or to limit it in any fashion.
My only suggestion, Your Honor, is that every single piece of evidence that's provided to them, it's in keeping with Massachusetts laws, in keeping with the responsibility that they have. Every single evidence is given the weight, if any, they deem appropriate. That is not a misapplication of the law. I think the Commonwealth's suggestion suggests in the answer that they should or they have to give those statements weight, and the law is they don't have to give them any weight. So I think
You don't
the
have to give
appropriate
them the same weight as
comment
other evidence.
by the court is exactly as the court suggested initially, which is you give it whatever weight, if any, you deem appropriate.
It is better because they don't have to give it any weight. They can say, I don't trust it. They can say it was taken out of context. They can say it's not sworn. They can say she didn't get to talk about it, explain it. They can have any reason for saying, I don't think this evidence matters. And so if you're going to tell them it counts like any other piece of evidence, that's suggesting if there's evidence like DNA test results that are pretty good, you go ahead and rely on that too. You know, rely on it like you would rely on a DNA test result. That's not the law. What I find ironic in all this too is we're taking this time, and Bev just basically, she's reading through it. She's gonna write stuff out. She's looking at stuff. And then what do we get? She's like, well, I'll say something along these lines. She won't even like write down what exactly you're gonna say. And then read it, and then just read it. And then that way there's no issue with a discrepancy between what you say to the jury and what you've written down as what you're going to say. She's writing all this stuff down, but then she's just going to go wing it to the jury. And it makes things messy. Makes things very messy, Bev. Just write it down, commit, and say it.
You can keep scrolling down. Past this. Just keep.
Well, I do. I'm still like, I'm hung up on this 12:45 or 5 a.m. thing. I really hadn't even thought about that as being a separate act. And then what would I want to do if I'm at the defense table?
All right.
Is it better to have
what I'm
both of
going
those
to
off
say
the
is,
table?
yes, the videos are evidence. You should weigh the defendant's statements as you would any other piece of evidence and give them whatever weight you deem appropriate. But first, then I'll go and I'll read the electronic communications and the humane practice. That covers it.
I don't have a principled objection to it if the court adds the word "if any,"
I understand.
because every single. I
I
don't want them to
understand.
think,
I'm not
for
gonna say
instance, the way that it's worded as the Commonwealth suggested it.
But I understand.
They have to weigh it the same way they weigh other pieces of evidence. Every single piece of evidence is weighed in and of itself. It's individual to the piece of evidence that's presented. For instance, they could weigh the statements by Ms. Reed. They could give it no weight. Each individual juror could decide, I'm going to dispatch it altogether and give it no weight, while giving another piece of evidence, like whatever that might be, the testimony of one of the ARCA witnesses, a complete weight. I think that we need to stress that the clips bear no additional weight, no additional gravity than anything else that they've considered. And the only way to do that is very simply, you give this the weight, if any, that you decide is appropriate. It doesn't, I think, comparing it and contrasting to other pieces of evidence in the case, it's unnecessary, and it tends to suggest they have to give it weight.
Okay. So your objection's noted. Now let's get to the third one. Does convicting guilty on a subcharge, example offense 2, number 5, convict the overall charge? What do you want to say, Mr. Jackson?
Your Honor,
No.
I appreciate the effort that the court went to amend the verdict slip as it relates to count 2. And I think there are some excellent suggestions by the court in the verdict slip. By and large, I think question number 3 is answered by the amendments in the verdict slip. So we certainly could say something like, does convicting guilty, the question was, quote, does convicting guilty on a subcharge, example offense 2, number 5, convict the overall charge? The answer is no, obviously.
Mm-hmm.
And
simple answer is
perhaps we could
no.
formulate an answer that says something along the lines of, no, new verdict slips have been provided that will make it more clear, or something of that nature.
She'll never
As
say
well
that,
as
because that
a
implies
decision of guilty on the OUR
the original one was
charge,
wrong.
002, number 5, is an explicit acquittal on the higher charges in offense 002, which is a proper statement of the law.
Explicit acquittal on higher
And then
charges.
There are suggestions that we have regarding the edits that the court has made to the verdict slip. And I'm happy to go over those with you and put those
Okay,
on the
go
record.
ahead.
With regard to going from the top to the bottom, just under number one reads, not guilty of the offense charged or any lesser included offense. We would propose that the court add the language, the consistent language that it's added throughout the verdict slip. If you quote, if you find the defendant not guilty of the offense charged or any lesser included offense, comma, stop and sign the verdict slip, period. That's the only place that that language doesn't appear, and I think it should appear.
Okay.
The second is a relatively minor issue. However, under number 2, sub 2, the parenthetical check one or both of the following, I think it should say, just to clarify it further, if guilty, comma, check one or both of the following.
All right, I think I'm going to leave it because it appears only under the guilty.
It appears only on,
Under the
Yeah.
guilty.
I think Bev is right on this
So,
one.
Go ahead. I'll hear you further.
going further, going under number 3, toward the bottom of the page, in the parenthetical that the court suggested, which we find is excellent. If you find the defendant guilty of the lesser offense
Okay.
of involuntary manslaughter, we would simply add that clause.
So we'd have to add it in all of them,
Correct.
which makes sense. I think
Correct.
we had it in the first one.
Right.
Okay.
And then moving to page 2, at the top of the page under sub 4, again,
Hold on one second.
of course.
Okay.
We had the same suggestion. It appears that the court is not inclined to give it. If guilty, check one or both of the following. And there's a typo. It says the parenthetical
We
says
fixed it.
check one of.
We
Yes. So we
fixed
fixed.
it.
We changed of to or.
So my only suggestion to that would be to, again, add the if guilty, comma, check one or both of the following.
Okay.
On that page, going down to the bolded parenthetical, same thing. If you find the defendant guilty of the lesser offense of motor vehicle homicide.
Okay.
Moving down under sub 5,
We
the
still
OUI.
need to say stop and sign the verdict slip.
Okay, do you need to sign the verdict slip, but they also,
Right, after the word stop and sign the verdict slip.
Yeah.
And then under sub 5, again, the same thing. We just suggested that for consistency that it say, if guilty, check one of the following of the both. And the final edit would be in the final parenthetical, the last sentence. If you find, I think her should be
Yeah.
changed to the defendant.
Should.
If you find the defendant not guilty on this offense and all other offenses, check the first box on page 1.
Okay.
And those are the edits that we have suggested for the verdict
All
slip.
right. Mr. Brennan.
I don't have any disagreement with the edits.
Okay.
The idea of instructing them on the nuance of selecting one guilty or not guilty, I don't think needs to be explained. I think that the edits, this proposed instruction explains it.
Yes.
All right. What
I
I,
don't have any issue with if you state, if you decide on a lesser included offense, it does not include the earlier offense. And I'm not sure of the exact language that can be. I don't think that's necessary, but that is something I wouldn't have an objection to. But I think the form that you filled it out with the edits is going to be sufficient for them to follow.
what do you think about the defendant's position that if you were to find her guilty of operating under the influence, Mr. Jackson said explicit acquittal. I don't like that language. I think if you find it, it means you have found her not guilty of each of the others.
That would be fine with us.
I think it's better if you find her guilty of any lesser included offense. It would not include the higher offense.
All right.
I think that's just confusing.
So what I planned on doing was bringing them out and giving them each a copy of the amended verdict slip, explaining that it really is consistent with the jury instructions I gave them, but walking them through it. So we start from the top and then explain, if you find the defendant guilty, you're done. Stop, sign the verdict slip, and let the court officer know you have a verdict or something.
I prefer that.
Yeah, I think I'll walk them through it like we do in civil cases.
I don't have any
Walk
objection to
them
that.
through it.
The only other thing is the digital instruction.
Yes.
We don't believe that it's necessary. I don't think that we should reemphasize that, and we're not asking for it.
All right, so you're waiving it?
We're waiving it.
Okay.
Yes,
All
thank
right,
you.
I will do humane instruction, humane practice instruction. So I need 5 minutes, and Tori, your computer, to amend this if we can, and we'll make copies. So we'll bring the jurors, let them know that we'll be bringing them in shortly, Tony. All right, thank you.
Rise.
So she needs 5 minutes to do exactly what, who knows, because she'll end up just saying, something to that effect. So guys, I do know we're waiting for, everybody's been told go back to the courtroom at 1:30. I am monitoring that to see what happens, but it is just the fans so far. But we will go ahead and jump over there when court comes back into session. So I'm still not sure what I think about 12:45 versus 5 o'clock versus do we want both on the table versus Hank offered to take 5:30 off the table. Do I like that? I mean, my prejudice on this, given what I explained with Washington law and our issues with unanimity, if Hank is volunteering to say just one, I'm kind of inclined to be okay with that. I kind of like that. But Bev says, we're not comfortable telling them a time if it's not in the indictment. Is there ever a time in the indictment? Has there ever been an indictment that has the specific time of the crime in it? I have to be skeptical of that. And I don't know why it would suddenly matter. Why do we suddenly have to elect the factual basis for conviction if we don't have to do that with the manslaughter? All right, guys, they are going live.
All right, so I'll see you at sidebar so we don't do this part in open court.
Okay, yeah. Go ahead, go straight to sidebar. We already know that's what you were going to do. So I guess it's just an issue of, is there a stronger case at 12:45 or at 5 o'clock? I guess my knee jerk is 12:45. That's, why Hank is willing to stipulate to that. That's closer to the, the retrograde extrapolation range. But the defense is just fine with you're the fact finder.
Jim, can I have that question, please? Thank you. All right, so as counsel knows, we received a question from the jurors. If we find not guilty on 2 charges but can't agree on 1 charge, is it a hung jury on all 3 charges or just 1 charge? I got some input from the defense at sidebar, essentially saying if we could just ignore it. We can't ignore it. To me, it's a theoretical question. And we don't answer theoretical questions. I tell the jurors that they're not to be concerned with the consequences of their verdict, and that's exactly what they're doing here. So I would propose just writing simply, this is not a question I can answer on this and sending it back.
You can't tell them what the law is on that?
I agree, we can't ignore your question. However, I think that it is apropos, given the timing of when that question came in, literally before the court had answered the other 3 note card questions. I think that it would be appropriate to send a quick note just asking them, given the fact that there's some clarity in your other questions, does this answer your question? In other words, can you proceed without any further input by the court regarding that second question?
So that made sense initially, but why ask them, do I really need to answer it to then tell them I'm not answering it?
Because I think at some point, they need to know what the law is. It's a reporting question. In other words, I don't see it as theoretical, as the court indicated. I see it a little bit differently, which is what are our options? And the options are built in the law, not in theory. If they come back with a verdict on more than one count, but they're hung on a separate count, they are to report those two counts, whatever counts they came to a verdict on.
So that's for a later time, right? So this is at this point.
Right.
It's premature, it's hypothetical, it's theoretical. I understand your point. I think I disagree with you at this point. It may be something later. The way the question's worded, if I find this, if we do this. I'll hear from the Commonwealth.
That's a
We agree
dodge.
it's consequence related. Your first suggestion, I think, is most appropriate, and we would endorse that.
Yeah, I'm going to do that at this time, Mr. Jackson. I'm not going to have a back and forth with them. I'm simply going to say, because it's true, it's the law, that this is not a question I can answer.
But I would strongly suggest that we find some other way. If that question continues to
No
remain,
answer for you.
then they're not going to ask that question. I don't think the court can say, or should say, I can't answer the question, because the court can answer that question. The court absolutely can answer it. I would simply say, this question is not before the court without further information, or something like that. Not the court can't answer that question, because if that question remains in their minds, we're going to end up in the exact same position that we were in last year.
There are other steps that can be taken to perhaps prevent that.
Whatever those steps are, I think the first step down the wrong path is to say, throw our hands up and say, well, we can't answer that question. Well, we know we can answer it.
So I don't know if I want to put you in an uncomfortable position. Mr. Yannetti, I'm inclined to answer the question the way I stated.
Could we have 2 minutes to confer with counsel, Your Honor?
1 minute.
How about 1 minute? You guys are 10 minutes late.
We do 1 minute. Thank you.
1 minute. Oh my Lord. You know you can't have two. You can only have one. Oh, for heaven's sake. Well. They don't know whether she's DUI or not. Good Lord. There's people that are willing to hang the jury over DUI. Is pretty much what it sounds like. So, if we find her not guilty on two, but can't agree on one, is it a hung jury on all or just on one? Almost like maybe they remember that this has happened before. Almost like they would like some kind of guarantee about how this is supposed to go down. It's a theoretical question, says the judge. Why? Because it has if in it. Because it has if in it. So you can't just tell them what the law is. This is a pure question of law. They haven't said, we have found her not guilty on two, but can't agree. What does that mean?
Language. I don't have a principled objection to the court's language that we not answer the question at this time. I would simply ask that the court answer the question as you suggested just now in open court. It's premature to address this question at this time.
No. What do you say, Mr. Brennan? My response was, this is not a question I can answer for the reasons I stated. It's theoretical, and we tell jurors that they cannot be concerned with the consequences of their verdict, and that's exactly what you would be asking me to endorse. What's the Commonwealth's position on the proposed?
I agree with your first suggestion.
Yeah. I'm going to send it in like this. Your objection's noted.
Your Honor, if I could make my record a little bit clearer, the court's indicating that it doesn't answer questions about the consequences of the juror's verdict. That would be punishment. Of course, you can't answer a question like that. This is not the consequences of the verdict. It's how do they report a verdict. So I think saying I can't answer this is sending a false message to the jury. If the court would simply indicate this is not appropriate for me to address at this time, that assuages all concerns. Certainly assuages our concerns.
About it when you get there. Address the hypothetical.
Well, I think what I could add is this is a theoretical question, not a question I can answer. That does the same thing. Is there an objection? I understand, Mr. Jackson.
Add the clause at this time.
Is there an objection to me putting this is a theoretical question, not a question I can answer?
No objection.
It's weird how she doesn't say that to does convicting on OUI convict on the overall charge. That's hypothetical too, isn't it, Bev? They haven't said We're convicting her on OUI. What does that mean? This is the same question, but just refined.
That is over our objection. I
understand.
just want to make sure the record is absolutely clear. That's over our objection. I don't think that's an appropriate answer to a very, very clear question. It could be answered in an innocuous way that does not affect Ms. Reed's rights.
Okay.
This way it does.
Okay, it was a clear question that the defense first told me to ignore. So
I think it's that.
Oh, God.
all right, we are all set. So let's send this.
We are all set.
All right.
Oh, man. She just had to get that little swipe in there. It's a clear question you didn't even want me to answer. Yeah, because I think they thought that the previous one would have answered it. It's the same thing. This is the same thing as the question 3 of the first question. Does convicting on OUI convict on the overall charge? How is that not hypothetical under this framework? Theoretical. Does convicting? This is asking for legal. This is in the abstract, pure legal question. They have not said we're going to convict her on OUI. It's not saying we're going to acquit her on everything that is not OUI. But that's the gist of where they're getting at. With now, if we find her not guilty on 2 but can't agree on the 1, right? Because we're stuck on OUI, and some people don't even want to give her an OUI. Like, how bad has the Commonwealth tripped over its feet on this trial when you've got a felony jury that's been here for 8 weeks? And they don't even want, there's some of them that don't even want to convict on a simple driving under the influence, where she went on camera and was like, yes, probably a little drunk, probably shouldn't have been driving. They just want to be sure it doesn't fuck the next jury down the road if they have to do this all over again. That's what this question is. They've already figured out this is why we're here. Are we going to fuck the next people if we don't do this right? It's the same question, but somehow, this one is theoretical. The other one was not. The other one was grounds to go through and revise the verdict form, guys, which we haven't, of course, watched yet. But I think we'll probably have time to get to that. It's the same. It's the same question. So I think that AJ is making a good record here. This is a very good point that it's not an encouraging response when you tell them, you can't ask that. You can't ask that. Peasants. I don't know, like, how are they going to express confusion with the verdict form under this standard? If they're doing ifs and stuff like that because they want to be sure they don't do it wrong? How is that not always going to be hypothetical? I don't know. I would love to see a question come back. We've found her not guilty of any homicide charge, and we just can't decide on DUI because that's how bad the Commonwealth's case was. But some people are really insistent on giving them that, and some of us aren't going to have it. So what does that mean? What does that mean for everything? I would love for that to just be real explicit on the record, because we already know what that means from the legal standpoint. From the legal standpoint, that would mean they can retry Karen Reed for voluntary manslaughter. They can do that. So might as well just have it explicitly on the record. Yeah, we're not doing that. All we're talking about here is OUI. Seems like that's pretty abundantly clear this morning. That's all we're talking about at this point is OUI. If we find her not guilty on 2. Yep, great point AJ's making, that this is the same. This is the same issue with last time. This is the same problem that's emerging. And how do you like before he can even get it out, before he can even stop, we'd like to ask the court to just say that answering the question would be premature. No. She's like, knee jerk. No, I'm not going to do that. No, I won't. It's completely closed off to modifying her position, her perspective, one tiny bit to find common ground with the defense and to see it their way. Not one tiny bit, just the instant reaction, the knee jerk, instantaneous response, reject. We're not going to evaluate what does this portend. We're not going to evaluate, is this tone going to be helpful? Is this going to encourage the jury to work it out and get to where they need to be? I can't answer that. Don't ask that. What are you thinking asking that? That's not your business, plebes. Ugh, l'état c'est moi. L'état c'est moi is so much the theme of this court. Well, of course, they are bringing the jury back in, but I am, not going to stare at the fan while they do that. Hospice Jess says, Andrea, we've missed your level head. Well, thanks, Hospice Jess. I haven't minded one bit having a little bit more of a normal sleep schedule. It's been great. It's still not, still not like it was, but yeah, we're real close. Real close getting our lives back, moving on. Maybe fingers crossed, even some of that for Karen. Rhonda, Iowa girl, my husband said your lawyer friend was right about the jury form. He saw that part when he walked into my office and I was watching you. Of course, you were right. This one did not take any special talent, guys. This was a problem last year. It's extremely foreseeable it would be a problem this year. It's a messy form. It's confusing anyway. It's not clear. Why are we treating these things differently than we're treating the other ones? It's just, this is a thing that doesn't make intuitive sense to people that aren't used to dealing with the nuance of legal documents, having to parse every word and think about the structure and all that. This one, I don't take any great credit for that. I think Stevie Wonder could have seen that one coming. It was going to be Ray Charles knew this one was going to be a problem. Z, with Bev Delay's verdict, maybe 2:27 p.m. Poetic Justice. We still got some time. We still got about 40 minutes? 40 minutes. If we had a verdict in 40 minutes, that would be kind of funny, wouldn't it? Danielle C, what's the OUI law time frame for OUI tests there? That's a great question. Let's see if we can find it out. Why not? Let's see if we can find that statute. Let's see. Not seeing anything that says there is a time limit. So most states have like 500 gazillion statutes for DUIs because there's all kinds of different minimum fines, suspensions, hearing rights, victim impact panels. There's like all kinds of things. So it can be a little bit tricky to try to sort out where you can actually find things. There's a whole like page on mass.gov about alcohol and drug suspensions, but that looks like it is mostly administrative stuff. Can you just tell me the statute where they have blood draws and then I can poke around? Nobody wants to tell me that either. Well, let me see. See if I can search something a little more specific. What ends up happening, you know, when you just search this stuff in Google generally is, you get a bunch of lawyer websites, and sometimes lawyers have really good websites, and give you like, you know, pretty detailed, comprehensive stuff, but most of the time they don't. Fortunately, most of the time they are just giving you kind of broad general information. You don't want to, you know, give away the whole ball game to somebody that you are trying to get to pay you to be able to answer those questions. So most of those you get a little bit of a teaser. Oh, that's not a good search. Okay. I'm just over in Google Scholar. What I've done, if you're interested in the method, I just try to find a case that's about the DUI blood draw statute so I can get the citation for it. And then I can look up the citation and I can browse around in the statute and see if I can find anything that would say if there's a limit on the time frame. All right, here is something. Massachusetts General Law, Chapter 90, Section 24 is the DUI statute. While under the influence, 0.08, mandatory fines, previous conviction. I'll just, I don't want to switch over the tab in case they bring the jury back in, you know, soon. Which is what I assume we're doing. We're waiting on because they had a question. We just had an argument about how to answer it. Are we just waiting till after lunch? Maybe. They've been doing lunch at the 1:30 to 2:30. So, but I'm afraid to click off the screen. But I got to show you guys so that you can understand why I'm staring at this. This is, like I said. So apparently in Massachusetts, they don't do 100 gazillion statutes. They just do one that's like 10 miles long here. See how long the DUI statute is? They just cram everything into the one. Look at this. It just goes on and on and on and on. They're like Nobel Prize short stories that are shorter than this. Let's just hunt through and see if it says blood in here anywhere. Blood. Okay. Does this say anything provided? The question of whether the defendant was at the time under the influence of intoxicant provided. Okay, if such test or analysis was made by or at the direction of the police officer, it was made with the consent of the defendant, the results made available to him, and defense was afforded a reasonable opportunity to have another such test or analysis, blood shall not be except by evidence that the defendant failed. So nothing so far about any kind of time frame. 5/100, there shall be a permissible inference that the defendant was not. I'll call the 2/100s. A certificate signed and sworn to by a chemist of the Department of the State Police or by a chemist of a laboratory certified by the Department of Public Health, which contains the results of an analysis, shall be prima facie evidence. None of this is saying that there's any kind of time frame to take the blood. The informed consent means that you're deemed to have consented. These are all just about suspensions for various reasons. The suspension of a refusal of either a chemical test or an analysis of breath or blood shall run consecutively and not concurrently, both as to any additional suspension periods arising from the same incident and as to each other. That was something that we kind of were talking about the other day on Bob and Allie's stream yesterday. Different states do that differently. If she gets convicted of OUI, what's the consequence of that? She hasn't been able to drive for like 3 years or something, but it's not clear she would get credit against that. Okay. None of this is saying under 21. None of this is saying that there is a time frame. Within a reasonable period of time. Wait, let's see. Whether a blood test administered pursuant to paragraph E within a reasonable period of time after such. Wait, what is such? This is just something totally different if they do a breath test and you challenge it. That I think is the closest that we're going to get to any kind of time frame in any of this. A reasonable period of time. There's nothing explicit that I can find in the statute that says, you know, they have this long. So guys, we'll go back to the fan because I don't think that there is a specific one, but went ahead and spent some time going through that. It looks like, thank you, Jeff. Jeff has found Commonwealth versus Colturi, a 2008 case. It says Massachusetts courts have emphasized that BAC evidence must be scientifically reliable and relevant to the time of operation. While no fixed time limit is set, blood draws typically occur within 1 to 3 hours of driving to ensure the BAC is admissible, as alcohol metabolizes at roughly 0.015 to 0.02% per hour. Think that's reasonable. It's a reasonable time, and generally within 1 and 3 is going to be good, but they're not going to rule out that other time frames would be unreasonable. So basically what that means is that there is no time frame. It can be whatever, and if they want to put it into evidence to convict somebody, they will. They'll find a reason why it's reasonable. Because reasonable can be anything. It can be it might be the most scientifically invalid thing ever, and we might get a range from like 0.03 to 0.51 or something like that because we waited so long. But that was reasonable because the defendant had run away and was hiding and wasn't able to be found until later. So, you know, they couldn't have done it any earlier. So it's totally reasonable that that's when they got it done. You know, something like that. Let me be able to find a justification. Reasonableness can be anything at all. Brooklyn James, if jury says OUI guilty, will OJO family talk at sentencing? I mean, I assume probably anyway. But I don't know. I don't know. I assume that they probably would anyway, because that's just normal for families to talk at sentencing. You know, routinely get up and want the book thrown at the person, given the maximum that's allowed under the law. It's sort of the script that's there for them to follow. What do you guys think? Would they take that personally? Would they like boycott sentencing if all they get out of it is an OUI? That's a wait and see, isn't it? Wait and see. I guess maybe we just won't answer hypotheticals here. We don't answer hypotheticals. We'll answer hypotheticals here, but this is maybe just a, who knows? We just have to wait and see. I think yes, they would still speak at sentencing, but just me. Mickey, if found guilty on OUI, but statute of limitations has passed, what happens then? The statute of limitations has not passed for a couple of reasons. One, statute of limitations in Massachusetts is apparently 6 years. That's what I saw. If somebody saw something different, let me know. But for general misdemeanors, which OUI is, I saw that the statute of limitations is 6 years. So that's pretty long, at least relative to what I'm used to. I'm used to misdemeanors being like 2 years, 3 years, maybe something like that. So it hasn't passed just even in calendar time, but it wouldn't pass because it goes from the date of the indictment. She would be considered constructively having been charged with OUI at the same time that she was indicted for voluntary manslaughter, that it's the lesser of. So there would not be an issue with the statute of limitations here. AHAP, as this trial comes to an end, throw a buck or two to AB if you're able. She's given so much time and intelligence to this trial. Think of her trees. They've missed her so much. I am not a paid party, just a fan. The trees have missed me, guys. If you're not over on X or Instagram or anything like that, which I certainly don't blame you if you're not, but I did share a couple little images of what I've been up to. I'll go ahead and why not? I'll go ahead and share that with you guys while we're looking. This is the trees. This is what I've been up to here. Get me off the screen there. So that's a little pruning that I got up to. This is the Chinese elm. Remember, guys, I was saying if you want one that you need to work on all the time, get your hands on all the time, Chinese elm is great because it's constantly growing. This is the second time I pruned it this year. All that lighter green stuff, that's the new growth. The darker green stuff is the stuff that came out first in the spring. And so now I'll wait another 3-4 weeks and it'll send out long shoots again and get real hairy and and we'll do it all again. This is just out there watering, guys. When you hear me saying I need to go out and do some watering on the trees because I need to pamper them like this. This is the tree in its happy place. This is my Korean hornbeam. It's probably my best trunk. Very good tree. I mean, it's still in the process of getting developed, but so those are a couple of things. And then of course here, let me pull this one up. This is what I was busy with this morning, guys. This is why I was a little late getting to the stream once things started happening. These are the chickies all grown up now. They look like all full grown chickens now. So these are some of the babies. So they look very Americana. Some of the tells for the Americana chicken, they don't have the big combs and wattles like you see like your foghorn leghorn kind of chicken. He's got a great big comb on him. The Americanas, they don't have anything like that. Very, very clean looking birds, in my opinion. But then they got their face feathers, they got their beards, and so they're feathered out enough now. Their little beards are coming out, so it gives them a little character. I think they're fun. So anyway, That's what I've been spending my time with, guys. Oops. Let me get that back off. Brian Coker, glad you're on. I had to watch other streams. It's like going to favorite bar, but your bartender isn't there. They don't know how to make my drink. Yeah, but booze is booze, isn't it, guys? At the end of the day, I had it's a couple of years now, and I still remember because I go out to drink so rarely anymore. But Jeff and I went to the comedy club here in town, and a little date night. And the bartender, I got a Manhattan. I usually will get a Manhattan if I'm out getting a cocktail. It's just, fairly easy go to. Well, this bartender, bless her heart, she really thought she was doing me a solid, because I watched her just like glug, 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 glug the bourbon, and then just a tiny little splash of the vermouth. And it's not what I'm about, guys. That's not what I'm about. It's about the recipe. It's about the balance. It's about the cocktail. But I couldn't hate on the bartender. She really thought she was helping me out there, doing me a solid. It's just it was not to my taste. It wasn't a good Manhattan. It was a great glass of whiskey. It was not a good Manhattan. Well, Brian, I know. I'm just not one to sit and talk about nothing. Nothing's happening. If things are happening to talk about, by all means, we'll talk about them. So just took me a minute today, but glad you're back in your comfort zone. Virgo, thank you so much, Andrea. You are a fountain of knowledge on law in the U.S. Found you during Delphi Richard Allen case. Keep up your excellent work. Well, thank you, Virgo. Appreciate that. Thanks for being here with us. I know a lot about Washington law. I can tell you all kinds of things about, like, hey, if this question were coming up in a Washington court, we'd have Petrich issues and unanimity issues and stuff like that. And it's wild to me sometimes how different states can be about stuff like that. Because that, to me, that seems very fundamental. Like, jury unanimity is not an issue that's unique to Washington. So why do we have this jurisprudence that apparently other folks don't? It's apparently our Constitution and not federal due process issues or federal notice issues or federal unanimity issues. At least not that the federal court system has picked up on, at least not as far as I know. Because if they had, then it would seem like that would also apply in Massachusetts, and we would be having a conversation about unanimity if we're talking about two distinct acts, each one of which could constitute the charged crime. Jury's got to be unanimous about why she's guilty, what makes her guilty, what did she do that makes her guilty. It's the whole function of having a jury. So, I learned a lot through this process too. To Truth for Liberty. OUI instruction without a time frame for the act committed. Fact problem. In KS, lesser instruction is plain error. No objection needed. If not factually inappropriate. I think most states have a standard of there has to be at least there. You can't ask for a lesser if there's no evidence. There's no way for the jury to reasonably conclude that only the lesser offense has been committed and not like necessarily the greater one. And I'm trying to think of come up with a example off the top of my head for that one is not going to happen. But that is the general idea. So, okay, well, I'll give you a fact question because it's come up before. In fact, here's one I got for you because this was a case that I had on appeal not too long ago. And so the issue was this was this is not a very nice case. This was a guy who got jumped and beat to death in the jail, and it's pretty bad. Quite a shit kicking. And so anyway, my client is one of the folks who's involved in it. If it's in jail, the whole thing's on camera. There's a gazillion witnesses. There's not really a whole lot of dispute about what happened. It's just who knew what, who was more culpable than who, what was, were there motivations that make more, some people more culpable than others, that type of thing. My client this is gang related stuff. My client is like gets a few kicks in. Basically didn't start it, didn't finish it, did participate. And so they're charged, everybody's charged with second degree murder. My client's tried separately. They get a lesser included instruction on voluntary manslaughter, but they did not get a lesser included instruction on involuntary manslaughter. And so the difference between those two things, voluntary manslaughter, there is a risk that a reasonable person would have known. A reasonable person would have known there was a risk of death associated with what you did here, and you recklessly disregarded it. You knew and consciously understood that there would be that risk, and you decided to go ahead and take that risk anyway. Involuntary manslaughter is more of a gross negligence standpoint, so it's more like it was foreseeable that something bad would happen, and you proceeded. So in that situation, they just basically concluded, well, the facts, because the whole thing is, caught on video, the facts don't support an inference that this was only negligence. So refuse to give the lesser included instruction on involuntary. That came up on appeal. They said it was fine. I'm still not entirely sure that I see why. Why is it precluded on these facts? My whole argument had just been, this wasn't a situation where there was really obvious injury. It wasn't like, it's not like a stabbing or something like that where you can kind of, it was very harsh beating. Don't get me wrong. It was not a good beating, but it also was like just a beating. It wasn't like shooting something. It wasn't like stabbing somebody. So possible you just get a little carried away. You get a little over exuberant. You're not really thinking, because he ended up dying, similar type of situation. He died of internal brain damage. His brain basically got knocked around in his skull so much. Anyway, is that a particularly good example of a situation where they said it wasn't factually appropriate? You couldn't say it was just negligence on that. The court said yes. Court said that was fine. I was like, I'm not quite sure. I see, but whatever. That was the best example I had. And so that is also the case in Massachusetts. I saw that in one of the notes to the jury instruction, the form that they have on the lesser included instructions. There does have to be some reason to think that only the lesser charge was committed to the exclusion of the greater. And so if the facts don't permit you to make that inference, then they're not supposed to give the instruction on the lesser. By taking out the time frame, does that change that situation? I don't think so. I mean, it just means you now have more options to consider the OUI. All this time I've been thinking only about OUI at the 12:30 time frame. Never even crossed my mind that they might be thinking OUI the next morning. See, this is why, this is what the jury does that makes it such an unpredictable institution. All these years later, here we are thinking of new things, new issues. Just hadn't even crossed my mind that would be an issue, but they're thinking about it. So I don't think that means it's factually unwarranted. They could, if there's a circumstantial case, that's enough. And the circumstantial case can be the, she only has to be affected by, her driving affected by alcohol. Doesn't have to have the per se limit. The serum, 3 hours later, 4 hours later, right at 9 o'clock. The serum was the 0.93. I don't think you get there, but it can be circumstantial. So I think there's an argument that they could get there on 5 o'clock, just under the affected by prong. Maybe that's why it took her 28 minutes to get from Meadows over to Jen McCabe's house, because suddenly it's not snow. Like suddenly it's not snowing isn't a problem. It's like been a problem all morning, but suddenly when it's time for Karen to drive to Jen McCabe's house, why is it taking her extra time? What on earth is she doing? Guys, she's driving in the snow. The worst storm in January in Massachusetts history. She's out there driving in it. Coffee addiction. It looks like the jury decided Bev isn't qualified to write a verdict slip. Don't worry, Bev, your rights are saved. It ate her up. It really did eat her up, right? To have to go in and correct it. Or was she setting that up? Did she keep that in her back pocket the whole time? Is that why she insisted, no, we're not going to change the verdict slip when the defense first brings it up? So that once the jury gets confused, she can backpedal, she can, step into the position she should have taken all along, which is just walk them through how to fill out this verdict form. It's not rocket science. Courts around the country do it every day. They figure out just very cleanly and clearly and systematically, just say it. Just say it. Just go ahead and say it. Just walk them through what they need to do. That's her fallback position. She is like, is she coming at it like one of the parties who's got a negotiating position, came out unreasonable, plainly unreasonable, so that when she gets a little bit of pushback from the jury, her fallback position can be what you frickin' should have done all along. I'm not going to say no. I guess we'll never know. Alyssa Ramirez, could you find her guilty of just OUI at 5 a.m. if it's under the manslaughter charge? If allegedly the offense happened at 12:45, why not have a separate charge? Well, I wonder if this is the kind of thing that the jury is thinking, because the manslaughter charge isn't specific as to time either. It's kind of generally clear what the time frame is, because I think we're assuming that John was dead before 5 a.m., but maybe not. Maybe not. It's just a kind of general series of events culminating in John's death and culpability, up to the point of finding him the next morning and he can't be revived. So it's not unusual for charges to be presented in these very broad and in general terms as far as the time frame goes. But I do wonder if this is what the jury is thinking. Why? Or some people in the jury are thinking, I don't know, like who's thinking 5:30? Are you leaning towards, it seems like you have to be leaning towards guilt and wanting to convict Karen of something, to be like, well, but maybe there was a DUI at 5. I mean, I don't really see a scenario where you don't think she's OUI. Here's kind of how I see it. Here's the best sense I can make out of it. What the jury's thought process is. I could see a scenario where the defense argument on the OUI and the burden of proof, it is kind of trying to have it both ways, right? When they first gave that lesser included instruction, it was very confusing to me, because I'm like, why wouldn't you just, if you want it, you're inviting that compromise verdict, then why wouldn't you just make that argument to the jury in your closing? Why wouldn't you just tell them explicitly, guys, nobody's going to argue with OUI. Nobody's saying she was perfect that night. And if that's going to bother you, knowing that she's not perfect, go ahead and find her guilty of the OUI. She admits that. She owns that. Don't let that worry you at all. Go ahead and find her guilty of that and go home. If that was kind of what your strategy was to get it done, which seems like what the strategy is for OUI, for including it as a lesser, requesting it be included as a lesser anyway. That's why. It's because you want that compromise to be available. But they didn't do that. And instead, they, in closing, talked about, Commonwealth hasn't even met its burden of proof on that, because you don't know. They don't know what happened. They haven't proven what happened. You have this massive range, but it's based on the assumption about what happened when she went home. And we have no idea if she went home and maybe had a few drinks. That's why her blood alcohol was so, so high the next morning. It is kind of having it both ways then, to be like, well, but then later that morning after she'd had those drinks, it's like, if you want the benefit of that possibility, that inference, you can't find her guilty at 12:45. But if she went home and drank, then that factors in at 5:00 when she woke up. I could see that type of situation. Somebody who's just really hung up on making sure that there is some negative consequence to Karen. Don't like that defense argument. It seems very likely that some of the jurors are not buying even the 12:45. They're not even buying that she drove drunk that night, guys. She said it in her own words, and they're not even going to buy it. The Commonwealth couldn't even sell that. It's mind-blowing. But somebody really, really, really wants Karen to suffer some consequences. So they're like, look, the defense said maybe she went home and drank. Maybe that's why. And if that's the case, if they want me to give the benefit of she wasn't guilty of it at 12:45, maybe that means she's guilty of it at 5:30. So it almost seems like this question potentially was them trying to shut the door on 5:30. The jurors that are not buying in on any kind of conviction, like, we're trying to shut down wanting to convict on something. Not sure. I mean, if they're willing to hang on OUI, don't know if they are. I mean, Bev is right about that, to the extent that is just hypothetical at this point. But God, imagine if they hung on OUI, you know how badly some people are going to just refuse to find her guilty of anything at all. How strongly against the Commonwealth's case you have to feel to hang on OUI on this case. That's wild. This made me wonder if that's what some of the jurors are thinking. If that's, they wanted clarity on, is that even on the table? And Bev's not going to take it off the table. A second here, guys. Oh, pardon me. So Bev's not going to take it off the table. Hank was willing to take it off the table, but Bev wasn't going to give it to him. Oh, I'd love to know what was going to happen here. If Hank had taken it off the table, then that's going to be the end for anybody who's like, well, defense tried to say maybe she went home and drank. She wouldn't testify to say that, but the defense wants that. Well, then you got to hold it against her at 5. It would take that right off the table if you can't consider 5 at all. But they didn't. So maybe this is some of the reasoning behind it. We're talking about her dropping off John outside 34 Fairview in that whole time frame, and whether that was a criminal act. Suddenly we're going to be policing the next morning. That's never been an issue. I don't know. Joe Flipperhead, let's finish this thing. Thanks for the amazing coverage throughout, Andrea. The best coverage, hands down. Go Phils, go Phils, go Phils. Let's keep beating the shit out of Miami, because why not? It's fun. We'll do it again today. Oh, let's get it done. Let's finish this thing. I like the time frame. You know, Tuesday today was really my kind of preferred date for something to happen one way or the other. It just makes sense to me with the length of this trial. You're going to take a day just to be like, holy shit, do you remember when Dr. Lapacetta said, and then when, you know, they're going to have to do their recap. Remember what stood out to you and all that. Wasn't necessarily expecting, like, as soon as we get in on Tuesday, they're going to start having issues with filling out the verdict form on count 2. But you know, today seems reasonable. Today seems like a decent expectation that something is going to happen one way or the other. If they're going to hang on count 2, then I don't think we'll get an answer to that today. But that would probably play out over tomorrow. Just hypothetically, if they don't come back after lunch and we've got a verdict, okay, we got it figured out. If they're gonna hang, if they're gonna hang on count 2, I don't know if they'd let the court know by the end of the day or not. I really don't. Don't know if they would know by the end of the day. Thanks, Joe. Thanks for being here with us. It's been a good run. It's been a good fun experience. But yeah, we are ready for there to just be some finality. Okay. I don't want to watch this trial again. Nobody wants to watch this trial again. Even Bev doesn't want to do this trial again. Even Bev doesn't want to do the trial again. Ed 2276, she answered their if question on if they convict for OUI, will that also be a conviction for manslaughter? Why can't she answer this if question? Yeah, I caught the same thing. These are both hypotheticals. These are just pure questions of law. How does the law apply in this abstract situation? Does convicting on a subcharge, for example, not like for real, is a hypothetical. For example, the OUI, does that convict on the overall charge? How is that not a hypothetical under the same standard? I don't know. That's why it makes sense to me what AJ was saying, as far as it's very possible that resolving this verdict form, making that clearer, would have answered their questions about the rest of this. That it would make that clearer. You're acquitting on these as you move on to the next one. You don't even move on to the next one until you've acquitted. They don't like the explicit acquittal. It is, in fact, an explicit acquittal. There's really nothing wrong with that. If the defense wants it to be that strong, if anything, I would think that language would tend to like discourage the jury. Just in general, it's an acquittal. We're like affirmatively finding something, because it could just be we're not convinced. Jurors aren't thinking like lawyers back there. They're just thinking, well, I'm not convinced. Well, that means you're acquitting. That's equivalent to not guilty. Prosecution has not met its burden of proof beyond a reasonable doubt. But people just think a not guilty finding is like something affirmative. It's more than just, well, I have some doubts. I think most people tend to think not guilty means she didn't do it. She's innocent. She didn't do it. I would love to know the distinction, if any, in her mind between why that is not a hypothetical question, but if we find her not guilty on 2, but can't agree on 1 count, is it a hung jury on all or just on 1? Why are we saying that's hypothetical? Seems fairly specific. Ever age, if guilty only on OUI, can the defense still appeal all of the issues that came up in pre-trial? Yeah, they can. They still have all the same legal issues. The question is just going to be what effect, if any, does that have on harmless error? Because did it affect the ultimate decision making on OUI? You know, Michael Easter, for example. Michael Easter, if this is an issue, Michael Easter didn't testify. It's still an issue. It's still a legal problem. I saw some folks mention that it's possible that his report is in fact in the record, that it's just impounded, so we the public can't see it. That would be good from a making a record standpoint, and it does make sense that that would have happened at some point. So let's say, you know, we've got a good record and we can show here's all the things he would have testified to and the effect that it would have had on the failure to follow procedure in this particular case. Is that going to affect the jury's consideration of the OUI? Well, it might, because if we're concerned about the time frame of the blood draw and what we can infer about her driving at the time, yeah, maybe it would. Maybe it would if I don't know. Just for some reason, the credibility of the process, or like the importance of following policy or something like that, you know, could have affected the jury's consideration on the fact that this wasn't even processed like a DUI. You know, don't forget that this wasn't even, nobody arrested her for DUI at the time, at the morning. Nobody did FSTs. Nobody did anything like that. Of course, she didn't drive to 34 Fairview, but even later on when she's at the hospital, none of this was DUI related. This was clinical. This was because she's there for treatment. She's there for medical. She's there for psychiatric assessment and medical treatment. So not following DUI procedure have some bearing. I mean, maybe I could see that, but I could also see, you know, no, it doesn't. It doesn't really affect anything, because the evidence is from the blood draw and the retrograde extrapolation, the serum, serum conversion and the retrograde extrapolation. Those aren't done by Michael Proctor or anybody else that's wearing a law enforcement uniform. It's done by the science people, the guy at the hospital who's unrelated to any of this, and then the person up at the crime lab who does math. You know, so would Proctor's credibility, for example, or Yuri's credibility, the police's interest in like throwing the investigation, would that necessarily like automatically lead to a different conclusion on the OUI? Not necessarily. So I think that's how they relate. You'd still have a lot of the same issues. It's just, do they contribute to this particular error, or does it, you know, go more to some other part of the case? Distractible Hermes. Can't answer means can't answer ever yet. Can't answer that. I can't answer that. Don't ask that. How dare you ask that, you peons? Know your place. Know your place. Do your job. Put the guilty where it belongs. I'm still waiting to see if, because I'm, you know, they haven't told the jury yet that they can't answer that question. You guys, how dare you? So I'm assuming we're just waiting to bring everybody in after lunch so we can tell the jury that, and then they can continue. But I don't really know. I'm waiting to go back to finish our recap from this morning. We've gone through the consultation on the jury's question. We heard the jury's question. We paused. We had the conference on what the response to the jury question is going to be. We paused again. And next, the jury is going to come back and they're going to be given the instructions but we haven't watched that yet. And I don't want to move over to that right now in case they decide to go live. So we'll wait and see. Can't answer that. Duncan, Idaho. AJ just needs to request the opposite of what the defense actually wants. Then Brennan will request the opposite and Bev will rule in that direction. You got to get into the psychological warfare, apparently. Just go ahead and, I mean, gosh, they almost, maybe they almost got there with the time of the DUI, Anybody think of a better, more coherent reason why anybody on the jury would be concerned with a possible DUI at 5 o'clock if it wasn't that there are plenty of people on the jury that are not going to be convinced that at 12:45 the Commonwealth has proven that she drove over the influence, but there are jurors who want to hold her responsible for something. They want to punish her for something, for not being perfect, get her accountability. And so, okay, but what about 5? Defense said maybe she went home and drank. And that's why she's not guilty at 12:45. But what about at 5? Then she would have been guilty at 5. It seems plausible to me. If that is the case, then they almost got there. They almost got there by getting Hank to walk into that. I'll just elect the 12:45 time frame. But Bev wouldn't go along with that. Bev wouldn't go along with that. So maybe she saw it the same way. No, I'm not going to take that off the table. If they're limited to 12:45, they might not convict her. What are you doing, Hank? We can't do that. Levels to the psychological warfare, I think. Camille Barclay, she knows it's going not guilty, so she's playing for a hung jury. I honestly don't get that. I really don't. I think Bev wants it done too, but she just wants it done with the OUI guilty. She also wants Karen to have to suffer some consequence, right? It's much easier to victim blame when we can say, here she was not being perfect. The fact that the state has, framed her, lied about her, abused her with this process, this criminal process. Well, it's at least a little bit her fault, isn't it? Because she did that whole OUI thing. That's what Bev wants. That's how I see it. I don't think she wants a hung jury. She doesn't want to do this again any more than anybody else. Maybe called her dare a little bit. Carla Zambujo. Whatever happened to telling the jury I'm here to teach you about the law, but now I can't explain the law? Right? It's a sudden shift in the demeanor from the court, isn't it? And I do wonder how stuff like that lands with them. Because here she has been so smiley and solicitous, and I hope you're comfortable, jurors, and you've been working so hard, and we appreciate you so much, and we're sorry for the delays, and you have to take the legal instructions from me. I'm the sole source on the law. Ask your questions to me, submit them to the bailiff. They'll come to me, we'll confer. But now you can't ask that. I'm not answering that. What's the matter with you? It's like it is a real shift from that very friendly, helpful, we just want you to be able to do a job, do it well, to it's kind of hostile to the jury. They have a question. And it's kind of a little bit of a slap response. Can't answer that. Oh, my bad. I gotta wonder, does that shift their perspective on the court, on the process, on the judge, on any of it? I do wonder when they get a response like that. All this time, the court's been acting like we're your friend, we're helpful, we're just here to help. We just want you to do a good job. We're supporting you, appreciating your good work. But you have a question about how to get it done? Fuck you. We're not answering. It's a different look. It's a different look for sure. Edward Foster, she should be getting a phone call from the Chief Justice before she comes back. They probably don't want the case being retried again either. They probably don't want the case being retried again either. Decent chance if it's just OUI, there's no appeal. Because can you? Of course. Do you? How much do you want to throw at it? You know, what's the downside? Yeah, there's the principle. There's the principle. There's always the principle. Some people really do want to take it all the way to the mat for the principle. And we have some indications that Karen might, in fact, be that person. We've seen the case go all the way up on a petition for certiorari, all the way up to the U.S. Supreme Court on very, very long shot odds that it was going to make any progress. Systematically did not make progress going through the system, but she took that on principle all the way to the end. So maybe she would appeal just an OUI, just on the principle. A lot of people wouldn't, you know, just like, look, we're done. I can live with that. Just move on with life. I don't know. Occiput Boner. Bev denied defense verdict slip because it had a spot for not guilty on each. So if they hung on OUI, how could they retry her for manslaughter when they wrote not guilty? So if they hang on OUI, there's no way for them to go in and find her not guilty of the manslaughter and all of the other lesser included. And that's because Massachusetts law doesn't contemplate that they can do that they can piece they can piece the lessers out and acquit on them individually. It's crazy to me that that's how they do it. That's how their law is set up there, but it's very clear from the Commonwealth versus Roth case. We looked at that yesterday on the Defense Diary stream. It was cited in the defense's motion to revise the verdict slip. It's very clear. They contemplate that taking partial verdicts on lesser includeds, you're not supposed to be able to do that. You're supposed to only be able to consider acquittal or conviction, indictment by indictment. So if they hang on the OUI, it means they've hung on all of it. It's not factually the case, but that's the legal presumption. So if they hang on OUI, there's no way under Massachusetts law to carve that out and say she's not guilty of everything else but OUI and only retry her on that. They won't allow it. Pretty wild, huh? This is getting into like we're kind of, you know, I'm mentally revisiting some of the issues from the first trial and the whole issue with the double jeopardy and those challenges and stuff like that. And the problem is it just leaves an awful lot of room. Leaves an awful lot of room for the state to be able to define what constitutes a verdict and have a lot of control over their power to be able to retry you based on that definition. That was the concern I had with the whole double jeopardy jurisprudence when we were looking at those writs and that whole process. Not that the law is wrong. The law was very clearly against Karen, but it's some very bad law when I think about it from a philosophical, kind of a practical standpoint. Doesn't that mean that the legislature, like there has to be some limit where the legislature can't legislate away the power of the jury to return a not guilty verdict? There's got to be a limit there somewhere, but it's really not clear what it is. And all we got through that whole briefing process was just the hint that, you know, at some point there's a constitutional floor, but we have no idea what it is. So it's a messy situation, and Massachusetts seems to have a particularly, I don't know, punitive approach to the lesser includeds that way. Brian Richardson, I hope the jury decides not to hang on OUI and put Karen Reed, O'Keefe's, and another jury through this dog pile of a case. Not guilty ×3. Thanks, Bev. You'll allow it. I really hope so too. Yeah. The more time that goes, the more I feel like if they had just been able to take the 530 off the table, they might be able to do that. That would shut up. That would shut up people that might be pushing for we'll take the defense at their word that she drank after she got home. But that means she was OUI at 5 o'clock. It's not necessary. Again, I think you can get out of that by you don't have the blood proof. But you got her statements. Consider it like any other evidence. Give it what weight you will, whatever weight you choose, if any. TG, when something is this consistently bad, it isn't bad, it's corrupted. At some point, coincidences stop being coincidences, don't they? And they start being circumstantial evidence. And so what point is that? Was it the first time that we learned about evidence mysteriously disappearing, or was it the second or third, or maybe the fourth? What was the point where it turned from coincidental to circumstantial? Delia Martinez, does hung on OUI hang her on all of count 2? It does. Under Massachusetts law, yes, it does. And that's why Bev has been so strident isn't quite the right word, but just insistent about we're not going to give them the option to find her not guilty on the lessers. That's why Commonwealth versus Roth says you don't do that in Massachusetts. You got to consider the entire indictment. And that's what then creates these, for me, perverse incentives to just not present your case to the jury then. Because why would I go get a separate indictment on OUI, present it to the jury if I wanted that conviction? But then that means, if the jury hangs on that, that's the only thing they hang on. If I can just tack on OUI as a lesser included to something else, just go ahead and take that instead. Keeps a lot more doors open. I don't like those incentives at all. I struggle with the grand jury system as it is. It's so foreign to me. It's not how we do things over here in Washington, but it just seems like if that is the point of the grand jury is to have the citizen acting as the check on the prosecutor, I don't know how not having to present the case that you present to the petite jury, the one at a trial here. I don't if that can be something completely different than what you show the grand jury, then how is it a check? I don't understand. Whatever, clever. Looks like they have 3 hours for BAC to be admitted as evidence. If longer than expert is needed for extrapolation, see Commonwealth versus Colturi. Thank you for that. That was the citation, the case that Jeff sent me in the chat. I read a little bit of a summary of that. So it sounds like 1 to 3 is going to be presumed a reasonable time. And if it's other than that, then you have to have the extrapolation. So we do have the extrapolation for the 12:45. We don't have the extrapolation for 5 o'clock. And it would be outside of the 1 to 3 hour window, right? It's 4 hours before blood drawn at 9 o'clock. Talking about her driving at 5 to 5:30, 5:30, was it 5:38 she got to Jen McCabe's? So you're still not within 3 hours of when her blood was drawn. Not that the jury knows any of this anyway, because they haven't been instructed on this particular aspect of the law. So I don't know what this is going to mean, if anything, but it really does. It really does seem like there's just a real holdout for finding her guilty of DUI at 5 o'clock. Gotta get her on something. Some people won't even have that. God, if that's the case and that's the state of this jury, what a judgment. What a judgment on this prosecution. We'll have to check when the court comes back in whenever that happens, we're going to have to check and see how Lally's looking. Is Lally looking a little perked up? A little, little steel in his spine, little nice self-satisfied posture in his chair. He at least got a hung jury. He got a hung jury on all of it. How you doing there, Hank? Thought you were this better lawyer getting paid all these big bucks. You get paid like twice Lally's salary to come in and lose a lot harder. Yeah. But then if Mr. Lally starts and thinks about that too hard, that may not be the win he's thinking it is. Because you didn't even get paid to bomb, did you, Mr. Lally? Teddy Bear 1287. Do you think there's any chance Karen's team is approaching with a plea for OUI right now? Any chance Brennan considers it? I doubt it, because at this point it looks pretty strong that that's the worst case scenario you're going to get from the jury. So let them make that decision. If they're going to impose that, great, let them. It sounds pretty clear. I would be comfortable betting, if I'm a lawyer in this case, we've taken the homicides off the table, and their focus on this charge, the OUI, it seems pretty clear that that's all we're talking about, is does she get OUI or not? So if they're even still having that conversation, I don't know that I'm volunteering, because they could decide not to. They could decide no. And I don't know that she's going to get any particular advantage. What's the advantage going to be? A sentencing recommendation? Maybe. I just think the risk of Bev going too far afield of what the normal practice is for a first-time OUI sentence in her court. Can't say she's not going to do it. Can't say she's not going to do it. But she's not going to go crazy. She's not imposing 2.5 years. Okay. She's not imposing any maximum sentence. Would it be worth the trade-off? What's the worst she could do? Let's say Bev would maybe throw her in jail for 30 days, a month in jail. Would you trade that to have the odds of the jury, the chance for the jury to say, nah, you're not going to do any time. You're not going to even have a conviction. Karen, the same person who, like we just said, on principle, took the entire due process challenge all the way up to the U.S. Supreme Court against very long odds. I don't think she's taken that bet. I don't. I think she's going to go ahead and play it with the jury. See what they deal. Dennis Jensen, haven't had nerves for 2.0, but here for the end. It did seem like throughout 2.0, I really never felt like there was a point where the Commonwealth had a moment where you were like, ooh, I guess she did. I guess she did do it. Ooh, that looks really bad. Oh, maybe she's going to get convicted. I think the closest they got was just at the very conclusion of their case. After Welcher is done with his testimony, you're like, well, I guess it's possible it happened. I guess it's possible. I feel like in the first trial, maybe this is just hindsight bias or whatever, but I feel like in the first trial, there were a few more moments, like distinct moments where it seemed like it looked bad. Like if the jury buys that, if the jury seizes on that, then things are not looking good for Karen. Guys, I'm going to pause for a second because I accidentally forgot to grab my tea. I'm going to go grab it. I will be right back, literally seconds. Okay, much better, much better. So maybe that's just my impression, but I felt like this was a much less rocky ride. And maybe again, that's just perspective. It's because I, already knew what had happened in the first trial, kind of able to forecast what's going to happen this time. But just overall, the presentation of it really never felt like there was a moment where Karen was like, "Ooh, she's on the back foot. She's going to have to come back from that. She's going to have to hope the jury doesn't buy that." Like somehow even the tail light and the search and stuff like that, Hank just couldn't make that stick really. I don't know. Peace Geek 1965, Stacy LeBruno. Andrea, thank you for your amazing trial coverage. Your insight, knowledge, and humor are the best. The chat and your mods are awesome too. Cheers. Cheers, Stacy. Thanks so much for being here with us. It has been fun. It has been a lot of fun. Unfortunately, this part of it, we're kind of all on equal footing as far as being able to interpret what's going on. I can give you my best guess from what I see, but my guess is just a guess, just like anybody else's guess is just a guess. No guarantee that anybody knows, has figured out what's going on in that jury's mind. Even in the court's mind for that matter. Just keep staring at this fan like, are they ever going to tell the jury? Are they ever going to bring him back in and tell them? We're not going to answer that question. Or did she just send it back in writing? Now I'm feeling like she just sent it back in writing. I can't answer that question. Didn't bring him out to do that on the record like you did the first time either. So now we've got a discrepancy too with how their questions are being addressed. The first series of questions, very formal, very respectful. We take it very seriously. The second one, you don't even get to come back to court to get an answer to your face. You're just going to get a piece of paper. Can't answer that. What are you doing wasting my time? Hurry up and find her guilty. Well, I think I might risk at this point, go ahead and going back to our last video to queue up from when they reread the jury and the verdict form, the revised verdict form, just so that we can watch that when it, watch what happened back earlier today and react to it. Because guys, there was actually some good stuff in there. I've been like afraid to pull away, but it doesn't look like they're bringing the jury back in at this point. So I'm going to go ahead and risk it and switch us over to where we are queued up. And I'll just keep an eye on the fan in the background here. Oops. Are we in the right place? Yes, we are. Let's go. Watch the jury.
All right, so we can bring the jurors over. Tori, do you have those? Oh, so Tony will take those. All right.
Remember,
so,
it's going to take her 5 minutes.
all
right?
so thank you.
She's got to get back. She's got to make the edit. She's got to incorporate stuff, and she's up there busily writing on the bench what she's gonna say. But just generally, because we're not going to commit to an actual script that we'll write down and then stick to. So I will switch my banner. Been waiting for that reaction to the second question. That doesn't look like we're going to get one. Yep, if you just joined, my bad. Sorry, should have been clear. This is not live. This is rewatching what happened earlier today. So we have already watched the announcement of the question and then the conference with the attorneys on what the responses should be the discussion about it. Bev like, no, how dare you, defense, propose things. Of course, I'm not going to do it that way. Hank seemingly maybe offering to shoot himself in the foot, but Bev not allowing it, forcing the possibility of a 5 o'clock DUI to stay on the table with the jury. And now we're just watching the part where the jury comes back in and she gives them some instructions. Is it what she wrote down and told the parties? Not exactly. She doesn't do that, guys. For whatever reason, she won't be told. She won't be held to what's in writing. She will get up and wing it. I guess I should have just queued it up to the the other part, but I didn't remember where the hot mic moment was, guys. I had to get that hot mic moment. Sounded like AJ saying, "I can't do this again, Roth. I can't do this again, Bob." But we don't know what he was talking about. Whether it was him nicely telling Mr. Alessi, "Go away, don't bother me right now. I have work to do on this thing," because that's what he then does. He proceeds to write stuff down on his notebook while Mr. Alessi confers with the other parts of the team, or if he's saying something deeper and more ontological about life in this trial. Can't do this again.
All right, jurors, we're in receipt of your question. We've been working on making sure that the answers we give you are the right ones, so it's taken us a while. So the first question, what is the time frame for the OUI charge? Offense 002, Section 5, OUI at 12:45 or OUI at 5 a.m.? The answer to that question is that you folks have all the evidence. And remember, it's only you who decide the facts in this case. All right, that's the answer to that question. You are the fact finders. The second question, are video clips of Karen's interviews evidence? How can we consider them? Yes, the videos are evidence. You should weigh the defendant's statements in the videos as you would any other piece of evidence and give them whatever weight you deem appropriate. But first, before you may consider any such statement, you're going to have to make a preliminary determination whether it can be considered as evidence. You may not consider any such statement in your deliberations for the truth of any such statement unless, from all the evidence in the case, the Commonwealth has proven beyond a reasonable doubt that the defendant made the statement that she's alleged to have made and that she made it voluntarily, freely, and rationally.
This
So
is a
that's
good
the
question.
answer to that question.
We need that again.
So for the third question, does convicting guilty on a subcharge, example offense 2, number 5, convict the overall charge? So with that, what I'm going to do is I have amended the verdict slip. It's the exact same verdict slip, and it's still consistent with the jury instructions I gave you, but it's a little bit easier for you to follow. And for purposes of going through this, we'll go through it together. And I've got a copy for each one of you, okay?
It's still consistent and it's exactly the same, but obviously it's not. But easier to follow because you just put it all on one piece of paper.
All right, so you'll see it really is the same verdict slip, but we've added a little bit of language to help you follow it through. So the first charge, manslaughter while operating a motor vehicle under the influence of liquor. So first, in the above entitled case, we say the defendant is 1, not guilty of the offense charged or any lesser included offense. If you find the defendant not guilty of the offense charged or any lesser included offense, stop and sign the verdict slip. Now, then you go on to guilty of the offense of as charged, manslaughter while operating a motor vehicle under the influence of liquor. Check one or both of the following: manslaughter while operating a motor vehicle under the influence of liquor and or manslaughter while operating a motor vehicle with a blood alcohol level of 0.08 or greater. If you find the defendant guilty of manslaughter while operating a motor vehicle under the influence of liquor, stop and sign the verdict slip. That means on each one, when you stop and sign the verdict slip, that means you have a verdict on this indictment. So stop and sign the verdict slip. If you find her not guilty of manslaughter while operating a motor vehicle under the influence of liquor, then continue below to the lesser included offense. And first under 3 is involuntary manslaughter. If you find the defendant guilty of the lesser included offense of involuntary manslaughter, stop and sign the verdict slip. If you find her not guilty of involuntary manslaughter, then continue to the next page. Guilty of the lesser included offense of motor vehicle homicide, felony OUI liquor, and negligence. And you have to check one or both of the following: motor vehicle homicide under the influence of liquor and or motor vehicle homicide by operating a motor vehicle with a blood alcohol level of 0.08 or greater. If you find the defendant guilty of the lesser included offense of motor vehicle homicide, felony OUI liquor, and negligence, stop and sign the verdict slip. If you find her not guilty of motor vehicle homicide under the influence of liquor, then continue below to the guilty of the lesser included offense operating under the influence. And you check one or both of the following: operating a motor vehicle under the influence of liquor and or operating a motor vehicle with a blood alcohol level of 0.08 or greater. If you find the defendant guilty of operating a motor vehicle under the influence of liquor, then stop. If you find the defendant guilty, you stop and you sign the verdict slip. If you find the defendant not guilty on this offense and all other offenses, check the first box on page 1. And remember, your decision must be unanimous. All right, does that make it any clearer, hopefully? All right, so with that, I am going to send you back out.
Before the jurors is sent,
Really
Sure, why don't you
supposed
come on
to
over?
ask. Not really supposed to ask them. Does that make it clear? What are you going to do if you get a response? Make it clear, hopefully. She's looking for like nods and reactions and stuff like that. It's not on the record. What are we to make of that? Don't know. I felt like that walking through the verdict slip was not necessarily more helpful, and in part because the whole choose one or both of
I heard myself say this, and I'm glad counsel told me I did. So if you go back and look at the form after 4, if you find the defendant guilty of the lesser included offense of motor vehicle homicide, felony OUI liquor, and negligence, stop and sign the verdict slip. If you find her not guilty of motor vehicle homicide under the influence of liquor, then continue below. I think I said then find, I don't know what I said. I heard myself read the guilty
you said
of the
then
lesser included offense. So if you find her not guilty of motor vehicle homicide under the influence of liquor, then you continue to decide whether the Commonwealth has proven to you beyond a reasonable doubt that she's guilty of operating under the influence of liquor. And if they have not, and if you find the defendant not guilty on this offense and all other offenses, then you go back and check the first box. So you follow it from the top to the bottom in this manner. Okay? Thank you very much. We're going to release you.
All right, to the court, please. Jurors, follow me.
So that was that. That was the last we heard from the jury in there. She did, guys. She's like, if you find her not guilty of motor vehicle homicide, continue to guilty of the lesser included OUI. She's like, just go ahead and go find her guilty of OUI, guys. Just go ahead and do that. Get that done. It's because that's how the verdict form is written. Her description of how to go through the form. Now, I don't have the form in front of me. Okay, so, but I remember part of the issue here is you have the involuntary manslaughter, for example, the lesser of, it's got two ways that it can be proven. And so they have to choose which one, or both, but they have to choose at least one of them if they convict her. But they don't explain that in any of the instruction, nor do they even tell you, here's how to mark the verdict form to indicate what you've decided. She says, stop and sign the verdict slip. Stop and sign. No, you need to indicate on the verdict slip if you found her guilty of anything. You need to indicate on the verdict slip which one you're finding her guilty of. And if it's one of these ones that has sub-elements, you have to indicate that too. So she like never tells them that. This remains super confusing. By the way, remember before, her oral instructions take precedence over what they have in writing? And so it could be perfectly clear on the verdict form. But she said in court, just stop and don't put a G on it. Don't put a check mark anywhere. She said, if you find her guilty, stop and sign it. If they stop and sign it without indicating, it's hung. That would be confusing. It would be unclear. It would be hung if you haven't indicated what your verdict is. She says you start with the manslaughter if you find her. So confusing how she goes through this. We've added a little bit of language to help. Have you helped? Have you helped? Start with the first charge of manslaughter. 1, if you find her not guilty of the charge or any lesser included, then stop and sign the verdict slip. Part of the reason why this is so awkward is because you put not guilty as the first option, but the way that you work through the charge, it's really the last one that you come to. Because you have to find her not guilty of everything to find her not guilty. That's the Massachusetts law. That's the Roth case. That's how you want it. You have to find her not guilty of everything to find her not guilty. So you have to rule out a guilty on any of the charges. So what you do is you start with the greater and you work through each of the lessers. This is not rocket science. I don't know why it seems like they're having such a hard time just explaining to the jury. Here's how you fill it out. Here's your process. It's pretty straightforward. Start with manslaughter. She did it. Check that box. Sign it. You're done. She didn't do it. Move on to the next one. How hard is that? And once you've moved through all of them and you decided she hasn't committed any of those, then you find her not guilty and you check that box. I don't know why this is got to be so complicated. So start with manslaughter and first go to not guilty of the charge. If you find that she's not guilty of the charge or any lesser included, then stop and sign the verdict slip. Then go to guilty of one or both, the 0.08 or the under the influence. When you stop and sign on each one, when you stop and sign, it means you have a verdict. What if their verdict is not guilty? If they're like, but wait, we got through We got through manslaughter and our verdict is not guilty. But you just said stop and sign to say I have a verdict. So I'm going to stop and sign. There's nowhere for me to put guilty, put not guilty. I don't think this was particularly helpful. I really don't. I have to hope. I haven't seen the verdict, the amended verdict form yet. Will it make more sense than what she just read, what she just told them in court? I don't know. And then because she has to wing it and can't just read a script, she tells them, if you find her not guilty of motor vehicle homicide, continue to guilty of the lesser included OUI. Just continue to guilty. That's all. Go ahead and go straight down to guilty. Now, I don't think that's what she meant. I think the problem is she was reading the form, and the form only indicates guilty. That's the only place there is on the form. Visually, it's the only place to go next. That's the bottom of the form because of how you have written this form. That's why she said it. Is there a little subconscious thing going on? Who knows? Maybe. But I think that's really what she was doing. She's reading her form, and the form said there's only one option here. It says guilty. So that's where you go to next. Go to the guilty form. She's like, I don't even know what I said. Well, yeah, and that's a problem, isn't it, Bev? Because if you just wrote down a script and then you read it, there wouldn't be any question about what you said. You would have said what you wrote, what you already disclosed to the parties and had your conversation about and made your record about, as far as, is that okay or not, as far as a response. And then you would just read it verbatim and not have to sit and wonder, what did I say? Did I say? Proceed to find her guilty? Yeah, I mean, one could hear it that way if they wanted to. I don't know what I said. That sums up the problem, doesn't it? You don't know what you said. There's really no reason why you shouldn't know what you said. But yep. We are just waiting for the court to resume at this point. So go ahead and clarify that for anybody new that's coming along. Yeah, guys, I'm still just watching the fan, seeing what happens. Ian Thomas says, sorry to taint your passion, Andrea, but currently thinking not bonsai, but bev size. You're not ready to be done with bev size yet? You're not ready to be done? I'll be happy if I never get another bev sci ever again. I would be perfectly happy with that. It would be not a day too soon. Oh man, it's like, it just really speaks to the human dopamine system, doesn't it? That what will get us reacting, what we can crave. Imagine having that deep craving for a bev sci. No, thank you. Not me, not here. Jeffrey B, anticipating an imminent verdict. So just wanted to take the opportunity to thank you for being here every step of the way, sharing your wisdom and bringing clarity to all of this. As someone that grew up in Norfolk County, this entire situation is so disheartening. I can't imagine what it feels like to be part of this community and seeing it outed like this, on a national stage. It's pretty disgraceful, I'm not saying it's Norfolk County people's fault. There's a lot of levels to what is happening here and where the responsibility lies and so on and so forth. Norfolk County doesn't control the MSP. Their shady stuff, what they're willing to do, their culture. Definitely can't hold Norfolk County responsible for that. But you guys are going to have an opportunity to consider some accountability for one of the major driving forces behind what we've witnessed here, and that is Michael Morrissey. Just think about those headlines after this this trial is done, dusted in the rearview mirror. That might be a nice epilogue. A story about Norfolk County. Just putting that out there. It might give us all a little bit of a warm, fuzzy feeling down the road. Oh yeah, Norfolk County. Remember that was that place. That was that place where they framed that girl. Framed that girl. Tried to pretend like she hit her boyfriend with a car, but he didn't have an injury on him. He was just beat up. He was just like really obviously beat up and hucked on the front lawn and left. They tried to blame it on her, but hey, they voted out the guy that charged it. That would be a good epilogue. Wouldn't that make us feel good? Appreciate you being here with us, Jeffrey. Bino, thanks for going live. Looks like a verdict today. It's positive signs for a verdict, isn't it? I think the question is just going to be that OUI. Are there people that are so hung up on we're not going to convict her of anything at all? They would rather hang on the OUI than just say, fine, we'll convict her of that and go home and not have to come back tomorrow. I think that's the question that we have right now. It's 3:30. They got hour left, maybe 2 hours. Time is getting short. Time is getting short. So that just really seems to be the question that they're facing right now. Come back tomorrow to talk some more, hang out on DUI, or go ahead and just cave and say, we'll give her that petty misdemeanor and call it done. They certainly didn't get the assurance that it seemed like they were looking for. That if we can't make a decision on that, does it put the whole case in jeopardy? Does it rule out us being able to give verdicts on what we can decide? They didn't get any kind of guidance on that. So if they are worried about kicking this down the can to the next jury that gets screwed over, then they're going to really want to make a decision. And if they really want to make a decision, yeah, just, some of it might just depend on who is more dug in, but also just which is the easier position to concede. To me, it seems like the easier position to concede is, yeah, okay, Karen probably drove drunk. She probably drove drunk at some point. Should she be convicted for that? Probably not. I don't know. Looking good, but that is going to be the $1 million question. Are we going to come back tomorrow so that they can horse trade some more over OUI? I mean, just wild that should even be an issue, hanging them up after all this with a manslaughter charge. The Commonwealth can't even convince them 2 days to come back with just at least OUI. Remember, Hank didn't even want him in the first place. Wild. If she hadn't given him, guess we'd probably be done. Melinderp, based on these jury questions, this is how I expect and hope a deliberating jury would think. Refreshing. I was surprised. I was very surprised by that second DUI, the second act. Hadn't even thought of that. That was hadn't even crossed my mind. Maybe we would convict her for the next morning. Shows that they are being very careful and very detailed and very thorough, considering it from all angles. They found an angle that I don't think had occurred to most of us who've been watching this case for years. How seriously do we have to take Karen's statements, the video clips? As seriously as you want to. That could be a sticking point as well. Some people are like, hey, talk is cheap. Some people are like, oh, but she admitted, she went on TV and she said, even she says. Then the concern about what does it mean? What does it mean if we convict on the OUI? Hopefully that's clearer. I don't know that I see any big problem with making it as explicit as Alan Jackson wanted to be. You are necessarily acquitting her of manslaughter and involuntary manslaughter and motor vehicle homicide if you find her guilty of OUI. You are necessarily acquitting her of those. He didn't say necessarily, he said explicitly. The same thing, really, in this situation. You have to. It's how the instructions tell you to do it. Consider this one not guilty, move on to the next one. Move through the list. And if you get through the whole list and she's not guilty of any of them, then you check the not guilty box. For some reason, it's got to be really hard to walk them through that. So yeah, it does seem like they are focused on at least the stuff that seems arguable. Unlike whether there was a motor vehicle collision, which seems to not be taking up a lot of mental space back there in the jury room. Whether she was driving drunk at any point in time, whether they have the power to convict, depending on how they see it, what they can rely on, and what are the consequences if they don't agree. They're thoughtful questions, at least. Colette Keenan, confused what they are stuck on. Can you explain the charge? It just sounds very much like they are stuck on OUI and they don't have unanimity, first of all, on whether they would convict her or not of that. Okay, Commonwealth, it seems, has failed to convince the jury even that Karen drove drunk on January the 29th, let alone killing. They haven't even convinced the jury unanimously that she drove drunk. Okay, so we've got dispute over that and whether they're even going to convict her of that. It's what it seems like. But they're concerned about if we can't resolve it, what does that mean? What does that mean for a future jury? Are we setting up another group of people to have to come in and give up their 8 weeks of their lives again to reach the same position that we're in right now? They want to know what's going to happen if we can't decide whether to convict her on OUI or not. We're not going to answer that. We're just going to revise the verdict form and let that speak for itself. Otherwise, we're not going to answer that. So hopefully that clarifies it. It seems like they've taken homicide off the table. All that we're focused on is OUI. And that's the crux of the dispute. Has the Commonwealth even managed to prove that she's guilty of OUI? What a long distance this case has fallen from the glorious heights of murder 2 all the way down with we're not even sure she drove drunk. Yikes. Nikki Cadia, can't wait for you to cover Koberger. I tried to watch alone without you, but I got lonely. I have to have your snark and commentary like Hank Thrust lol mentioned on Defense Diaries. Well, I don't know if we're going to get those moments like that over there in Koberger. They don't just a different character, different vibe over there in that courtroom. Very different judge. Still very prosecution friendly, but not one that we would accuse of not being in control of his courtroom. You notice how even with something as basic as who is speaking first, Bev won't take charge of the damn courtroom. Well, just whatever you guys, why don't you just say you're standing? So they're inviting you, Bev, literally inviting you to take charge of the process. You don't want to, but then you do, you know. Like we want to pretend like we're doing it the way that you guys want, but we're going to actually end up doing it the way that I want to do anyway. Because as soon as you make a suggestion, I'm just going to be like, no, 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 we can't possibly do that. Coburger is going to be intense, guys. It's going to be intense. Very horrible, horrible crime. Very slim evidence. A lot of feelings about it. A lot of prejudice. So much extrajudicial gossip kind of stuff. A lot of poisoning of the well in that regard, where I could easily see a situation where the evidence gets vetted in court. It's very, very strong, or it's very weak, very, very marginal circumstantial case at best. But you'd have, a bunch of people who've heard all kinds of stuff outside of the court process. Well, but remember when he was sitting at the kitchen table sorting the garbage with his gloves on, Remember when he did a weird thing in school? What was the neighbor thing? The thing with the neighbor? I don't remember. I don't follow the gossip stuff. If it's evidence, it'll come out in court. If it's not evidence, then doesn't always mean it's not valid, shouldn't be considered, but does mean it's not going to influence the verdict, the jury, and the outcome. At least it's not supposed to. So that is going to be quite a trial to watch. Still sorting out what my format is going to be for that one, but at least initially for jury selection, I do plan to be there. See what I can see. Skylar K, will amended verdict slip further delay jury? It could, because now they gotta walk through it. She says they didn't change it significantly. So imagine a situation where they've started to fill it out, but now it's changed. As long as it's pretty close to the same, it shouldn't be hard for them to have to go in and redo that. But yeah, it could. The negotiating how to fill out the verdict slip, given how you've answered these questions, seems to be that's the main thing left to resolve. What does it mean? Seems like it should just be as simple as did she OUI or not? Has the Commonwealth proven it or not? That should be the issue they have to focus on. But it can never be that simple. It can never be that simple. Apparently, they need to also have to have some negotiations about what does this form even mean? And how do we fill it out? And I can imagine a situation back there arguing. She said if there's a verdict that we sign it to indicate, but the verdict is not guilty, but there's nowhere to put that on the box. I could just I could see, yes, there being ongoing concerns and negotiations about how you even fill this thing out if we have reached an agreement in principle on how all the charges are going to be resolved. Lindsay from Sue O. Per Karen, the fourth question came in before they answered the other three, not after. Can you explain why the judge didn't answer all together? It's not super uncommon for that to happen. The jury is still back in the deliberation room. They're doing pretty much whatever they want to do while the court is coming into session to deal with the questions. I've seen situations where they send out a question, but then before the court has even figured out how to answer it, they've reached a verdict. Like they were able to either answer it themselves or decide they didn't care about the answer that much anyway. And so it just sort of moots, the need to be able to answer that. So it's not uncommon for them to continue working while the court is, in session dealing with an earlier question. Why didn't they handle it all at once? It could just be a timing issue. You saw the process. The process is generally advise the attorneys of what it is. Okay, so make the record. Here it is. Here's what the jury has said. Give you some time to chat amongst yourselves about what you think the appropriate response is. Have the hearing on what the appropriate response is, and then either write it down and send it back, or bring the jury back in and give them the response verbally. Doesn't it kind of seem like it's just, I don't like the optics of this first set of questions are really important. So we'll bring you back into the jury room to explain our answers to you in open court and read them to you in person, hear our voices, etc. Versus we're just going to send back a slip of paper telling you, don't ask that. I don't like the optics on that. Doesn't that seem really strongly like it's signifying that your first question is really important and your second one, it's trash. It's trash. I don't like that. But anyway, it could just be timing. It's come in too late in the process. They've already gotten down the road of like, how are we going to respond to question number 3 before they've really registered that question number 4 has come in. I don't know. Just could be an issue of we're going to take things systematically one at a time. We got this question first. We're dealing with this question. We'll finish dealing with that question before we turn to something new. Maybe. Now, if instead of another question, it had been, we have a verdict, would you be treating it with that same, I can wait? Probably not. Probably not. So all I can tell you is the explanation that makes the most sense to me is just timing. Timing wise, it didn't work. It came in later after they had already started working out how they're going to respond to 1, 2, and 3. So they just decided to get through that first before dealing with 4. But I don't know. It's really just a guess. Summertime. Apparently it's a crime to go out drinking with a bunch of cops and then drive to drop off your drunk cop boyfriend at the other drunk cop's house. Ha ha. I have to wonder if that's why there would be people on the jury who are like, absolutely not on my watch. No way are we convicting her of OUI under these circumstances. When all of these people were out driving, and these are cops, by the way, they've been out drinking all night, driving around. They're fine with her driving. They didn't have an issue with it then. Why should I? It wouldn't surprise me at all. Not every jury is going to be okay with the idea that, some of these animals are more equal than the other ones. So don't concern yourselves with them getting off scot-free and no consequences at all. Just worry about Karen. Some people aren't gonna be okay with that. Bird, Sue O'Connell is reporting this last question actually came in before the other 3. Oh, I see. Before the other 3? She did say they came in on note cards, and I don't know what order they came in, but it seemed like she was saying the 3 came in on note cards and she didn't know, but then like the 4th came in after? Or are you saying the 4th came in first and they just overlooked it? I am not sure. I am not sure about that. If we find her not guilty on 2 but can't agree on 1, is it a hung jury on all or just on 1? I could see that being possible. That first they ask a question about if they can't resolve it, but then they're continuing to wait and continuing to try to resolve it, and they're looking for guidance on these sticking points that they have that might help them resolve it. What time frame? What do we consider? Does that mean we're saying somehow she committed manslaughter or something? I could see that being possible. I mean, there's a logic to it, but I don't really know. Sabina D, if I were a juror, I wouldn't cave on that OUI just on principle, since they had cops doing that. So why should she be the only one to be punished? She can't be the only, you can't be the only one that's thinking like this. It does seem like that's not an unreasonable response for somebody that's sitting on the jury. And in a case that especially has been highlighting how the cops are special, they're better than all of us. We're just here to take their word for it, and they're going to do what they want to do. And if what they want to do is, make sure the girl is fucked, bring some serious charges on her, don't worry about the homeowner. He's a Boston cop too. You've already seen a case that's focused on the imbalance when it comes to justice and how much power law enforcement has to decide who's going to suffer consequences and who isn't. And a lot of people aren't going to be cool with that. So I can't think you're the only person that is having this kind of reaction to it. AK, in general, does it reflect negative on a judge when a jury hangs? If it does, do you think Bev would rather have a not guilty verdict than a mistrial? I don't think it particularly reflects negatively on the judge, because it's largely out of the judge's control. She doesn't decide what the evidence is. She doesn't decide what the charges are. She's got her sphere of what she can influence. So I suppose in this situation, if it was her decision to give all of these lesser includeds, because I still haven't been able to pinpoint, pretty confident that the Commonwealth was like, we don't want the lessers, but not clear to me that David Yannetti requested it. But if he did, then forget it. But if he did not, and this was all Bev's idea, then perhaps that would, you have to take responsibility for what you had agency over. And if you had agency over trying to throw something so petty and minimal at them that they might bite just to get done, just to get some kind of pound of flesh, then if that doesn't work and that causes them to hang, then you would bear some responsibility for that. But legal responsibility, absolutely not. But even just moral responsibility, doubtful. The issue is the case isn't strong, and that's not a reflection of her. God, she bent over backwards to give them every possible opportunity and advantage that she could. Hank Brennan still couldn't accept those gifts. He still had to keep giving them away. But I do think she would rather have a not guilty verdict than a mistrial, because I think she just wants this done. I really do. I think she just wants it done. I think her preference is convict on OUI. Just convict on OUI. Make it easy. But that way Karen Reed gets to suffer something. There's some slight vindication of the Commonwealth. It's not a complete and total rebuke of you absolutely wasted our time and our attention and the resources of the county over the last several weeks. It makes it sound like, well, it's justified because she did commit the OUI, That's what I think she wants. It's just that little bit of saving face is fine. But if it's between hung and a not guilty, I think Bev wants it to be done. She doesn't want to do this again, guys. the attrition strategy. It's not just working. It's not just Brennan working that against the defense. Okay. Bev is ready to be done. This has already made her work a lot harder than I think her preference would be. So nope, I think she would rather have it done definitively one way or another than have to do it again. Joss Girl, someone on X said, ask it differently, Mr. Foreman. Bravo. Ask it differently. Just bring the jury in, sit them down in the box and say, jurors, I've received your question. If we find her not guilty on 2 charges, but can't agree on 1 charge, is it a hung jury on all or just on 1? And jurors, I would ask you, can you answer that? Can you answer that? I can't answer that. MK, Mark Betterow says he disagrees with defense adding the OUI. Bev denied Karen having him on her team. Does this help on appeal if convicted on OUI? No, it won't matter. Strategy is strategy. If anything, this is like kind of underscoring that if the request for the OUI lesser came from the defense, that was a strategic decision. Strategic decisions are, they're extremely well insulated from challenges that there's ineffectiveness, that was a wrong decision. They get broad leeway to decide strategically what makes sense, and whether to go all or nothing on a charge is classic strategy, classic trial strategy, because there's no right answer. It's just a judgment call that you make based on how you've seen the trial go, your read on the jury, the risk, your client's risk tolerance, all of these types of things will go into that calculation. So no, it really, they're insulated from ineffective assistance because it's a strategic decision. God, I was thinking something else, but I just lost it. Does it help on appeal if convicted on OUI? No, it really wouldn't. The other piece of this is just that, the issue of Betterow being denied, like, it's already about as strong as it gets. You don't have to show an outcome. You don't have to show it would have been different if Betterow was on the team. Like, that's already written out of the analysis because it's presumed he would contribute to the team and that they would, probably do some things differently. It would be a different trial. Why? Because you have a different attorney involved, and Karen has the right to choose which attorneys she wants involved in her defense. So they don't look at what are the consequences from that if they're deciding whether it's an error or not. It's already an extremely strong issue. So yeah, I don't know who made the decision or what exactly. But I'm not going to agree with it or disagree with it. I get the logic. I really do. All I find strange about it is just if you're not going to go with that, go all in on it, jury, go ahead and find her guilty of OUI and go home. Make it that simple. Then why would you even ask for it? I don't know. Don't have answers for a lot of this stuff. It's just, we'd just be guessing. But I see the logic of that defense. Doesn't that make it easy? If we really don't want to do this again for the 3rd time, you really want to find her guilty of something, fine. Give her the OUI. Should take you half an hour to figure out there was no collision. Go ahead and find her guilty of OUI, and then just go home. Make it easy. If you're gonna follow that strategy, just lean all in on it. John BD Bot, I think Bev vibes as if she wants a hang on OUI to keep the 2nd count viable for a trial 3 with significant risk of serious jail time for Karen Reed. It is possible. I mean, you know, we're all going to have different reads on what's happening. Oh, looks like they are going back into court, guys. Something going on. It's 10 minutes to 4, so it would be early to be dismissing them for the day, but we haven't had any news of why they are coming back.
Put us back in session in 8, seated.
All right, jurors, I know you want to go home, so
Oh, boy.
it's been a long day for everybody. I have to give you those same cautions. Please do not discuss this case with anyone. Do not do any independent research or investigation into the case. If you happen to see, hear, or read anything about this case, please disregard it and let us know. Be careful with your social media use. We know you've all been working really hard and we appreciate it. So please just clear your heads. Don't think about this case at all as best you can. And we'll see you tomorrow morning when everybody's fresh to start again. Thank you.
All rise for the court, please. They're following.
So, did it make it easier for them? That's revising the verdict slip and so forth. Don't think she's going to say anything to them, but guys, they all seem happy.
Okay, Tori. All right, we'll see everybody tomorrow.
Thank you. Court is adjourned.
So I know that if I am in this case, I'm running this trial. I've just defended my client being charged with second-degree murder. And I've spent the day hearing about how the jury isn't sure if they're going to convict her on operating under the influence or not. That's a very successful day. Okay. That is not anything to be sad or unhappy about. Okay. If things are as they appear and the main consideration that is facing the jury is that somebody is or some buddies are really stuck on either she did do the OUI or she didn't do the OUI. You know, don't know which way there is a conflict on it. The worst possible outcome sure seems at the end of the day today is that they could come back tomorrow and just be like, fine, she's guilty of OUI. That's a major win. It's a major win for the defense. So I don't, I'm not surprised at all that they seem generally pleased with the state of where things stand right now. Not a single question or concern or anything like that about homicide, but a lot of questions about driving under the influence. Really seems like that is all that's on the table. Because if the others were on the table, who cares? Who would even care about OUI? Does it seem more likely that if we've already decided she's guilty of manslaughter, or we've already decided she's guilty of murder, does it seem more likely that we'd be willing to be like, fine, we'll throw out a not guilty on the OUI to please those dissenters than if we've unanimously agreed she's not guilty of all the homicide charges? But we're like really stuck on she committed that DUI, but there are some holdouts even on that. I'm not really sure if we can have any indication of kind of where the split is on that. But it's just really hard to see a situation where they've convicted her of murder, of manslaughter, of anything homicide, and they're having any heartburn at all about what to do with OUI. It just, that doesn't really compute. It doesn't really make sense. It's just a very easy, who cares? Fine, throw that away. She's already convicted of murder. Who cares? But if she's not guilty of murder, she's not guilty of manslaughter, then it matters a lot more whether she's even just symbolically, guilty of something. Something that gives the Commonwealth the slightest bit of chance to save face. So hard to see this as anything but a very positive place for the defense to be sitting as far as their position goes. Chop-O-Matic, Bev wanted guilty. Now that the tea leaves don't predict that, she's angry with the jury and done with them. I'm not going to answer that. What's the matter with you people? No, I don't think she's angry with the jury. I just think she wants them to hurry up and find her guilty of DUI and be done. She really wants the cover. Is the conviction of DUI, is that enough of an outcome favorable to the defendant to, or an outcome not favorable to the defendant to preclude the Section 1983 suit, the lawsuit for violation of her civil rights that we've been talking about, the possibility of something like that happening? Don't know the answer to it, but it certainly would make it murkier. It's something that then would be on the table to litigate. It's just sort of an obvious issue that the opposing party say she sued Michael Proctor for planting some bumper glass and deleting the videos and so on and so forth. Say she did that. It's just a free issue he can raise. Well, she didn't get a favorable termination because she was convicted of a crime. Okay, it wasn't the crime charge, but it was still a crime. She wasn't found to be guilt-free, faultless. I just hate the implication of that, right? But that's how the jury thinks about it a lot of the time. That an acquittal is like pinning a medal on somebody. It's like saying, I vindicate you. I support you. I hereby put the white hat on you. You are a good person. That is one thing that it can be helpful to do in closing. Is just make sure that the jury knows. You're very used to it. See, you're very used to dealing with stuff like that when you have clients who don't look good, clients who aren't good people. They have a long history. They've committed all kinds of crimes. It's just legitimately in question whether they committed this one. It can be very, very helpful and kind of intuitive to just invite the jury to consider the fact that an acquittal just means you're saying the Commonwealth didn't meet their burden. You're not saying this person is perfect or anything like that. You're not pinning a medal on them. It's not the significance of the acquittal, because I think a lot of jurors just tend to think that way. It's like we're simping for her, with a not guilty. No, you're not. You can really not like her. And I mean, they did. I know that they touched on it, but it just crossed my mind that it might not be as intuitive with a client like Karen, because you don't have those obvious problems that you have with somebody who's got a felony rap sheet that's half a mile long. That situation is pretty easy to remember. You gotta make sure the jury knows. Voting not guilty does not mean we're voting that this is a good guy, that we like this person, we want them and welcome them in polite society. It's not that at all. But you might forget to mention something like that with Karen, because why wouldn't you like her? Why wouldn't you? But people have different intuitive knee-jerk responses to people. Some people just don't like other people. Some women don't like other women. Some people are skeptical of the accused, don't like people that are accused. So just have that urge. Penalize her for something. Horace Bogardus, what would happen if the jury checked not guilty at the top and guilty on count number 5 for count 2? Guilty on number 5 for count 2. Guilty on number 5 for count. Number 5 would be OUI. So they check not guilty on the top and guilty of OUI on the count 2 form. It's an inconsistent verdict. And so all I can, it wouldn't be clear, did you vote to acquit or did you vote to convict, because they can't be reconciled. And so all I can imagine is that they would send it back to the jury, tell them, you have not filled out the form correctly. They'll do some like general restatement. If you find her not guilty of the charge and all of the lesser includeds, then check the box. But if you find her guilty on any of the lesser includeds, just check that and then stop. Don't check the not guilty, you know. But the bottom line is they would have to fix it. There's no way to take that verdict because which verdict is it? That's 2 verdicts. You know, one is not guilty, one is guilty. You can't reconcile those. So they would have to they'd have to go back and sort that out. Dubra 79. This feels so unfair. Not everyone speaks legalese. The judge should answer the questions so the jury understands. They are holding her life in their hands. I don't know what the problem is with the jury being educated about the law. Like, why should that be so concerning or offensive? She's like, well, we don't want them thinking about the consequences. You can tell them the law and also tell them consequences of a verdict are not anything you're supposed to consider. You can do both. It doesn't have to be one or the other. The fact that they want to know the law does not mean necessarily that they're wanting to take account of the consequences of a verdict. They just want to know, you know, they want to know the law. They want to know what does it mean, what they're being asked to do. Kind of keep coming back to, they didn't really have a problem with that first question about just convicting on a subcharge. For example, just hypothetically, just convicting her on OUI, convict on the overall charge. It's a legal question. We walked him through it. Don't know why it should be so problematic. Even if the answer is give him the full law. What's the worst thing that would happen if we told the jury, ladies and gentlemen of the jury, under Massachusetts law, if you cannot reach a verdict on any of the lesser included offenses, if you can't reach a verdict on all, if you can't, like, how do you even say it? If you can't reach a final verdict on count 2, including all of the lesser included offenses, then Karen Reed can be retried on the charges that are set forth in count 2. If you find she is guilty of any one of the lesser included offenses, Karen Reed can't be retried for any of it. That's the law. What would be the worst thing that would happen if you told them that? I mean, if we're just going to consider that question, the worst thing that's going to happen, they're going to convict her of OUI so that they can be sure she doesn't get tried again on anything else. But they'd also be like, if we acquit her on everything, we can't retry her on anything else. Like, what's wrong? What's wrong with them understanding the legal context that they're operating in? The thing is if there was a juror, if there was a lawyer on the jury, they would know that. And that's not illegal to have that knowledge. It's not like that would be disqualifying, being in the jury room, knowing that, hey, If we convict her on any one of these, they can't go back and retry her. But if we can't reach a verdict, they can retry her on all of them. That's not illegal knowledge for somebody to have. Why don't we just tell them that? I don't know. Miss Shorty, not guilty, not guilty, not guilty. Andrea, your coverage has been impeccable and indispensable. Thank you. Enjoy your well-deserved break from this crazy shit. Have a ham sandwich for us. I'll have a nice PBJ. The ham we'll save that for Dr. Rentschler. Crime Canuck. If Karen didn't cause John's death, who did? Never mind. Hypothetical question. Wonder if FBI looked deeper into Colin's actions that night. Well, I'm pretty sure we know that they did. Right? Because we know that they looked into like the Life 360 data. Wait, do we know that? No, because that came from Jen McCabe's phone. Pardon me for the slurp there. That came from Jen McCabe's phone, and so that could have just been the local police, and the defense found it through the local reports. Didn't necessarily get that from the FBI. Is there anything that we know of that relates to these folks that we only would have known through the FBI? I don't think so, other than just them being called as grand jury witnesses. And we do know that they were. We know that they testified in front of the grand jury. So, I mean, we know at the very least they asked questions. If they asked questions, yeah, they probably looked into it, and they probably had some of their own suspicions. If I were going to guess, I would guess that it was maybe the FBI that got interested in the Life 360 and spotted that, and the defense just found it in the FBI records. You know, that came up in the grand jury or something like that, and maybe drew their attention to it. But maybe not. Maybe not. Dalia Martinez, was it a mistake to add OUI to count 2 if it hangs all of count 2? I don't know if you can say it's a mistake. It's a trade-off. It's a known risk. And so you have to assume these are, knowledgeable attorneys. They know what the risk is. They voluntarily chose to take that risk on. It wasn't an accident. They just they understood that was a possible consequence, and they made their choice. Does that mean, do they regret making that choice? I mean, well, maybe, but how do you make a better choice given what you know at the time? You don't know who the jury is, what they're going to struggle with, etc. You don't know. I don't feel like it's not the kind of thing you can say was a mistake. It's a judgment call, and there's upsides and downsides to whichever way you do it. So I think calling it a mistake just based on the outcome, you can say it was the wrong one. It didn't get them the outcome that they desired. But was that a mistake? It was a strategic call. They bet on, of the possible outcomes, which one did they think was likely? I think they probably bet against a hanging on OUI of all things to hang on. Seems like it should be pretty easy to decide. If OUI hangs the entire jury, and we have to go back on count 2, I think the big takeaway on all of that is just that the Commonwealth couldn't even prove to a jury unanimously beyond a reasonable doubt that Karen even drove drunk. If you can't even get a conviction on that, it really speaks to the weakness of your case. You can't even get a conviction on that. Kylie, if they hang and defense polls, would they poll on lesser to have a clear record of where the hang actually was? I'm not sure that they can, because they can't do a partial verdict on the indictment. Let me see if I can find. We've looked at the rule before on the polling the jury. Let's see if I can find that one real quick. Oh yeah, here we go. Let me go ahead and share this. Good old Rule 27. Verdict shall be unanimous, general, several offenses. Okay. There are two or more offenses or defendants tried together. The jury may, with the consent of the judge at any time during its deliberations, return or be required by the judge to return a verdict or verdicts with respect to the defendants or charges as to which a verdict has been reached. What the Commonwealth versus Roth case says is that this language just means the primary charge. It does not apply to lesser includeds. There is no discretion to come in and ask, well, but to pick apart the lesser includeds, it's all or nothing when it comes to the primary charge. So they can ask them if you can agree on count 1 and count 3, even if you can't agree on count 2. But she cannot require them to return partial verdicts on the lesser includeds. So the judge may declare a mistrial as to any charges upon which the jury cannot agree upon a verdict. This again is just talking about the primary charges: murder, manslaughter, leaving the scene. Provided, however, that the judge may first require the jury to return verdicts on those charges upon which the jury can agree and direct that such verdicts be received and recorded. So what happened in the Commonwealth versus Roth case, judge looked at this exact language, said, makes sense that we should apply that to lesser included offenses. So when they come back and they say that we're hung on a charge that has lesser included offenses, I'm going to ask them to specify. I'm going to exercise my discretion under this part of the rule here and ask them if they can return a verdict on any of these lesser includeds, and they can. So we're going to send it back. They're going to return verdicts on the lesser includeds, and they're going to acquit her of some, and then they're going to indicate which one they've hung on. It's very important to understand the Commonwealth versus Roth case. The Supreme Judicial Court said that was wrong. That was wrong. It's not how you do it. It's not how you do it. In this particular case, because you did that, we have to treat those not guilty on the lessers as having the power, the double jeopardy power to bar a retrial on it. But that's not how it works in Massachusetts. We take things charge by charge. So judge, you looking at this language and applying that to lesser included offenses, that was legally incorrect. That was legally incorrect. You only have the right to ask for partial verdicts as to the different indictments as a whole, but not as to the lesser included offenses that might be contained within those indictments. So this is exactly the section that Roth was dealing with. So then the poll of a jury, when a verdict is returned and before the verdict is recorded, the jury may be polled in the discretion of the judge. If after the poll there is not a unanimous concurrence, the jury may be directed to retire for further deliberations or may be discharged. So this language doesn't specifically say you can only poll them on the indictment, on the charge, not, lesser included. It doesn't mention any of that at all. But I think we can infer that because this section here, section B, the one that the Roth case dealt with, they've said very specifically, this does not invite splitting out verdicts on lesser included offenses. It would make sense that the polling would not apply to that as well. So that, I think, is the limitation on their ability to be able to do this. I don't think they can do it on the record and find out. I think it would be pretty obvious. I have to think it would be pretty obvious. But no, Roth makes it clear the judge doesn't have discretion to make them like formally decide that. Lauren Patterson, I practice family law. I cannot imagine the stress of waiting for a jury verdict. What do you mean? You just get to wait 1.5 years for your bench trial judgment to come down. What do you mean, the stress of waiting for a jury verdict? What do you think of Judge Bev's answers to the jury? I really didn't take issue with the first couple. Personally, I think if Hank Brennan is willing to say, I'm only concerned about 1245 on the DUI, then you should go ahead and give that to the jury. That's their case. What are you doing deciding they should prosecute a different event that they're not even trying to rely on for liability? That's really not your place. But she's uncomfortable because of the indictment. The indictment didn't charge DUI at all anyway, so I don't know. I'm not comfortable enough, accustomed enough to grand jury processes to really understand if that's a legit reason to be concerned or not. It just doesn't seem consistent to me with how the facts presented to the grand jury are not binding in any way at all on what they're allowed to do at this later trial. So why would it suddenly matter? If the prosecutor wants to limit it, why can't they? I'm not sure about that. But that wasn't the defense, pushing for that. So I don't have a particular issue, I guess, with how she answered it, other than they want to say just 1245. I don't know why you wouldn't, but AJ very emphatic on the second one, the video clips of the interviews. Any weight, if any, you deem appropriate. What do you think, guys? Did she use that language? No, of course she didn't. Of course she didn't. She said, yes, the videos are evidence. You should weigh them as you weigh any other evidence and give them whatever weight you think appropriate. Not if any, whatever weight you think appropriate. I understand AJ wanting the if any, because it does make it explicitly clear you don't have to give them any weight at all. But whatever weight you think appropriate also includes that. Certainly doesn't rule out that the whatever weight you think appropriate is no weight at all. So I don't really take issue with how she answered that question at all. The videos are evidence. Weigh them as any other evidence and give them whatever weight you think appropriate. Is that maybe a little bit confusing? Not really more so than just jury instructions generally, right? Weigh them as any other evidence. Alan Jackson's point here was that if there's other evidence that they may weigh very strongly, they may think Dr. Rentschler's testimony extremely strong. We give it full credit. We have complete faith in it. We question none of it. Does this mean I have to weigh Karen's interviews the same as that? I can understand how you could read that into it if you wanted to. Weigh them as any other evidence. But give them whatever weight you think appropriate. I think it's pretty clear that she's saying the evidence gets weighed individually and you just treat the statements like the other pieces of evidence that you weigh. The amended verdict slip in general, I favor it. This is kind of what we talked about when we had the first verdict slip out and some of the problems with it and how confusing it is anyway. One possible solution to that is just very simply incorporate the instructions about how to fill in the form on the form. Make it a little bit more explanatory. And so it seems like she's done that. At some point, somebody will get the form and then we can look at it, see like visually how it works and stuff like that. But I don't really take issue with that as the improvement. Like in principle, it's just that in effect, the way she's described this, This sounds like a mess. It really does. If guilty, stop and sign. You never told them like where to indicate and what to indicate. I just don't know that that this was ultimately really all that clarifying if they're already confused about it. So I don't love the answer to count 3, but that's got to be a little bit contingent on. I'd like to see the form, once we have it. How she grows. I'm so confused. Was the jury supposed to be brought back into court at 1:30 EST for the new instructions, or was that done privately? Seems that it was done privately, that they would just send a note back to the jury. Sometimes that's how it's done. I'm kind of used to seeing that. That tends to be the normal practice in Washington, in part because 99% of the time, the answer that they give the jury is always just go back and reread your instructions. They won't provide an affirmative answer to anything. It's really obnoxious, really annoying. It's so disrespectful to the jury, I find, to just discredit their concerns. Go reread, like you just imply that they just haven't read it closely. Like they're sincerely expressing their difficulty, trying to get guidance, and you're just so dismissive of that. But that's the norm where I am. So it's very normal to just write that down. In fact, our verdict, we have like a form that you use for jury questions. It's very common to see. And it's just got the case caption, and it's got a place, a little jury question, and then a blank area where they can write it in. And they handwrite it in. And then down at the bottom, there's a gap and answer, a place where it says judge's answer, and they can just write in whatever the answer is, and they'll just send that back to the jury. So they go through the same process here, where they bring the lawyers in, read the question to them, talk about what are we going to say. The judge ultimately says, well, I'm just going to tell them to reread their instructions, regardless of what anybody else wants, and then they write that in the answer part and send it back to the jury, and you never have them come back into court at all. So I'm used to seeing that process. It's not wrong to bring them back in. It's not wrong to just send it to them. All that really stands out to me is that it's noticeable that you did it 2 different ways with these different questions. And that seems to send a message. It really seems to send a message to me. This one is, the series is very important, and we're giving it lots of attention, and we're bringing you back in. But this other one, we're so dismissive of it. We're just sending back a note saying, no, try again. Wrong question. So it does seem like this was done privately. Catalina, if the judge refused to answer my question, if I'm sentencing a woman to murder on accident, I would say fuck it and just do not guilty down the board. Maybe if I'm concerned, I'm real concerned about, tricks, legal tricks. Do I trust this process? Do I trust this institution? Do I trust this system? Not really. So I want to be sure that this is going to go down the way I think it should. Yeah, you didn't get a whole lot of reassurance from these answers that she gave today. You didn't get a lot of comfort over that. So I could see that. If I want to be absolutely sure that she's not going to be punished for some kind of, involuntary manslaughter thing, some vehicular homicide thing, whatever, anything having to do with John being found outside 34 Fairview, I want to be sure that none of that comes down on her. She doesn't get penalized for any of that. Then yeah, the only way to do that is to not convict her of anything. It's the only way to be sure. Acquit her on all of it. So your logic, Catalina, certainly makes sense. Sarita Banana, if I were a pro OUI juror and Bev said, I can't answer that, I'd say, well, you suck. Something's fishy. I changed my mind. Not guilty of OUI. Thank you, Andrea. You're the coolest chicken and bonsai mom law lady in the land. Wow. Thank you so much. And she says, I can't answer that. I can't answer. what's going to happen if we find her not guilty on the one but hang? I'm not going to tell you. I'm not going to want to hang. I guess if I'm thinking she's guilty, would I be happier? Would I be happier if she has to come back and face a manslaughter charge again? Just, because I'm so hung on there being something, there being some consequence, some judgment. Or because I've already agreed she hasn't committed a homicide crime, even if I'm inclined to be like, well, but she probably did drive drunk, would I be willing to let that go? Just to be sure? We know she didn't do the manslaughter. We want to be really sure that another jury doesn't have to deal with this. So I can live without convicting her. I'm not sure. I think it just depends on the motivations for why you were pro OUI in the first place. If you were pro OUI on the merits of the OUI, then it seems pretty easy to walk away from it. If your main concern is she's definitely not guilty of homicide, and we don't want her retried for that. But if you're just sort of generally, I don't like Karen, I think she maybe she did do it, and I'm just not going to let her go, scot-free, then you might be more inclined to go ahead and hang it. So I think a lot of this probably just depends on the motivation of anybody who is wanting to convict her of OUI. And if there's multiple, you don't know that people have the same motivation. Libra in Seattle, thank you for your amazing commentary. Your calm presence has been very reassuring during this shit show. Well, thank you for that. It's been good having everybody here. Just take it in together, guys. We're not alone. We are not alone. Dan Greenwood, why is she all jazzed up like someone put lipstick on a pig? Hashtag white girl, white claw wasted. She did seem like she had went and put her lipstick on at the end of the day, didn't she? When she brought him back in to send him home, she had put her lipstick on. Did notice that. I don't know. My lipstick always wears off in like probably 20 minutes or something like that. But, it is what it is. It's fine. Sandy B, they asked the last question first, according to Sue. Yeah, I'm not clear on exactly what this whole time frame is. Not totally clear to me. Did they send question 4, what we're calling question 4, out after they got questions 1, 2, and 3, but before they were answered? Or was it the note cards came back and I don't know what order, and for some reason the 4th one got overlooked? I'm not sure. I think we're going to have to wait for more clarification on that. Ben Togel, why do they need to gaslight the jury? It's more patronizing than gaslighting. You guys can't possibly handle the import of this information about the law and about the consequences. So don't worry your pretty little heads about that, guys. This is for the grown-ups to be concerned about. You don't have to worry about that. It's much more patronizing and paternalistic. You can't be trusted with that information. You see, if you knew what the consequences of the law were, you might consider that has something to do with the justice of the outcome, you see, and we can't have that. We can't have you deciding cases on the justness of the outcome. You might get it wrong. So you need to just put that out of your mind. Let the grown-ups worry about it. You can't be trusted with that information, but that's fine. Someday if you grow up and you become a big boy and you go to law school and become a lawyer yourself, then maybe you can have that knowledge. But for now, don't worry your little head about it. That's kind of the premise behind a lot of these legal rules, right? It's definitely the premise behind like hearsay, Premise behind bad acts, restrictions on that type of evidence. If the jury heard that, they might give it more weight than it should. So we just don't give them that information. Tammy Jones, Andrea, she still never answered whether a guilty on OUI means a guilty of the primary charge OUI falls under. No, she couldn't just give a straightforward, explicit answer. She did for the other ones. Yes, it's evidence. Yes, it's evidence. What was the other one? Time frame, you have all the evidence and only you decide the facts of the case. You are the fact finders. Not a real direct answer to that one either. But yes, the videos are evidence. She was not struggling at all to answer that one directly. No problem at all. Yes, they're evidence. Consider them. For heaven's sake, consider them. How are you going to convict her of OUI if you don't consider the videos? Yes, they're evidence. That one's easy to answer explicitly. But this bottom line, just going to let the amendment to the verdict form do all of the talking and not just go ahead and come out and answer it explicitly. If you convict her on any lesser, it necessarily means you are acquitting her on the greater charges. You only work your way through the lessers because you have acquitted her on the greaters. So by the time you even get to the lesser, you've already acquitted her on the greaters. Seems pretty simple and straightforward, but she can't just answer it in a simple and straightforward and direct way. And that's really, say that again, that's really not a Bev thing. It's not unique to her. Who just judges routinely. Don't answer the jury's questions. It just seems so disrespectful to me. But that's how it is. I had that issue on appeal. I fought that fight, raised that fight, tried to get a petition for review on. Could you at least say that they have some kind of, at some point, the courts have an obligation to just answer the question directly when it's not in dispute what the right answer is, and there's no obvious harm in the jury knowing? Can't we just tell them? No, there's no requirement at all. Not in Washington anyway. Dan Greenwood, am I right in thinking there is a jury officer that helps juries navigate their process? I definitely remember having someone in the UK for these questions. Not in the US. Not in the US. There is nothing like that. Nobody is permitted to have any kind of ex parte contact with the jury. So all of their communications have to go like this. They have to be in writing. And then that writing, they typically give it to the bailiff, the court officer. Court officer passes it on to the court, and we see this process. But the only actual communication they have with anybody along this part of the process is supposed to be contact the court officer to let them know we have a note for the court or we have a question for the court. Here it is. That's it. So if they got questions, this is how they got to present them, how to deal with it. They don't have any kind of assistance like that. LTL Media, I live here, cover this case, and I'm sick to my stomach. I don't want to seem unsympathetic or, I'm way over here on the other side of the country. It's not my community. It doesn't affect me personally, what happens in this particular trial. And I definitely understand. You live in Norfolk County, and all this evidence has just come out about how shady and underhanded and punitive and corrupt the law enforcement and criminal justice system generally is in my community. I'm going to be disturbed by that too. So I don't want to minimize any of that or discount it, but I do just want to reemphasize. It seems really clear right now that what we're arguing about is Karen even going to get convicted of DUI? And the takeaway from that is that the Commonwealth blew this so badly. And there are people on that jury that are pissed off enough at what they've seen here that they won't even convict on the gimme charge, where Karen went on these interviews and said, yeah, I was probably buzzed and shouldn't have been driving. They can't even convict her on that. So I don't think this is cause for a negative perspective. I mean, it's not unreasonable to me that there would be people on the jury being like, well, but guys, she probably did commit the DUI. She probably did. Just on the evidence, on the merits, on what we saw, she probably did do that. I think you can have jurors that are being very diligent, very responsible, very skeptical of the Commonwealth, and still be like, well, I mean, she said it herself. She probably shouldn't have been driving. It doesn't take bad faith to get to that position at all. So I think it's really the fact that there seemed to be a substantial number of the jurors who were like, I don't give a shit what she said. I'm not convicting her of DUI. That's cause for optimism, I would think. I don't want to, take away or suggest that your feelings are not valid or anything like that. But that's just my perspective on how we're seeing this unfold. I have a very hard time seeing this as a negative development for the defense. Distractible Hermes. If your blood alcohol is 0.05, that means that 87 hours prior, it was 1.39%. Did you actually do that? Did you just make some numbers up? Did you actually do the extrapolation? The formula's out there. It can be done. Yikes. That's our reasonable time right there. Sandy B. Morrissey is at VFW with the McAlberts. That doesn't seem surprising to me. That doesn't seem surprising to me at all. That's what this is about, isn't it? This is this is the alignment. This is the configuration. This is the playing field. These are the teams. That doesn't seem surprising to me at all. AC 75, completing jury forms sounds a bit like completing voting slips or forms. Anything not in the box is void, or how close are we here to hanging chads? It is kind of, isn't it? You got to get it exactly right, or who knows what the consequence is going to be. This is why yesterday when I was on with Bob and Allie over on Defense Diaries, and we were talking about the possibility of what if the jury just writes in on the verdict slip what they want it to be. And I'm like, please don't do that. Like, of all things that they could, please don't go in and try to edit the verdict form to be the way you think it should be. Because all that's going to do is just introduce ambiguity and conflict and issues over what you actually did. What is the significance of what you did? And does it legally undermine any conclusion that you reached? It just creates a mess. Please don't do that. Because then ultimately it just goes up to the Supreme Court and they go eeny, meeny, miny, mo. All right, you win. Congratulations, Mr. President. You just end up leaving it up to leaving it up to the judge to sort out. Did you convict her or acquit her? Please don't do that. We don't want to have to deal with that through a whole process of decision making and an appeal. So yeah, there's lots of pitfalls with it, and stuff that seems like it's perfectly clear to lawyers, not always perfectly clear to lay people. And then kind of the other side of that can be the problem where the lay people are like, we're dealing with lawyers. We know how careful lawyers are with the words. So we need to, flesh out every single little bit of nuance of the words in these instructions, and you can talk yourself into them being more confusing than maybe they just are on your first reading and your intuitive reaction to it. I think it's a good analogy. It is a lot like filling out a verdict form, because unless you just do it, and except your choices are a little more complicated, you know. You don't have to choose like which prong of somebody's argument is causing you to vote for them as opposed to the other person, you know. It's more complicated to do the verdict form. But a very, very similar analogy in terms of you got to just do it right, and you better hope you get it right, or who knows what somebody is going to decide you actually did, if they decide you did anything at all. It's just messy. Duncan, Idaho, I'd guess the hang-up is between trying to convict on OUI and refusing to, in light of everyone else OUIing and drunkenly losing their guns that night. The lost gun isn't in evidence, is it? Or did it make it in? I remember they heard about the Kevin Albert. Didn't they hear about Kevin Albert got disciplined? Or they heard about Proctor got disciplined relating to some action with Kevin Albert. But I don't remember if they heard the specifics. Kevin Albert lost his gun on that drunken night out at the Cape. Didn't know where his gun was. I don't think they have that in evidence. But yeah, I think in general, it's people are like, well, seems like she probably did the OUI. And then other people who are like, over my freaking dead body, I'm not convicting her of anything. That's just what seems likely to me. I could totally be wrong about that, but just makes some sense. I know a guy, the jury didn't even know Hank's clips were evidence. Hilarious. It's kind of funny, isn't it? They had to spell out what exactly is this anyway. This is being treated so differently than anything else. There's no questions about it. Nobody is talking about it. You're just kind of showing them to us like you're a DJ or something. And this is a bad sampling that you're doing here in this courtroom. I mean, it did stand out. It did get treated differently from the other pieces of evidence. You didn't have to have a sponsoring witness. So, I mean, it can make some sense to me why they'd be confused about, since this was treated differently than the other evidence, does that mean that it is in fact different? Should we also be treating it differently? You guys did. Should we also? I think that does make some sense. But also, yes, kind of funny. Like, what is it if not evidence? What else is it? I don't know. Desert Quill, I must be missing something because I'm not seeing a verdict today or any day. Seems as if this is clearly already a hung jury, in my opinion. I don't get that impression. Not from that last question. Number 4, which may be number 1. We don't know. If we find her not guilty on 2 counts, but we can't agree on 1, is it a hung jury on all or just on 1? This to me is making it pretty clear they have a verdict on 2. They have found her not guilty on 2. And they just want to know, how much do we have to resolve, the issue with the OUI count 2 without worrying about causing a problem for a future hypothetical jury. It's really what they want to know. How big are the stakes if we don't decide count 2? I think that's making it very clear. They have the jury on the 1. The issue now is just, is anybody going to cave on 2? And if so, who? Seems to me like it's pretty easy to cave in favor of just convict her on the OUI. But if you got folks in there that are standing on principle, over my dead body, after what these police did in this investigation, and everybody else is driving around drunk, like hell, I'm going to convict her of OUI. It's going to be hard to talk him off that. Snookers, will the defense appeal the lesser charge of OUI if found guilty? $1 million question right there. My thought about this is that everything else being equal, just taking the situation in a vacuum, would you? Yeah, why not? Because what do you have to lose? You don't have anything to lose. Why not appeal? You can potentially get it thrown out as well. That's consistent with the principle of I didn't do anything wrong. I shouldn't. They didn't prove it. They didn't prove I did any of this. So makes sense kind of in a vacuum to go ahead and continue with it. And that does seem to be, like I said before, kind of consistent with how Karen has already conducted herself in the case, with her willingness to fight, taking that double jeopardy issue all the way up to the U.S. Supreme Court is somebody who is willing to push the limit for the principle. Because that was always a very weak legal position, not a good prospect of success, but vindicating that was worth the time, the paying the lawyers to go and deal with it, and all of that. So that as a matter of priorities for her, it mattered. Now, in a vacuum, taking that out of consideration, yes, appeals cost money, appeals take time, and so that's your trade-off. If I'm going to have to spend 20 grand on this appeal, it might be more, but let's say it's 20 grand I'm going to have to spend on this appeal. What's my possible upside? My possible upside is my clean criminal record, not having to pay a fine. If there's any jail time, I've probably had to already serve it before I can appeal. I'm not sure how Massachusetts handles stays while the case is on appeal, but generally speaking, there's a presumption it does not, just appealing doesn't stay your sentence. So you can't get your time back if you've already been sentenced to, 10 days in jail. You would have had to have done, you're not getting that time back. So that's not an upside. It's really just penalties, those collateral pain in the ass kinds of consequences. Like, do I have to get an interlock device? Do I have to go to the class? The different things you have to do, the hoops you have to jump through. Those are really convenience factors. Are those going to be worth 20 grand to you? But otherwise, it's just the vindication of clearing your name, not having a criminal record. It's petty. It's not like getting convicted of a felony where there can be consequences, like serious consequences for being able to get professional licensing and stuff like that. OUI, worst consequence is general. You can't go to Canada. You can't go to Canada. Makes it very difficult to go to Canada. You have to wait till a bunch of time passes and you don't get convicted of any new crimes, and then you can go apply for a certificate of rehabilitation to be able to go to Canada again. But that's really the main downside. So it's just a question of the trade-offs. It's very reasonable for people to be like, you know what? There's not really a big upside to going forward with appeal. Do I want to spend 20 grand on it? No, you know what? Forget it. That would be a very logical, very rational way to go with it. And if you want to be done, big upside there. You can put this out of your mind and go on with your life, handle other things. Some of the other factors that we've kind of touched on a little bit, does this like muddy the waters a little bit if you're convicted of OUI? Does it muddy the waters if you're thinking about filing a 1983 suit against Michael Proctor, Yuri Buchanan, anybody else involved on the law enforcement investigation side of things? That might give you a little bit more incentive to go appeal it. Is it going to have implications for the civil suit? Remember, that's been lurking out there. The O'Keeffes sued Karen Reed, C.F. McCarthy's, and the Waterfall. But that's for causing John's death. Just being drunk in and of itself didn't necessarily lead to that outcome. But And a conviction has the potential to muddy the waters much more than an acquittal. Acquittal's pretty clear. Didn't find her guilty of any of it. Now you can still come back with a lower standard in a civil case. You know, it's just preponderance of the evidence. So an acquittal doesn't bar them being able to go forward with a civil claim. And just like we saw with OJ. But a conviction potentially makes it easier for them to find, you know, some of the elements, some of the charges. And if they're leaning in favor of a maybe she did it, it's really, you know, you need very little more than maybe in civil court. Maybe that's enough incentive to go ahead and appeal it as well, and just not hand over that element, that finding. So I can see this going both ways. My assumption would be that she would appeal. That would be my guess. If I were going to predict, what would she do? And I think one of the big reasons for that is because they didn't invite the conviction. After all of this, we wanted the instruction in so that the jury had the option to make it easy so they don't hang and make us retry her on manslaughter again. But we're not going to invite them to do it because we don't actually want that, and we will fight it if it comes down. I could kind of see that. So objectively, plenty of good reasons to go both ways. But my prediction would be I think she probably would appeal. It's just consistent with how she's handled the case so far. Amanda, Hank is just waiting to argue. The jury asked about acquitting on some and hanging on another. Therefore, they've been communicating outside the deliberation room, and there should be a mistrial. Come up with something, some reason to ask for a mistrial, or has he totally given up at this point? He didn't put up much in the way of objections today. I mean, he volunteered to limit. That to me, you volunteered to limit the DUI to 1245. Don't even get them the option. If you're the prosecutor, don't you normally want the jury to have every possible option to be able to convict available? Why would you take them off the table? But he wanted to. Why? Because that's all we've ever focused on. It's not a very prosecutor who wants to win kind of attitude. I kind of feel like Hank has already given up. But if he can come up with a reason to ask for a mistrial, I have a feeling he would do that. He would do that. But as far as like the hung jury and that question, what do we do if it's a convicting on the greater? Is that a conviction on the overall? No problem with what the defense wants to do as far as the verdict form. Edits, explain it. Doesn't agree with the explicit acquittal. Doesn't think they need to be told it means you're acquitting on the greater. So I think he's trying to maybe keep it at least a little bit confusing, in the hopes that that maybe they'll just hang. I don't know. Marie V. Sands, is the defense regretting putting that charge now? She could have been acquitted had it not been there. I don't think so, because we're not done yet, guys. We're not done. We're not done. The strategy has not unfolded to the conclusion. We're just in the process of working through the effects of the strategy. We don't know if she's going to walk away acquitted at the end of all of this. We don't know what the outcome is going to be. It's possible if they hadn't asked for this charge, if the reason why, this is a hang up is because you've got some people that are just absolutely insistent that, we think she probably did all of it. But guess we can't prove it, but this DUI, we absolutely can prove that. She admitted it herself. We got her words. We got that blood draw, 9 a.m. We know she admitted she did that. Then we wouldn't necessarily be sitting here at an acquittal right now. We could still be arguing about, can we all agree that she's not guilty of a homicide charge? It's just, you get too far into the counterfactuals. A lot of it you may never know, because unless the jury decides to tell us what their thought process is, we're never going to know. Even if they do, any one person's account of what 12 people are doing and thinking in the deliberation room is inherently limited. So you don't know that you're getting the full picture. You don't know that you're getting the accurate picture. Said many times, this, talk about it all the time with witness testimony, what bad evidence it is, in part because perception and memory and stuff like that, they just are not the reliable things we think they are. Take one event and give it an audience of 12 people, and you're going to get 12 different perspectives on it. It's going to be the same thing with accounts of deliberations. So I don't know that we will ever really know what the thought process is or what the hang up is. We're not in a position at this point to say whether the strategy has played out the way that the defense wants it to or not. It could very well be that the defense is going to be satisfied with a conviction, and they think that that would be the worst case scenario. She gets convicted of OUI. Tina T, you are all set. Did you like how she gave that to the defense team? Did she like, I put in my notes, AJ is very clear. We want, if any, and he's going on, and Bev says, I understand. And then I have in my notes, your objections noted. And I put the little notes by it because she was all sing-song. Your objection is noted. You are all set, guys. I've heard you enough. That was funny. Duncan, Idaho, are you kidding me? Well, I'm not kidding you. Bev isn't kidding you either, although sometimes it can be a little bit hard to believe what Bev is doing. Sandy B, jury thinks if they check guilty of OUI, it means she is guilty of involuntary manslaughter. The judge didn't answer their question. No, she didn't come out and just answer it explicitly. Give them the assurance that no, by virtue of working your way through the form all the way down to OUI, you necessarily have to have concluded she's not guilty of all these other offenses. Why that's so difficult to say, I don't know. You're not going to find me an advocate for not answering jury questions. Give them the information. Tell them what they want to know. It's the law is supposed to belong to all of us. It's supposed to be a public resource. It's supposed to be part of our civic processes. In an ideal world, you shouldn't really have law school as a thing. It should just be like everybody that goes to school learns about our legal system and like generally how it works and stuff. Salem Southpaw, why are you convinced they aren't hung on manslaughter? Because they wouldn't give a shit about OUI if they had decided she's guilty of manslaughter. It's an afterthought. It doesn't matter. If they were concerned about that, it would be, the questions would be more along the lines of like, well, can't we convict her of both? Like if the issue is we've already convicted her of manslaughter, but we haven't convicted her of OUI, but we're thinking about it, but we're not sure if we can. If you've already convicted her with manslaughter, you're done. But if you haven't decided on manslaughter, that would be your focus, wouldn't it? Because it's a little bit more important than worrying about an OUI. You get her on manslaughter, there's going to be serious consequences. Are we really, really concerned about but is her license going to be suspended for 90 days? Is she going to have to get SR22 insurance? No, I think that they've made it clear. It's the OUI is all they're talking about. It's what all of their questions are focused on. That seems to be the issue. The only one that they've hung on is the one with the lessers. I think that that is significant too. So I don't know, of course, we're all just kind of projecting, kind of doing our best to predict. But to me, that seems pretty obvious that if we're sitting here arguing about OUI, it's because that's what we're down to. That's all that's on the table. If we were thinking at all about convicting her of manslaughter, that would be our focus. And that would be, if we're having trouble understanding the facts or the law that would allow us to get there, that's what our questions would be about. Brooklyn James, where can I find when covered Roth MA not accepting partials? Sorry, I missed it. Love your insights. Let me just pull it up because we talked about it yesterday at Defense Diaries when I was on with them. I did talk about it. One of the last streams, but I can't remember which one. So this is the case that you're looking for right here. You can, see, well, I guess you can't really see the site from this. But this is the case, Commonwealth versus Roth. Right here on Find Law. Pretty easy way to find it. And it goes through, what the issue is with the lesser includeds and what the judge did and what the finding and stuff is. So I would mainly just encourage you to find that case. It's out there, and go ahead and read through it. I don't remember where the exact timestamps or anything like that is from when I discussed it before, but it has come up a few times. Chef 22504, Ann Dowd, final answer on casting for Bev. Let me look up Ann Dowd. Who is Ann Dowd? I don't recognize her at all. I don't know if I know anything that she's in. Let me look at her IMDb real fast. What has she been in? The Handmaid's Tale, I didn't watch it. The Exorcist, new movie, I didn't watch it. The remake. I don't know if I've seen anything that she's been in. Looks like she's done a lot of TV. I don't really watch a lot of TV. It's like Great British Baking Show and Project Runway, and that's about baseball, Oh, she was in True Detective. I did watch True Detective, but only in one episode, so she doesn't stand out to me for that. Yeah, I don't know. It's a fairly long IMDb, but it's pretty TV heavy. I don't think I've seen her in anything. The movie Philadelphia, she was in that. No idea what her role was in that. I don't remember her at all. Well, thank you for your nomination. I know nothing about like her vibe or anything like that, but can see a little bit of a visual reason to cast her. Ty, what is the sentencing tariff for the OUI alone? I want to say $1,000 fine. Tory OUI sentence. See if I can find out real quickly what the mandatory, if there's like a mandatory minimum sentence. Criminal penalties. Okay, so this is from a Find Law article. Take that with a grain of salt. These things are not always extremely well sourced, but they're usually at least in the ballpark. So that says all OUI convictions for persons 21 or older include required sentencing elements. These include $250 fee to the Head Injury Treatment Services Trust Fund a $50 fee to the Victims of Drunk Driving Trust Fund, a $65 fee per month if placed on probation, and complete a substance abuse assessment and drug or alcohol treatment program is needed. So you have $300 in mandatory fines. If you're on probation, another $65 a month. Then your sentence may include a fine of between $500 and $5,000. So that's just an option they can tack on anywhere in there. Up to 2.5 years in jail, probation for up to 2 years, completion of a drug or alcohol education class, driver's license suspension of 1 year, and complete a substance abuse assessment and treatment program if needed. So some discretion within that. The only thing that is mandatory is the $300, fund, the specific fund assessments. Fine is optional, jail time is optional, and all of that. Rowan, I need to know how you take your tea. Hoping not guilty tomorrow. Me too. Me too. That would be great. So my tea, I'm a little bit of a tea snob. I like my Silver Needle white tea. I take it plain, but I brew it. The 75 degrees, first brew in the 2 to 3 minute ballpark. Just a little particular about how I like it. Then the more times I'll rebrew the leaves a bunch of times. I'm totally fine with that. But you do start to lose flavor over time. So by about the third brew, maybe more like 5 minutes, you're letting it sit. Speaking of my tea, Rowan, thank you for bringing it up. I'm going to pause real quickly and then I'll be right back. But I am going to refill, because we still have some questions in the queue to get through. So give me one moment and I will be right back with you guys. All right, guys. After saying that, then I literally just like shorted myself on my brew a little bit, but that's okay. That's okay. I got enough. I got enough tea vibe out of it. It's all good. All right, Melanie, if jury is hung on OUI, can Bev declare hung mistrial? Seems like she won't ask them what they're hung on and what they acquitted on. So that's getting us back to the partial verdict, right? Let's go back to that rule. Let me pull that back up again. Let's go ahead and bring it back up. So this is Rule 27. Let's go ahead and walk through this again. Is that, no, that's too big. We can't see that. That's blocking the screen. Oops, blocking the screen a little bit. I'll put me over here. If two or more offenses or defendants tried together, the jury may, with the consent of the judge or at any time during its deliberations, return or be required by the judge to return a verdict or verdicts with respect to the defendants or charges as to which a verdict has been reached, and thereafter the jury may, in the discretion of the judge, resume deliberation. Okay, let's take this first, because here's what they're saying. At any time you've got multiple charges in a single trial, the judge can either say or can require the jury to return a verdict on anything you've already agreed on. Okay, we just got this hypothetical question. If we find her not guilty on two but can't agree on one, is it a hung jury on all or just on one? Can't answer the question is all Bev had for the answer. Certainly wouldn't be inappropriate at this point in time to go ahead and start thinking about Rule 27B here. You can say, if this hypothetical question that you're asking is a reflection that you have actually reached unanimous agreement on some of the charges, go ahead and finish that. Complete the verdict forms, fill them out, send them back, and then just go back and finish on the one you can't agree on. The rule makes it clear she has discretion to require them to do that. But she didn't seem interested in exercising it at this point, did she? The judge may declare a mistrial as to any charges upon which the jury cannot agree upon a verdict, provided, however, that the judge may first require the jury to return verdicts on those charges upon which the jury can agree and direct that such verdicts be received and recorded. This is all discretionary language. May is discretionary. None of this says a judge has to do it. None of this says the judge is required to ask the jury, can you reach unanimous agreement on anything? None of this requires, even if the jury has apparently indicated at least a possibility, a suspicion, a reason to think they have in fact already found her not guilty on two charges. Entirely discretionary with the judge, whether she wants to finalize and formalize that or not. And so far, she's erred on the side of not. So this is something we might see tomorrow when court is back in session. Wouldn't surprise me if we heard something from the defense pointing out, hey, in light of that question that we raised, maybe, judge, you should consider exercising your discretion to ask them if they can return a verdict on any of the charges right now. She's probably going to consider it premature, wait for them to come back and say, oh, we can't reach a verdict on whatever. But, if we start going in that direction, it seems pretty clear this is where the defense is going to be drawing her attention and wanting her to do. And so then the question is going to be, How broad is her discretion to say, no, I'm not going to take their verdict? Seems like it's pretty broad, doesn't it? This was the whole issue with the double jeopardy question that went up. So, wow, this has a lot of power at the state level to decide what even constitutes a verdict. What would keep them from just applying state law in such a way that there is really no such thing as a guilty verdict? We just refuse to take them. If the jury is going to acquit on something, well, then we'll call it done, and we'll hang on all of it, because under the rule, she has the discretion to hang on all of it. Even if they say explicitly, we found her not guilty on these. It's up to her whether she wants to formalize that and turn that into an actual return of a verdict. So that would tell us a lot about how Judge Bev wants to see this go. So far, my thinking is she doesn't want this done again. She absolutely doesn't want it done again. However, if it reaches a point where it's going to be inevitable that it's done again, does she want it done again on just manslaughter, or would she rather have the door open for murder yet again? Why do I think Judge Bev would love to leave murder on the table if a retrial is going to be inevitable anyway? Let's hope we don't have to worry about that at all. Best case scenario is that we don't have to worry about that at all. But that question is about the polling rule. And so she has discretion to not ask them. I think that's a good observation you had there. Beth Dutton with a super chat. Thanks so much for that, Beth. Appreciate your support. NCLK, will you cover Luigi Mangione's cases? I've only looked at that one really from a distance so far, not followed it closely. It's going to be a little bit more obscure, of course, because it's in federal court. And so anytime you're in federal court, you don't 99.9% of the time have cameras. Very few number of pilot courts in the country that do federal courts that have the cameras in, but not aware that this is one of them. So it's always a little bit harder to cover cases that you can't watch them for yourself because you're relying on secondhand information. And it's not always good. It's been part of the issue for me with trying to pay attention to what's going on with Diddy's case. It's a lot of people trying to interpret information that's being fed out of the courtroom by mostly non-legal professionals. Now there's Joe in there. Good logic, guys. Good logic. Joe has been doing some Diddy coverage. I defer so much more to the take of somebody that has a legal background telling me about what's happening in the courtroom, because they're just better positioned to understand what matters and what doesn't. The press just often doesn't get it. So anyway, that's a complication with Luigi. So I'm not going to say no. I'm not going to cover it, but I am a little bit more wait and see. And it hasn't captured my curiosity, I guess, at this point to quite the extent that some other cases have. Some shenanigans involved, no question about that. Right? Some issues with ruses and things like that. But let me give that a solid we'll see. NCLK. We'll see. Maybe. If there's nothing else going on, when we get to that point. Lucy Fair, is it unreasonable to fear for Karen at all if she's found not guilty or even just guilty for OUI? I might be catastrophizing, but I can't shake that fear. What are you afraid of in terms of a consequence? The discretionary penalty could be up to 2.5 years in jail. It's quite a lot. Quite a big penalty that the judge has hanging over her. So yeah, I mean, you can be concerned that the judge is going to impose a trial tax. Okay, sentence her to something worse. than you would give ordinary first-time offenders who come in and plead guilty. Maybe they don't get any jail time, but this person has required the whole expense and process of a trial. Of course, they can't come out and say that, but it's what they do. Impose a trial tax. She has to get some jail time because she's made us go through all this. And then the other side of it too is it's a way that they can backdoor punishment for the things that the jury acquits her on. Okay, she gets explicitly acquitted, let's say, of murder and manslaughter. All the homicide charges seems pretty clearly to reflect a jury decision that there was no collision here. But that's not explicit, and she's not bound by it. And so it's a way to backdoor and be like, well, but this isn't like an ordinary DUI because this one had life-changing consequences. And just, backdoor in a penalty for what the jury, seemingly would have concluded that she didn't even do. So those are risks. But I tend to think that they're pretty minimal. I really do. There's only so harsh of a penalty you can impose for straight OUI before it's becoming very clear you're singling this one out. And you have to have really good reasons to do that. It's not that, judges do have discretion in sentencing, and it's not a bad thing, but their discretion exists because it means the penalty is supposed to at least somewhat reflect the characteristics of the defendant and the characteristics of the crime, of the charge. So if it's particularly egregious, yeah, then the court is supposed to have more discretion to do something. But it's just, you see that making a lot more sense in a context of like a homicide, than something like an OUI. What's a simple OUI versus an egregious OUI? Well, a lot of times it'll be things like your blood alcohol level is so high, you were, driving like an absolute lunatic, going 80 miles an hour all over the road. Bunch of people had to pull off, endangered lots of people, something like that. Or it has to do with the characteristics of the defendant. You've done this a whole bunch of times before. With DUI, that tends to get built into the statute itself. It doesn't really factor into the judge's discretion because they have different mandatory minimum penalties depending on if you've been convicted of it before. And also, by the way, like if you refuse the breath test. So that type of thing is very common as a reason to distinguish between convictions of different people, but it's already built into the statute. It's not like she would be kind of double dipping if she were gonna, impose a punishment on Karen. It doesn't apply in this situation anyway, because she didn't refuse and she doesn't have priors. So she has the power to be able to impose more than just the same sentence she would give anybody else who walks into her courtroom and pleads guilty of OUI, and you don't even have to think about it because it's so routine. She can. Is she going to do something significantly worse than that? It just seems unlikely. Because she knows not only that will increase the likelihood that you're getting appealed. If it was, a mixed question before, see it both ways. The harsher a sentence you give her, the more likely it is she is going to go ahead and appeal that. See if she can get it stayed. It may not be an automatic stay, but there's often a way that you can request a stay. And then, by the way, if your sentence is extremely egregious, better chance she would get a stay while the appeal is going on. So I think that I don't think you're catastrophizing. I think it's normal to be concerned about this. We don't trust this institution and we don't trust this court. So of course you'd be afraid of it. But to me, looking at the situation and the inclination that everybody is going to have to protect their own position, protect their own status, Bev is going to know, not only are you inviting an appeal, but you're just screaming for a rebuke in the court of public opinion if you treat her differently than you treat other people. You've taken so much heat for being biased, and it's just going to confirm that. So I don't think there's a reason to be hugely concerned, but I can't say it's non-zero. A lot of discretion with the judge. I get it. John Scott, inconsistent verdict instruction should be that clear and neutral, but I don't believe it would be in this case. Do they have an inconsistent verdict instruction? I kind of forget what, if anything, they have on that. They have the jury instructions in like different places, different courts, and there's kind of some strange stuff in some of it. Let me see if I can find anything. Yeah, I don't think they really have anything to like deal with that situation. If they get an inconsistent verdict, I think they're just winging it. There's no form. God help us. God help us. It would be Bev winging it. Go back and do it right. Can't have both of these outcomes. So then proceed to put your finger on the outcome that you want. So if you just find her guilty of the OUI, then just do that. And that's all you have to fill out. But if you're thinking she's not guilty of any, it's just a way of trying to lead them to where you want them to be. Zencat. FYI, Mark Betterow praised you to the heavens last night on Young Jerks. No one is smarter, legally speaking, than Andrea Burkhardt. Holy cow. Well, he's one to talk. That guy knows his way around a trial. My goodness. Thank you for sharing that with me. That's very high praise. I love me some Mark. I love Mark recaps. Mark has that everyman's perspective on the case. Like, Mark to me is, if I'm hiring a trial lawyer, Mark is exactly the person that I want, because he can communicate things in lay language very clearly, very well. He can summarize things. He can sum up and like clarify. Here's why we're having a problem. Here's what it all boils down to. And you can't, some of these skills, you can't teach them. They're irreplaceable. And he's got great common sense. So that's very, very high praise from someone I have an awful lot of respect for. Hoping that, sometime over the next couple days, maybe we'll get a chance to connect again. I think we had one show on Young Jerks maybe where we were on a panel, but otherwise, I would love to spend more time with Mr. Betterow. Really appreciate his takes. Beth Tutton with another super chat. Thank you so much for that, Beth. Nicole K. Andrea, how sure are you that it's the OUI the jury are not agreeing on? I'm not in the jury room. I don't know. I can't have 100% certainty. I feel pretty good at 90%. I feel pretty good at 90% certain, because that's all they're asking about. If they were hung on something else, they would be asking about the thing they're hung on. So to me, it seems pretty clear that that's the focus. They walked in this morning already knowing she's not guilty of homicide. All we have to do is sort out the OUI. And they're not in agreement on that. What an indictment of the Commonwealth. It really is. God, you can't even convince them. You can't even convince 12 people that she drove under the influence when she's on video saying, you probably shouldn't have been driving. Yeah, you guys are a mess and nobody agrees with your takes and your prosecution or trusts you. That should be the big takeaway. Gender neutral. Biggest lesson, keep your mouth shut if arrested. This is an evergreen lesson. Evergreen, keep your mouth shut, because anything you say that's in your favor, you're not going to be able to use anyway, right? We already know that when Karen was arrested the second time and she's on video, we saw it in the first trial, telling Yuri, are we all in on the joke here? Because we know that You know, Brian, did she say Brian and Colin beat him up? And, you know, his face was all messed up or whatever. I mean, I forget her exact words, but laid out the third party culprit theory 3 months after the event happens, when she's arrested after the second indictment back in June. She doesn't get to use that. So anything that you say that's in your favor, no guarantee that it's going to benefit you at all. And then anything you say that can be twisted, it will be. So no, there's no reason to say anything. They're not your friends. You're not going to talk yourself out of the situation. J. Coop, Andrea, are we sure it's hung only on OUI? We're not in the room. We can't be 100% certain. All we can do is interpret what we're seeing, what they're talking about, what their focus is. Their focus is clearly OUI. 2 of the 4 questions explicitly say OUI is what we're concerned about. 2 of them don't say explicitly OUI, but one says very clearly, can't agree on one, the one that contains the OUI, probably. And then one that's asking about the evidence, which is like the strongest evidence they have of OUI. Karen saying, well, you probably should have been driving. It seems very clear that that's what the focus is. So if that's the focus, it seems like it stands to reason that that's the point they can't resolve. If they couldn't resolve manslaughter, that would be far more important to get that resolved than to be, you know, playing around the edges here with a lesser included misdemeanor. It's just so insignificant compared to the homicide charges. So that's my read on it. Michelle J., can the defense file a motion for the court to move the lesser included standalone DUI to a third, or does it have to be on the indictment? My understanding is it has to be on the indictment. It's a lesser. If it's a lesser, then it just falls under this count 2 and it's considered as part of count 2. If it were going to be treated separately, it would need a separate indictment. And she doesn't have any right to go to a grand jury or ask a grand jury to return an indictment on OUI and OUI alone. So I don't think she has the power to do this. This again just is in the hands of the prosecuting attorney and what they decide to present to the grand jury and what they don't. And the incentives are alarming. Yinzer, in your Yinzer, is that a Pittsburgh like kind of Yinzer? Or is that like Yunzer? Would that be with the, I don't know, Yinzer. In your opinion, is this trial the most popular in the U.S. since OJ's trial, including criminal and civil cases? No, man, Depp v. Heard. Way bigger than this one. People all over the world, millions of people. A lot of people watching this one, but I think this is still mostly either like in Massachusetts, like local attention, a lot of local interest and attention that, is maybe driving some of the popularity more than cases that don't have that much local interest. And then also just true crime people, people who are interested in the criminal justice system, people who are concerned about misconduct, wrongdoing, maybe like a little bit of crossover with distrust the government folks. But like Depp v. Heard was everywhere. That would be my answer to the most popular trial since OJ's trial. But there's a lot of eyes on this, no question about that. Katie Cat, could jury send a note saying we find her not guilty on 1 and 3 and we find her guilty on number 5 on number 2 only? What is the proper way we are to write our true and honest verdict? Yeah, so yeah, they can send this note. Let's imagine a scenario where they send this note. What does that mean? We already know because we just looked over Rule 27, that Bev does not have to give them the opportunity to give partial verdicts. So this is not a partial verdict. This is telling them explicitly, we've reached verdicts on all three. We just don't know how to fill out the form. What's she gonna do? She doesn't have to do anything at all. We could have another, I can't answer this question. Reread your instructions, reread the form. If she hasn't answered their questions directly so far in general, I don't know why she would answer the questions directly this time. Tell them just mark that on the form and sign here, like the thing a helpful person would do. I don't think she would do that. Anybody really think she would do that? Here you go. If that's your decision, and here's how you need to fill out the form and sign it. Of course not. No, she'll just be like, go reread the verdict form. Go reread the instructions. Figure it out. Doesn't want to put her finger on the scale while, putting her finger on the scale. It's like trying to delay the inevitable. It would be interesting if they did send a question like this, wouldn't it? Because this is no longer hypothetical now. This is no longer hypothetical, and they are putting her on the spot. The problem is with the verdict form. You want to make this clear? We're making our intentions clear. Do you want to make it clear? A little bit of a moment of truth for Bev. Do you want to make it clear, Judge, or do you want to make it hard? I don't think she's going to make it easy for him. M. Hampton with a super sticker. Thank you so much for that. Appreciate that. Carrie, Attorney Betterow gave you great reviews last night on the Young Jerks. Love him. I do too. That is blush a little bit. It's high praise. Radio Wheelies. Do you think the feds come after the responsible person or persons for John's death if Karen is found not guilty? And what would that look like? No, I don't think they do, because in general, they don't have jurisdiction over murder. They don't have jurisdiction to prosecute who killed John. They have to have very specific, like factual issues in the case for there to be jurisdiction for murder. So I'm going to go ahead and share this. This is kind of like I just said, it's a lawyer website. And so you got to kind of take it with a grain of salt, because they don't always get everything exactly right. But, some give more detail than others. This one in particular seems decently sourced. But so it's describing, when is murder a federal crime? So it's all under different statutes. This is why it's hard to find out, because there's like a billion federal statutes. These are some of the facts. Murder of an elected appointed official, a murder of a federal judge, or a federal law enforcement officer. Okay, not just any random cop. If it was just John as a Boston police officer, that's not going to be enough to get federal jurisdiction. Immediate family member of a federal law enforcement officer. Other murders because of the circumstances in which they happened, to try to influence the outcome of a federal court case. No indication of that. Committed during a bank robbery. Murder related to this exploitation of children. Drug-related murders. Murders on ships. Murders for hire. Murders by mail. There's nothing that implicates, these kinds of facts that would give the feds jurisdiction to prosecute a murder here. So no, they're not going to. If this jury finds Karen not guilty of homicide, then nobody is going to be charged or pursued with homicide of John. Nobody besides her, because the feds aren't going to have jurisdiction to do it. And do we think the Commonwealth is going to backpedal now and look at somebody else? I don't. I definitely don't. They would just double down on the jury got it wrong. It's what they often do. The squid. Let's say Karen is found not guilty and the Commonwealth decided to go after the real culprits, whoever they are. We'll put ourselves in this imaginary land because I think that's all it's going to be. Would that new case be DOA because the defendants would have legit third-party culprit defense? If they went after the third party, are you saying and the third party would say Karen did it? I mean, I think they could try to say Karen did it, but it seems hard to see how that wouldn't somehow open the door to Karen has been found not guilty of doing it by a jury. But that is in general the problem with it, because now the Commonwealth has pursued inconsistent theories. You spent 3.5 years insisting that it was Karen Reed. You spent $10 million. I don't even know how much at this point. How much have they spent on this prosecution to try to prove that it's Karen Reed? And now, my client, Johnny come lately, you couldn't get her convicted. So you want to come at him. That's the general issue with trying to prosecute somebody else after you've had an initial failed prosecution, is you've changed your theory. And so the fact that you believe something different initially, like this wasn't your first choice. This wasn't your first choice of a case. It was your second choice. You couldn't get her convicted. So now you're going with your second choice. It's just kind of baked into that process. So I think that's part of the reason why you don't see it very often. They know it would look inconsistent, but I think also just psychologically, once they've decided they're going down this road, they're dug in. They have the tunnel vision. They're convinced they're right, so they're not going to change their minds. Cat, QQQ, if it occurred to a juror, would you want them thinking, what is better for Karen Reed if they know it will be hung, or prefer they stand firm? Would you want retrial factors in mind when deciding a verdict? I mean, I think that's what the jury wants, and that's why they're asking these questions, because they are trying to do their job. They want to be diligent. They don't want to be causing a problem for somebody else. And so if it's an issue of we sincerely can't come to an agreement, and whatever will be because of that, they want to know, like, they're just not comfortable with that situation. They're not comfortable with whatever will be. So I think they're telling us with this question, they want to know, how bad is it going to be if we don't resolve our conflict on count 2? So they don't want to create a problem for another jury down the road. They may not want to create a problem for Karen. They may not want to spend the money, for the Commonwealth to prosecute it. As far as like, what do I, if I'm the attorney or something like that, what do I want the jury to be thinking about that? Yes and no, yes and no. I see the upside of the jury knowing, look, if you hang on this, we're going to have to come back and do this all over again with a homicide charge, with the manslaughter. So it would really help if you came to a decision, but at the same time, now you're telling them convict. You're just telling them convict on OUI, so we don't have to do this. And they could have done that in closing. Like, I don't know. I don't know. I don't know what to make of the defense strategy on this. I really don't. It really seems like it's they wanted the door open for an option, but they didn't want it to be like such an easy option that you would advocate for it. So I do think it's natural for the jury to wonder, what's it going to mean? We want to do the job. We don't want this to be somebody else's problem. Michael Oldham would be tempted to research if no help from JC. Didn't think about that. Hopefully they will not fall prey to that temptation. Somebody goes and researches and then gets, bring it into the jury room. They're going to get snitched out. It happens all the time. It's almost a certainty that it would. It is misconduct. It's specifically in their instructions that they can't do that. So if that gets outed, then the juror is getting questioned and getting removed. And then we have to bring in the alternate and we have to start everything all over again. You got to start the deliberations all over from zero. So everything that we did yesterday, going over the remember when, you got to do that all over again with a new jury. Now, there's no rule that says you have to do it exactly the same way. But the idea is you got to start from scratch. You don't get to be like, hey, 11 of us are agreed on this, so you're on board, right? I hope they don't do this, but I do understand. Yeah, makes sense. You're not going to be helpful. The jury's asking for help. They made it clear they need help. They want help. You're not giving it to them. What are they supposed to do? The squid, regarding my previous chat, I don't believe the Commonwealth would ever do the right thing. Yeah, as far as prosecuting the real perpetrator. I'm just wondering how much damage they did to the idea of justice. Yeah. I'm not counting on justice in Norfolk County personally. Just me, but that's just me. I'm not. I would say, yeah, my confidence in the system over here is pretty thoroughly undermined. pretty sure I'm not feeling the integrity of the system over here, but that is just me. I think there's been massive damage. Let me just reiterate one more time. If we are in fact at a point where the jury is arguing over whether we're going to convict Karen Reed of OUI when she is on video admitting shouldn't have been driving. Yeah, I'd been drinking 4, 5, 6 drinks. Probably not as safe driving as if I hadn't had anything at all to drink. You can't even convict her of that. That's because this jury doesn't like you, doesn't trust you, doesn't think much of your system either. I think there's been a massive amount of damage. Catalina, as someone in the jury's age bracket, seeing those cuts on the video makes me throw them all out. We've all seen what a bad cut can do to someone. Yeah, the interviews where it's just cherry picked and you don't know what they're talking about. Even the whole, like, the drink count ended up 4, 5, 6 drinks. I'm not convinced she wasn't talking about freaking Yuri Buchanan's drink count and not her actual drink count that she had from her own memory there in the waterfall. We don't know. Not in the waterfall, and it was mostly in CF McCarthy's. And she described it as weak drink. And so I got the shot. It was a weak drink. So I got the shot and I put it in, and then that happened again. And I mean, even with her like describing it, I didn't get to a 6 drink count. I don't think I got to any point where the count of what we actually saw in the video was 6 drinks. So yeah, I'm going to be skeptical of it. It's this is such a good point. Like, we're in the reality TV era now. Everybody knows it's all about the edit. You can edit anything to tell the story that you want it to tell. That doesn't seem like a revolutionary concept. So this is a good observation. I think, because that is something that might be a little bit different generationally, that the younger generation is totally used to, like, edits, being off, edits being distorting, edits not being the full picture. But older people are more accustomed to long form and kind of the old ways of doing things. And video is really good evidence, that kind of thing. So I could see that. I could see that potentially being an issue. Brenda, in my humble opinion, OUI charge doesn't matter if she did hit him. Yeah. If the jury thinks she hit him, I don't think we're arguing about OUI. I think we're arguing about what degree of homicide are we finding her guilty of. That's why, to me, it seems very clear that that's not what the jury's hang up is. T-Shaw, let's be honest. If she got pulled over that night driving with John O'Keefe, she would not have gotten an OUI. We'll never know is the thing. I mean, here's the thing. It's so easy to get an OUI. It's so easy to get an OUI. We don't know what she would have blown. That's the $1 million question. Can I tell you that a cop that wants to take her in for OUI would be able to find that she failed field sobriety tests? Yes, they will. They will write their same formulaic police report that they write for everybody else. She had glassy, bloodshot, and watery eyes. Her speech was slurred, and there was an odor of intoxicants emanating from her person. The field sobriety tests are made to fail. Like if they wanted to arrest her, yeah, they could. I don't think that's difficult at all. Have I told you guys a story about, I don't trust like the breath test machines and stuff like that either. I really don't. Did I tell you guys a story about the conference that I went to? It was a defender conference. It was just on DUIs many, many, many years ago. But somebody had what was, back then the machine that everybody used for the breath test in Washington. It was the data master back in the day. And so part of the presentation had a girl who was average height, weight, and everything, probably 5'6", 140, something like that. And gave her some shots, gave her a shot, had her blow, wait a little bit, have her blow, give her another shot, have her blow, wait a little bit, give her another shot, just so you can see what breath test you get, what result you get, and how it aggregates over time and everything. And guys, it only took two drinks in half an hour, and she's over the limit according to the breath machine. I'm just average size. Karen's going to be a little bit smaller than that. So I'm not convinced that they wouldn't find a way if they were so inclined to do it. And by the time they've pulled you over and started asking those questions, usually they're already inclined to do it. But we'll never know. It's a counterfactual. We'll never know. Mid-Michigan Aviation. Could the jury ask, we are unanimously not guilty on every charge except OUI and need clear instructions for how to record this correctly on the form? They absolutely can ask it. If the question is, will they get an answer if they ask that? Who knows? Not required. Not required that the judge answer this. And I'm skeptical that she would. I'm very skeptical that she would. Just tell them, reread the verdict form, reread the instructions. Told you everything I can tell you about how to record your verdict. Jaron, find any media's comment section. That is your jury. Common sense, critical thinking are gone. I can't imagine choosing to risk my life on a jury trial. I don't necessarily think that the jury pool is the same. It's the same sample as the comment section. For a lot of different reasons, maybe more so in Massachusetts. I keep coming back to Massachusetts has a very different manner of selecting their jury pool than most of the other states I've ever seen. Most states you're pulling from the driver's license, registration, and voter registration, and those are where you get your name. So if you don't have a driver's license and you don't register to vote, you're not going to get called for the jury. So you just end up with skew in the population that ends up ever being called into the courtroom at all. And by and large, I got to think that skew is not going to align with folks, those of us who hang out all day on the trial. I mean, yeah, some of us do, but the bulk, I don't know. I'm just not sure that's really the same cohort. But, risking the life on a jury trial, it is tough, but do you trust a judge more? Do you trust Judge Bev more in this situation? I don't. I just don't trust the judge. I mean, Turtle Boy is proof that sometimes the judge can get it right. But I don't like that risk. I like the idea of the Commonwealth having to convince 12 people a lot more than I like the idea of the Commonwealth having to convince one. But these are tough calls. I do worry a little bit about the jury composition, and it's mainly the civics, the lack of education that we have about civics anymore. God, you want to get real depressed? Watch like some of those man on the street interviews. Who's the president? I'm not the most. Okay, I'm very uninterested in politics these days. Somebody super chatted me the other day about Army 250th anniversary parade. Have no idea what that's referring to. I don't know, guys. I'm not following the news on that stuff. Jeff had to tell me, oh yeah, there's like a bunch of protests going on this weekend. So no, I don't know. Very out of the loop on that. But you see like men on the street videos, and people just don't know basic things about the system. It can be a little bit depressing. Teresa Kaufman, seriously, how do they correctly complete the form to find her guilty of driving OUI only? You have been my refuge in this horrible story. Thank you. So at some point, maybe we'll get to see the form and we can confirm this. But what it sounds like to me is that you would leave the entire form blank, except for at the very bottom where there's a little space and it's OUI, and you would check that box. She's guilty of that. And then you would sign the verdict form. And that's how you would indicate that. Only OUI that she's convicted of. You just leave everything else blank. It's hard to take that on faith, isn't it? That you just leave it blank and that means that has legal significance because you filled out this other one. I think it's natural for people to think, we should like, there should be something to indicate how we found on all of these. That's why the defense wants the not guilty option for each one of them. But that's just not what they're going to get. It's confusing. Hopefully the revised instruction, the revised verdict form makes it easier for them to follow. Bradley Brown is a new YouTube member. Welcome to the channel. Summertime, you think OUI would be time served at this point? In a normal case, you would, right? She hasn't actually done a lot of time, right? Because she's bailed out. She got arrested. She bailed out, so she didn't actually do much in the way of time. And then the statute that we just looked at earlier in the show for OUI and the suspension, the license suspension, it seems to contemplate there's 2 different ways your license can get suspended, and they don't like run concurrently. They run independently of each other. So she wouldn't apparently get time served for something like that. But it's just such an unusual situation. Most of the time with the DUI, you're dealing with the person was arrested and charged with that at the time. And so they have a breath result. That breath result gets sent over to whoever handles the licensing, driver's licensing in your state. Washington, it's the Department of Licensing, and they take action automatically based on just having that breath test result faxed to them by a law enforcement agency. They go ahead and suspend your license. They've got their own administrative process to do that. And then you might separately get a mandatory suspension as a consequence of being convicted in court. But in Washington, those things will run concurrently. An administrative suspension that you got because of that breath test, and then a court-imposed suspension that you got by virtue of being convicted. But Massachusetts law says very clearly they don't do that. So I don't think there's really time served other than just a little bit amount of time that she did because she got booked in and I think had to spend the night before she got bailed out. That said, it's probably very possibly a night more than a lot of people Charged with OUI, spend in jail. I don't know. I guess it's not that uncommon to spend a night in jail because they don't arrest you and book you in and then, cut you loose to go drive yourself home. They tend to at least keep you in until like you're sober or something. But the Danish doll, she's Aunt Lydia in The Handmaid's Tale. Brilliant. Aunt Lydia was the facilitator, wasn't she? Caitlin C. Can juror look up law at home to answer question? Bev wouldn't. It's not the facts of the case. It's the law that we all have to live by. They may not, and if they do, it will be a problem. It's outside research. I think it might be in the instructions. Let me see if I can find that real quick in the model instructions. Let's see. Research. You must not do any kind of research about this case. You may not do so in any way, including with an electronic device such as a cell phone or tablet. This also applies to the alternate jurors. So that's very universal. That's there in the form instructions that they're given on how to conduct their deliberations. Now, Bev doesn't always give the form, so I don't remember, if that was a specific language that she gave in this case. But generally speaking, now any research is off the table. You take the law from her. They decide the facts based on the evidence and only the evidence at trial. So if somebody were to go and research, it would be a problem. It would be misconduct. We'd be having hearings, and that jury's probably getting booted. Melissa Garcia, law tubers to replace Reed team. Who you picking? I've said from day one, the law tuber I don't want to go up against in a courtroom. I don't want to see over at opposing counsel table is Peter Tragos. That would be a nightmare. I would be very worried about my ability to capture the jury and give them the better explanation, the better reason for why they should say things my way. So. Pete, make sure your number's listed if there's another hung jury. Robbie, it just seems antithetical to our judicial system that Bev is unwilling to make the verdict slip crystal clear and remove all confusion for the jury. Maybe from a philosophical perspective, the whole process of dealing with count 2 and the lesser included, it's already a convoluted and confusing process, and it may simply not be possible to dispel all confusion. We might be asking too much of the linguistic process that ultimately the law is. Okay, the law happens in words, through words. And words have ambiguities built into them. I'm not trying to go like to Derrida, okay? Those of you smarties in the chat will know. I'm not talking about some pharmacon here, okay? But it is. The joke there. There's a work that Jacques Derrida is a deconstructionist philosopher. And his idea is that basically language is inherently meaningless, and we're constantly in a process of like assigning meaning to words. The words themselves, they aren't. There's no essential meaning, and so he uses the example of pharmacon, which is the Greek word. It can mean drug. It can mean poison. It entirely depends on the context. It's that whole idea of the poison makes the dose makes the poison, right? What is oxygen, water? Very good for you until you get into dosing issues where it becomes very, very bad for you. So that's the kind of idea that he works at with language. That it's always inherently ambiguous. So I think there's just, without knowing and being willing to guide the jury through, we know where you're trying to get. Here's how you get there. And it's just not clear to me that there is a way that would satisfy everybody, that makes it crystal clear and no room for any ambiguity at all. It's just, we're dealing with language. There's kind of always the potential for misunderstandings in there. But to not at least, try a little bit harder, I don't know, not even be willing to consider just to get a proposal from the defense. No, barely done talking and you're no, not doing that. You could at least consider the possibility, maybe revising things a little bit. Jilly Bean, people say if I was innocent, I would be screaming from the rooftops. Haters' videos were her screaming from the rooftops. That's true. The videos were her testimony. It was her chance to tell her story, right? That's what she said in her words. These were her testimony. She is trying to scream from the rooftops, but she didn't get on the stand, and that's what the haters and folks who will go ahead and penalize somebody for exercising their rights, even though the instructions say you can't. They want to hear her testify. They want to hear her get on the stand and answer questions and be insulted and belittled and treated badly by Brennan, just like all the other witnesses. She doesn't have to, but there will always be people out there that want to penalize her for that. So Yinzer, yes, proud Pittsburgher here. Okay, I had to be clear because I wasn't sure. You're going to have to forgive my ignorance, but I wasn't sure if Yins was with an I or with a U. I wasn't sure if it was Yins or like Yins. These distinctions matter, guys. I'm a connoisseur of like these regional dialect stuff. I got to know, is it Yins or Yins? Thanks for answering that one for me. Nicole K, say the jury hangs and we find out after it was only on the OUI. You still think Commonwealth will retry? Taxpayers won't like that optics are bad. Taxpayers won't like that optics are bad. Optics are terrible, but would they? The optics have been kind of bad so far already, haven't they? You couldn't convict her. And we already had a jury, 5. Was it 5 at final count that came out and said, we did acquit her of murder? And they still retried her on that. So I don't know that it would matter if it's not legally binding. I don't think they care about the optics. Does Morrissey think it would save his position if he backs off now? Would it? Would it save his position if he backs off now? I really don't know. Yeah, I think that barring a legal reason not to retry her for voluntary manslaughter, then of course they do that. That's their leverage. They're not going to give it up. It still remains out there. Hey, Karen, you can make all this go away by just pleading. Just plead. Okay, we're not going to let you walk with just a OUI, but maybe the motor vehicle homicide. Just plead to that. No, it's all their leverage. So I think they absolutely hang on to that if they can get it. Byron Butterfield, let's say the jury is trying to say hung only on the OUI, but not guilty of manslaughter and want to take everything else off the table. How do we mark this? Seems to be the issue, isn't it? Also, wasn't Sandra Birchmore obstruction by death of a witness? Yeah, I think that was the federal hook in that one. The fact that she was the witness to the crime being, the exploitation of her as a child. I think that's the theory for that being federal jurisdiction. But we don't have something like that here. There's no indication that John is a witness to anything, or that him being killed is related to that in any way. Really seems like this is not an intentional killing. It's just things went wrong and bad decisions were made about how to deal with it and try to avoid consequences for it and so forth. We'll never know, unless and until somebody who was there decides to tell us what the true story is. But yeah, I mean, let's say the jury is trying to say hung only on the OUI, but not guilty of manslaughter and want to take everything off the table. I'm right there with you. I think that's what we're dealing with. I think that's what we're dealing with. And they just want to be clear. Is there a trick here? We don't trust you. We don't trust you, the institution. We don't trust the legal process. We don't trust it. So is that going to have the effect we think it does? If this is the direction that we're going? Rueri. If this ends up in another mistrial, do you think Hanky will be on the prosecution for round 3? Rory, thank you. My name is pronounced Rory. You gave it a good try last night. Thank you, Rory. Thanks for your streams. Been following with you and EDB. Well, that's great company to have me in. Thank you for making time for me when you have Emily D. Baker you could be listening to. That girl is I enjoy listening to Emily. She's a hoot, man. She's got some good insight a lot of the time, good takes on what happens in a trial. Oh, good question. Would it be Hank? I mean, so at this point, decent chance, right? Hank is going to end up doing worse than Lally. Okay, Lally got a hung jury on all three charges. Decent chance the best Hank is going to be able to do is a mistrial on count 2. So he's already done worse than Lally, but you've paid him twice as much. Your hand-selected guy. It's hard to justify continuing to do that if you're not getting the results for it. Just give it back to Lally. I could see giving it back to Lally. Hard to justify continuing to pay a special prosecutor to retry it again. Do you pick yet another special prosecutor? That would be even harder to justify, just because the expense of the time that it takes to get up to speed on a case. That's like the biggest switching cost you have whenever you get a new lawyer. Like, just assume one of the big reasons not to change lawyers in a case, because you're going to be paying the new lawyer to do all of the stuff that your first lawyer did to get up to speed. So you're going to be paying again for duplication. Not something I would think the taxpayers would be real thrilled about. Let's pay another special prosecutor to get up to speed. I could see giving it back to Lally. Ahap, if a grumpy, hungover Danny DeVito in a blonde wig hasn't cast his Bev, I'm not watching. You could do worse. But now we're definitely in farce territory with this production. So we just have to bear in mind. Amy Inez, off topic, but wanted to share my thoughts and prayers for the Decker family for the loss of the girls and hope they find Travis soon. I'm from Wenatchee and it's been devastating. Love your channels and thank you. Yeah, that has been a really awful story coming out of Wenatchee, Chelan County over there. Terrible story. If you guys haven't heard about that, appears to be a domestic situation that went very, very badly. A conflict relating to custody of the daughters, young children. Daughters were in father's custody. They were found deceased. Found, I think, with his truck abandoned, and he has just vanished. They're currently still looking for him. Not sure if they have any clue where he is. So not sure yet. I'm watching that situation. Of course, it's not clear yet if that is going to actually turn into a case or not, because it depends on if they find him. And if they do, is he still in a living state or not? Kind of controls whether you get to pursue a prosecution or not. But just ultimately a really sad situation. It's hard for stuff like that to happen in a community like Wenatchee, not a real high crime area. So, homicides and stuff like that, especially this type of crime, really, really devastating. So yes, thoughts and prayers for the Decker family. And we will be hoping that they get some answers soon. Prime Finder, is it correct that OUI was not in the first trial? That's my recollection. It was not a standalone. The last of the lesser includeds was the motor vehicle homicide. Was there any evidence testimony in this trial to support OUI? It's circumstantial. The clips don't prove anything, in my opinion. Thank you. It just goes to the weight. You give the clips little weight, but the jury is entitled to give the tapes definitive weight if they want to do that and say she said it, therefore we're done. They can. They're allowed to do that, legally speaking. So that in and of itself is enough to get you to OUI if they want to credit that. Just treat it as she's admitting she was affected by alcohol at the time she was driving. She said so herself. Otherwise, it's circumstantial. DGA S33. With regard to the interviews of Karen Reed and how they were cut, the listener doesn't even hear the question that was asked to Karen. Yeah, that's a very good point. It's a very good point. It's an important part of the context is knowing exactly what she's responding to. That would help us understand, for example, when she says the final drink count was, if we knew the question was, how many drinks did Yuri end up saying that you had anyway, versus do you have an independent memory of how many drinks you had? It sheds a whole different light on what she's saying when she gives that answer. And so we don't know that. We're deprived of that context. The jury is deprived of that context. Question just remains, so do you discount it because of that? Or do you go ahead and accept, well, seems like it's saying this, so she's on tape, there it is. That could potentially be generational, like was pointed out earlier. Dog bite community member. You're a member of the dog bite community. How do you get to be in the fingers through the brain community? How many people are in that community? I live 5 minutes from Karen's parents, used to be their neighbor. If this happened to most people, they would have been screwed. Most people can't afford to pay for this amazing defense witnesses. It's true. It's true. Most people just back this up because I stand for my public defenders, right? I recognize, yes, there are some bad eggs, and it doesn't necessarily draw the best and brightest of the legal minds unless they really do believe in the mission. So you kind of get extremes that way, but I just want to point out, all I'm trying to say here is that somebody could have a public defender who would absolutely kick ass. Okay. There are public defenders that are they're completely unsung heroes. They are some of the best lawyers you would ever see because they try cases day in and day out. And they would try circles around, a private lawyer who hasn't had nearly that much experience compared to them. But the reason I bring this up is because you can get arrested for something like this and not be in the position of being able to hire the lawyer and still put up a good fight if you get a good public defender. And there are good public defenders out there. However, what you may not be able to do is bail yourself out. What you may not be able to do is bail yourself out. And that's a major part of the thumb screw when it comes to getting people to just plead guilty, just get it done. Because the issue isn't so much, is my lawyer willing to fight? Can I get the resources to be able to put on a decent defense? It's, can I sit here in jail until we get to trial? We're 2.5 years down the road. How many people are going to be like, yeah, if I haven't been able to make bail, I've been sitting here for 2.5 years so I could vindicate my rights? Not that many people. So if you don't have the money for bail, that is like one of the biggest turning points that I think I see in terms of, does this case have a chance of going forward to trial? Far more often, I'm visiting my client in the jail and it's early in the case and we're going over the police reports and we're talking about the options and what should you do. And, this looks really good. There's a lot of holes in this. I think this you know, I'll interview this witness, and if they don't come off really well, I think we got a really good chance. Yeah, but how long is it going to take? My kids need me. I'm not working. I'm not making any money. It sucks in here. The food is really bad. If I just plead guilty, they'll let me go right now and I can go back to my life. Can't tell you how many times you hear something like that. So to me, that's the big turning point. Whether you're going to see justice or not, can you afford to make bail? My idea. Bev was upheld in multiple appeals courts re-instructions. She's going to feel that justifies not changing her mind. But if this is the standard format, how many other juries struggle with this? I mean, the fact that in this very case, a previous jury apparently struggled with this should be a pretty good indication that perhaps there's a problem here. It's not everybody else. It's not all of the jurors that are the problem here. It could in fact be your form, or perhaps your confusing and illogical process dealing with lesser included offenses. I haven't seen that this verdict form is standard format. Let me, pretty sure I looked. I have not seen anything in the form instructions for these charges that give them. It's the lesser included offense instruction. Where is that? Let me find it. All right. We've looked at this one before. This is kind of old, but it's the one I was able to find. So let me just pull it up and share it. Try to make it nice and big. Okay. Here we go. The offense of blank includes the lesser included offense of blank. As a matter of law, wait, can you guys see this? Yes. As a matter of law, the complaint that is before you, which charges the defendant with blank, also charges him or her with that lesser included offense. The Commonwealth may prove the lesser included charge of blank, even if it fails to prove the greater charge of blank. You may find the defendant guilty of the lesser, so OUI, only if you are not convinced beyond a reasonable doubt that the defendant is guilty of manslaughter. And you are convinced beyond a reasonable doubt that the defendant is guilty of lesser included offense. Does this seem like a little bit more logical and sensible? Oh, wait, is this even Massachusetts? Oh, for heaven's sake. This isn't even Massachusetts. It looks a lot like the form. Is it? No, this is Massachusetts. It's citing Massachusetts law. I just got confused here because it says the model charge is adapted in part from recommended Arizona jury instructions, and also from the manual of model jury instructions for the Ninth Circuit. We're not in the Ninth Circuit or anywhere near it, but all the case law here is to Massachusetts stuff. So this is a district court instruction. We know that because it's talking about the complaint and not the indictment. But the instructions do say if you don't have one for superior, you can use the district court ones as a model on something. So they could have used something like this as a model. Does this make it more clear what it means to kind of systematically work through these? This is what the form is. There isn't a form for superior court that I've seen. So I don't know what Bev has had reviewed, what has been affirmed or not affirmed. I don't know. But there doesn't seem to be a form verdict, like a form verdict form for them to go with, at least not that I've seen. Nana Geek Joe Ellen, could you explain why they needed to pay a special prosecutor when there were plenty of them in their own office? Hashtag FKR. Well, we don't know. It would be nice to have an explanation for that, wouldn't we? We would like to have that explanation. Why does the prosecutor think that it's necessary? Why would you not just, I don't know, assign it to a prosecutor in your office? And if they don't want to do it, well, that's a little thing called insubordination, and people often lose their jobs for something like that. We know that Mr. Morrissey himself cannot prosecute it because he has been disqualified by the court, but not his entire office. The attorneys in his office are able to do it. Lally was able to do it before, and Lally seems willing to show up here in court. McLaughlin seems willing to show up here in court. So it doesn't seem like they have a principled objection to the prosecution. So why do you got to bring in the special prosecutor? Only inference I can really draw from it is the ones you had, you didn't think they did a good enough job. You need someone better than the people you're already paying. That's why you're paying a premium to ostensibly get that. That's a question that somebody needs to ask Mr. Morrissey. Why are we paying a special prosecutor when there's plenty of people in your office? 2 of them showing up every day of this trial, as a matter of fact. Sar Robbie, how are we to have faith in our judiciary if at least attempting to remove any confusion for the jury isn't the intention and goal of every judge? Their goal is self-interest. I mean, they're like anybody else, kind of that way. They just self-preservation. They want to not be reversed, and so they're going to take the safe outcome. And the safe outcome most of the time is do nothing. Do nothing. The more you change things, the more you flail around, the more you're making a decision that potentially then is going to be a basis to reverse you. It's a potential point where you made a mistake. So they just try to minimize that. This is just a factor of the system being carried out by human beings who are extremely fallible, have their own interests in mind. You know, it's different in the conceiving of it than it is in the carrying it out. It's easy to conceive of, well, as a matter of principle, given the role of the judge, of course the judge would want to dispel the confusion of the jury. But if you're not taking into account the practical effect that doing so increases the risk that the judge is going to make a mistake and get reversed and then be embarrassed and then have to do the trial over again, etc. Well, then the practical standpoint is it makes sense why they don't. So you have a situation where the incentives conflict with the principle. Probably most of the time, the incentives are going to win out over the principle. The squid, for anyone wondering, the reason the feds got involved originally is because they were already investigating MSP for corruption and bribery, including issuances of CDLs. They likely couldn't link Proctor federal crimes. Possibly, yeah. I remember seeing something coming up where I think they did hand down some indictments on this, where it was like a scheme that because the MSPs involved in like getting a license, a commercial driver's license, they were like somehow able to, or maybe did they have sidelines where they did the testing for the CDLs? God, now I forget what the details was of this particular case. But basically it was a situation where, people were getting, I think it was cops off duty doing the CDL testing. And so they would get paid. Hey, my brother-in-law, my brother-in-law's coming in to do his test, take care of him. Sure, no problem. And, just pass it, make it an easy pass. So I do remember seeing that. But frankly, I've seen a few different cases of official corruption come out of Massachusetts in just the last couple of years. So it's really hard to know what they focused on. The overlap in the players with this and the Sandra Birchmore case makes it hard to not see that as a potential connection as well. because that of course happened a year before John died. If you're already investigating these shady people, are you maybe going to be interested in other shady actions that they've been involved in? You know, seems like a logical hook, but we don't know, and we won't ever know unless somebody decides to tell us on the record and officially. By the way, I'm very skeptical of that. I'm telling you, so you have to believe it, that we got from Chief Rafferty and from Hank Brennan. I'm sorry, I don't believe it. I'll wait and get it from the source. Call me skeptical. DHEC34. I really struggle with guilty verdicts on OUI only because there's so much reasonable doubt. Also, they didn't even observe her driving. It's also weird. They don't have to observe her driving. It's circumstantial. People saw her in the driver's seat. You know, you can infer from that. But I think for me, if I were considering it, I think I would probably have an issue with the blood alcohol, the blood draw. If the blood draw was 0.93 milligrams per deciliter serum, that was a serum. So then we got to convert it to blood, and converting it to blood, I forget the exact math, but I want to say it was somewhere like 0.8889, maybe 0.87. 0.87 at 9 in the morning. You're going to have a hard time getting me to she was over the limit 4 hours before. So we just don't know. There's too much gray area in all of this. Because I mean, if you're buying that she was over the limit 4 hours before 9 o'clock. Okay, say it's 0.02 an hour roughly elimination rate. That means she's like 0.16 at 5 when she's out driving around. If we buy that, why like, are we assuming then she got up at 5 and drank? It's just hard for me to distinguish between what you could safely assume about her condition that morning and how she was in the night before. Like, why even distinguish? It seems like if you're willing to say she's guilty at 5 o'clock, why would she be guilty at 5 and not at 12 just because of the maybe she came home and drank? I guess. I don't know. I I'm with you as far as reasonable doubt goes. I don't see it, but I can also see people saying, well, she said she admitted it. So I consider talk pretty cheap. That wouldn't be enough for me, but I can understand how it would be for some people. Marla Hooch, is the issue on the OUI now about an unclear indictment without a time specified for OUI? Jury is left to fight nuisance like an attorney. Misstep by defense. I don't think so. I would suspect that it's rare for an indictment to include a time at all. It's not required. It's not required. I really think this is just a situation where it's kind of like Hank Brennan said. They've always been focused on what happened before Karen Reed went back to One Meadows. That's been the focus of the criminal inquiry. And it's just never really crossed anybody's mind that, oh yeah, that actually is an implication that maybe she committed DUI hours later at 5 in the morning. And she went and left then. They didn't seek an independent indictment on OUI at all anyway, So it's just an afterthought. I don't think it's an issue of the indictment being unclear. It's an afterthought. It always was. Seems like the Commonwealth didn't even want it. So is it the indictment that's unclear? I mean, not really. It usually says on or about, doesn't it? Let's pull it up. Says on or about, pretty sure. Yeah, on or about January 29th, 2022. Kieran Reed did do X, Y, or Z. That is standard charging language, and they use that in part because it does give them a little flexibility. They can be a little bit wrong. They're not guaranteeing it was on January 29th, 2022. They're just saying generally in this time frame, somewhere around then. But if I'm off by a day or two, it doesn't kill the indictment. If I'm off by a little bit, does it kill the indictment? It doesn't typically kill the charge. So I'd be surprised if it was normal for there to be a time charge in the indictment. The issue here is just that this is technically two separate factual grounds to charge her with DUI, and I'm just not sure anybody had really given that any thought because nobody really cares. The Commonwealth seems like they don't really care about OUI, so just not thinking real deeply about potential problems with that. Watchdog is gifted 10 Andrea Burkhart memberships. Thank you, Watchdog. Appreciate that. We love seeing the chat light up in green. Music to my soul. I think they structure the form that way because they don't allow partial verdicts on the lesser includeds, so they don't want to allow the jury to find not guilty on individual charges on account. Thoughts? Exactly right. This is exactly right, because that's what happened in Roth. The jury was given the option to come back and explicitly acquit on the lesser includeds, and the Supreme Judicial Court said, no, that's not how we do it in Massachusetts. But because you went and did that, we have to honor double jeopardy and not retry on those ones. But everybody in the future, don't do it like this. So that's exactly why, because yes, if they mark not guilty on the lessers, pretty good argument that the double jeopardy is going to attach. And she can't be retried on that. So they're not going to give her the option. Roth precludes that. Despite the look on my face, you're still talking. Everyone, understandably, gives Karen shit for talking. But in her case, interviews generated public interest and subsequent donations necessary to fight the state. Also, check out Schneider pens. Okay, I'll write that down. Schneider. I'll check them out. I have to look up and see where I even find those. I agree. There was a cost benefit analysis that went into the decision to do the interviews. I don't think there can really be any debate about that. There is a reason why they chose. Everybody knows, certainly the lawyers, every lawyer involved in this discussion about whether the interviews are going to happen or not. They all know, of course, there's a risk in doing it. And so they made a decision. It's a calculated risk that they took because they had to consider, what are we getting out of doing it? And yeah, the public support and getting people on her side, filling the war chest. I mean, yeah, these had to be considerations for her. So if those benefited, then potentially it was a good decision, especially if at the end of the day, the worst case scenario we're talking about right now is her walking out, maybe being convicted of an OUI. That's a pretty good trade-off. Wicked Psyched. Hiring a special prosecutor in this case sounds like a taxpayer-funded no-bid contract. The state said conflict of interest. They didn't, though. If they had said conflict of interest, we wouldn't have Lally and McLaughlin sitting there in the courtroom. If there was a reason they couldn't prosecute the case because of a conflict of interest, they wouldn't be in the courtroom involved in prosecuting the case. So Brennan is just an add-on. He's not a replacement. He's not necessary. He's a choice that they made to add on to what they already have available to prosecute the case in their office. Sounds like a taxpayer-funded no-bid contract. I don't know if they bid or not, but I can be reasonably confident that, Hank Brennan or Michael Morrissey handpicked Hank Brennan. I don't know if he specifically solicited bids or went through a formal process like that or anything, but I would think he solicited interest in taking on the role, whether formally or informally, and interviewed the options, the candidates, see who looks good, who he likes as an option. Maybe price is a consideration in that, but maybe it isn't. Not clear to me at all. It looks to me like Michael Morrissey got to just sort of unilaterally choose to spend a whole bunch of taxpayer money on Hank Brennan. And here we are. Not clear that there's really any limit on that, which is a little bit strange as far as the process goes. But like I wonder about things like, is it coming out of the district attorney's budget? See, budgeting, like when you want to get into like the politics of decision making and stuff like that. Oh God, go to some public meetings when they're talking budgets, because that's where a lot of the fight happens. You know, somebody spent this on this and they're trying to put it under this line item, but this other agency also draws out of that line item and they don't like it. So we're fighting over, you know, where does the money get budgeted from? It should come out of the district attorney's budget, should it not? They should not be able to just generally obligate the state treasury or even the county treasury to pay for what seems to be a special wish, a little luxury for the elected prosecutor. Why should he have the authority to go ahead and modify everybody else's budget? You only have the money you have, but he can just decide, spend whatever. No, it should come out of his budget. I just don't know if it does. I would love to know. Transient man testimony said they used a moist towelette to sterilize for the blood draw. They did indeed. I work in medical research. Sounds like an alcohol wipe to me. It does, and I'll tell you why. I looked this up when it happened. Like, is a moist towelette, is this a term of art? Like, is this one of those things where it means something specifically in advertising, and it has to have certain qualities to characterize as a moist towelette? And I didn't see anything to that effect. I saw that a moist towelette can be, most commonly is either alcohol sanitized or it's just sterilized water. But here's the issue. If it's just water on the moist towelette, the whole purpose of using the towelette on your arm is to sterilize your arm. Water is not going to do that. Water is just going to get your arm wet. There's no reason to just get your arm wet to draw your blood. The whole point is to sterilize the arm. So if it's not an alternative sterilizer that you're using, like what you claimed in the first trial, which is that you used betadine. That's what they claimed in the first trial. And that makes sense. That's common. It's alternative form of sterilization. But a moist towelette, even if it's not alcohol, then it's just water, and you have a non-sterile blood draw taking place. That's not good either. I have a very hard time believing the testimony about this. Both trials. The first trial, the way around this issue was they claimed that they had taken all of the alcohol swabs out of the blood draw room. This made absolutely no sense because they're also acknowledging you almost never do DUI related blood draws. You're doing clinical stuff. And if you're doing clinical stuff, it doesn't matter if you do the sterilizing with the towelette. You're going to get close enough. And now in this trial, like we've abandoned the betadine and now we're using a moist towelette, but it's not sterilizing if it's not alcohol. If it's just wet water, why are you even using it? Doesn't make any sense to me. I think they probably did use an alcohol swab. That's why we've gotten the inconsistent explanations and why the explanations that they are giving don't really make a lot of sense. Show your teeth. Hey, Andrea, happy to see you're online. I watched Defense Diaries all day. Good for you. And was itching for some juror question convo. Love the channel. Well, as soon as I saw things were in fact going to happen today, I did. I had, planning more than likely. I kind of anticipated there probably would be stuff today. So I kind of already anticipated doing that. But I will confess the jury got moving a little bit earlier than I expected they would. Caught me outside messing with the chickens. Had to get things tied up before I could come in and address it. But yeah, I was also watching Defense Diaries when it happened live. So good choice for you guys. So tomorrow, I guess I better be ready for an early start tomorrow, huh? Not right at 9. Surely not right at 9. But I got to think we're going to know pretty soon, early on in the morning, is this fruitful or not? Are we making progress? Are we going to reach a verdict on OUI or not? They're going to have that sorted out pretty quickly. They had all afternoon, didn't get it resolved. So now they're going to sleep on it overnight and think about what can we live with in terms of an outcome. And they'll come back in tomorrow and they'll take everybody's temperature again and they'll figure out real quick, are we going to be able to come to some kind of consensus that we can all live with? Or are we stuck? Shouldn't take them that long to figure that out. So I'm anticipating probably something happening fairly early tomorrow morning. So I'm not going to once again, I'm not going to get up and anticipate that something is happening and go on and stream if there's nothing. I will wait until there's some kind of news, but I am going to be prepared for the possibility that news is going to come early. And so do my best to be available so we can watch that happening live if it does. But there is another little complicating thing going on tomorrow, which is that we have the Koberger hearing. And I already told you guys, need to watch that, need to live stream that, because it's a very important decision to make over, is this trial even going to go ahead in July or is it not? And what's the thought process behind it? Is it because of the media? There's more stuff coming out in the media. To what extent does that contribute? Because that might have some possibility of, I don't know. I hate to think that the media might actually act responsibly, take it into account. Hey, we caused a trial to be delayed once already. Maybe we should be responsible and not go and air stuff 2 weeks before the next trial date. But I don't think they're going to do that. So I don't know. But important issue. So I am planning to live stream that. That is supposed to start at 12:30. I think that's Mountain Time, isn't it? Boise's on Mountain Time, so it's an hour ahead of where I am over here in Pacific. It'll be 11:30 my time. 2:30 over there on the East Coast. So we might be juggling a little bit tomorrow. Gonna just have to play it by ear and see how things go with the timing. But I'll be prepared for there to be early news, and we'll take it. If we get a resolution, great. If we don't, then we'll just see what we get and take in the Koberger hearing, see if anything else happens in the meantime. But this is the part where just nobody knows what's going to happen or when it's going to happen or if it's going to happen. So we're all kind of playing guessing games, doing our best to, to the extent we can, go back to our normal lives, guys. Readjust. There's nothing else that we can do at this point. Our role is done. It's all in. All the information's in. everything the jury is going to be able to consider. We've talked about every possible interpretation of the evidence other than the second act that could constitute a DUI at 5:07 in the morning. It was the one thing that we didn't think of. Really didn't even cross my mind. Didn't even cross my mind they could be thinking about a second act there. Maybe have a unanimity problem. So we don't know. It's unpredictable. We're just trying to do the best we can to start to normalize things a little bit, but recognizing there's still work to be done before we get to wrap this case up and put it in the rear view and hopefully never see it in a courtroom again. That would be fantastic. So that is the plan for tomorrow. Play it by ear, see what happens in the morning, see if we get maybe arguments. Again, they might be bringing in some arguments on, hey, there might be a little bit of an issue here with the unanimity that we need to clarify. Maybe we come in and hey, this is not such a theoretical question because you answered the first one theoretically, and maybe we should go ahead and invoke Rule 27 and ask you to poll the jury and return any verdicts that they've already decided unanimously are not guilty. Wouldn't surprise me to see something like that coming up, but it's all guesswork at this point. So kind of play it by ear, but assume I will go live on this case at some point tomorrow. And I will be going live for sure for the Koberger hearing at 11:30 Pacific. So that will be the plan for tomorrow, guys. Hey, thanks for showing up on like no notice. You got like half-hour notice, I think. Finally got myself together to be able to go live and yeah, just kind of taking in the implication of everything today. And I still just really am stuck with that takeaway. Seems so clear, very clear. The focus here is the OUI. And if they can't even get that unanimously, then this prosecution is a train wreck. Guys, it's a mess. If they can't even get not guilty, if they can't even get a unanimous guilty on OUI, a nothing charge, it really seems to me like there are people on the jury saying, no way, nothing, not going to do it, not going to give the Commonwealth any credit at all. So now we just got to see how that plays out. Could be ironically that kind of reaction to how bad it is, how wronged Karen has been by all of this. Rather ironic that could potentially end up leading us having to do the retrial on the voluntary manslaughter. Support Karen so strongly that they won't back off that position. I don't know. I have to see how it plays out. TG, can we count on another 20 hours from you tomorrow? I don't know how he managed to pull off 6 today with a late start, but here we are. I don't know. You guys know the routine. How long do you want to send the super chats? I'm going to be stuck here until we're through the queue. It's just, hey, if you guys are going to spend your money to get my attention, I'm going to give it to you. So I do respect that, and I appreciate the support. So guys, again we wait, but actually a little bit of good advice from the judge today, not just for the jury, but for all of us too. It's fine, guys. Nothing else is happening right now. Put it out of your mind. Go enjoy the day. Put it out of your mind. Take this space to go ahead and care about some other stuff for a little bit. It will do us all some good. Just focus on other things. There's nothing else that we can accomplish here by continuing to give this mental space. And the being in limbo will eat you up alive, because you'll never have answers to so many of these questions. So it's better to just not get stuck on that. Appreciate the limits of what we can and can't know from a process like this. Massage Girl, can the defense motion for their forms again? They can, but she's already rejected them and she's already decided herself how she wants to modify it. So she's not going to grant that. She's going to say, I've already done a modification and I'm happy with what I did. And you have a suggestion? No. Nope. Instantly knee jerk. So I don't expect that to happen, but yeah, we'll see. We'll see. It's not impossible. All right, guys, let's take our time for ourselves. Nothing more to see here. Tomorrow will come soon enough. Tomorrow, perhaps we will get more answers, but there is nothing more to accomplish today. That said, if Mark Betterow is recapping somewhere, I'm off to find it too. So we'll just, we'll see. We'll see what's going on for the rest of the evening. But what do you guys think? What do you guys think of where we're at? That's my take. I don't see this as being, I see this as being really nothing but positive for the defense. All we're arguing is whether she's going to get a DUI or not. That's a major defense win and just massive egg on the face of the Commonwealth. You can't even convict her of DUI. That just speaks volumes about the lack of faith anybody in this courtroom has in you, your officers, your prosecution, your representations, your investigation. And that should send a message, you know, but will it? Well, we'll see. So guys, I'm out. Enjoy your evenings. Thank you to all of you for being here. Thank you to the mods as always. Just drop their lives and come in here to help us have a good scene and a good conversation. Really appreciate all that work and that dedication. We'll be back at it again tomorrow. So just, I guess this is the time I have to say have the notifications on, just because we're still playing it a little bit by ear tomorrow. But when I go live, that will be the way to find out. So you will get notification if you are signed up for notifications. Everybody take care of yourselves. Keep our fingers crossed. We'll get something definitive tomorrow. We'll just go ahead and manifest that, put it out there, put that kind of energy out there. Let's be done tomorrow. Okay. If we all kind of pull for that, well, maybe we're not the only people thinking that. Maybe the jury's thinking that too. So check back in tomorrow and see you guys. Thank you, everybody, and take care of yourselves.